I don't think you all understand who I am. I mean, I've always been a straight-A student.
Have you been drinking?
I had a drink. I am an outstanding mother to my son.
It's her day to pick up the kid, but it doesn't always happen. 1 or 2 days a week, maybe she gets him.
Go back inside. Jesus.
Do you need Jesus right now?
I excel at everything.
She hasn't worked for over 2 years. I mean, she was always calling to borrow money, and it's been like 2 years since she got a job.
Babe, I had no idea.
Jesus Christ.
Well, good morning, everyone. How are we? Back for another day of the Owens Shenanigans. Let's watch what Court TV has pulled up here for us.
Did you ever believe he could die in there?
No, at all.
Were you trying to kill him?
Never.
Did you want to kill him?
I did not.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
Good gracious, that blink rate. Everybody's talking about the blink rate. Anyway, it'll be coming on in about 12 minutes. Until then, we missed looking at the docket yesterday, so I've done some things here that I thought you guys might want to hear about what was put on the docket. Item on the docket that I wanted to bring to your attention was this latest notice of supplementary discovery. And they want to look at the digital investigator Uadan's property form. She is the one that did the digital extraction of Sarah's phone. And this is coming from Cacciatore. So do you guys remember when we were talking about the different police reports and whatnot in the trial? This was I think this happened on Friday, right before they did their closing, right before they did their openings. They came to the agreement that the police reports were not going to be entered into evidence for the jury to view, but while a witness was up on the stand, they could review their report for reference to answer any questions, right? I don't know why the defense wouldn't have already had this. I think I freaking have this. Let's look. Okay, so all the stuff that I've been given, I don't see the specific report that they were mentioning in that motion. So I don't have it. So I just double checked to make sure. So we'll see what happens there. Let's go back and look at the screen here. They asked for that. Then they wanted a request for special jury instructions. This was put in by Jay. And it's the state's request for special jury instruction regarding Florida criminal standard jury instruction. I'm reading this just as it is, and it's kind of weird the way it sounds, okay? So just bear with me. The defendant filed a motion to suppress statements, which was denied prior to trial. A significant portion of the motion was devoted to whether or not the detectives told/asked her something to the effect of, with these rights in mind, do you still wish to speak with us? This is not required by law. However, it is proper for the jury to consider the totality of the circumstances in deciding whether her statements were voluntary or not. Therefore, if the defendant raises this issue in front of the jury, the state is requesting an instruction be added to 3.9b, the defendant's statements, so that the jury understands they are solely making a factual determination regarding voluntariness, not a legal one. Okay. So here's what it states. This is important, you guys. Okay, so listen up. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. This is a correct statement of law and would not be required to ensure that the jury is not confused by inferring that it was legally required when it was not. Okay, so remember yesterday when I had a fit about them, they didn't come back and cross that? They've put it in the jury's instructions. I hope the jury sees it. I guess they will. I don't know with all the other paperwork they got, but I thought it would be a good idea if we went ahead and reviewed some of these docket items that have been popping up, and something I didn't even catch yesterday. So let's go over these. How on earth did I miss this yesterday? All right, let me zoom all the way in for you guys. Okay, listen closely, everyone. State's request for in-camera hearing regarding financial arrangements between the defendant and defense team. So the state is pointing out that the defendant obviously has claimed to be indigent. She had several appointed lawyers prior to forfeiting her right to an appointed attorney. The defendant is receiving costs for money from JAC because of her indigency. Apparently, only the investigator, Billy Lane, from Prison Break Investigations, is being paid by the JAC. The defendant has secured the services of 4 attorneys. 4. Well, yeah, I guess they're counting the paralegal, I guess, and a jury/trial consultant, and perhaps more people that the state is unaware of at this time. The defense team is expending a tremendous amount of cost, having traveled from Milton, Florida to Orlando, Florida for several-week trial. The team returned to Milton, Florida prior to the arrival of Hurricane Milton in Central Florida, and then traveled back after it had passed, incurring additional cost. The state is concerned about a potential conflict of interest between the defendant and her team. And they reference the Florida Bar Rule 4-1.8D. The only way for the court to know if there is an actual conflict of interest rather than a potential conflict of interest is to review the financial arrangements between the defendant and her team. If there is an actual conflict, the defendant can waive this right with clear, unequivocal, and unambiguous language. For a waiver to be valid, the record must show that the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and the defendant knew the right to obtain other counsel. The state is requesting the court to conduct an in-camera examination of the financial arrangement to assure that there is no actual conflict of interest, and if there is an actual conflict of interest, the defendant validly waives any actual conflict of interest. Okay, this just passed by me yesterday, and I want to understand it further. So we need to listen to what was said in court again.
Okay. All right. State, any other issues we need to address with regard to the discovery issues that you brought to the court's attention this morning?
No, sir.
Okay. All right. Moving now to the motion. I have reviewed that motion.
Judge, we were not aware of the motion until he made mention of it, so we need some time for the lawyers to review it, for us to discuss it, and to see whether or not it has merit or not.
Okay. It was e-filed last night, looks like 9:37, and then sent courtesy copy to myself through Ms. Barrios and you, Mr. Owens, at 9:38 last night. I'll give the opportunity to review that. We can address it after the lunch hour. And that'll give the court the opportunity to do any research during the lunch hour on it as well. All right. Anything else, Mr. J?
I'm I looked at it briefly. I'm not for sure exactly what the allegation is. I don't know if we need to talk about that. So excuse me?
I'm not.
Can we approach the bench?
Sure, come on up, yo.
Gee, did you guys see that coming? So they basically have tabled this till later, and I just wanted to bring it up because I think they were going to look at it last night and it never got addressed. Because remember last night, Sarah was on the stand, prosecution came up and crossed her and all that. Yeah, we should be starting any minute now, you guys. I'm on live at Court TV, so we're good. And I have the sound on, so we're good there. So anyway, that's going to probably, I don't know, maybe it'll come up this morning. I don't think they finished talking about it. And I just thought, how did I miss that? Like, what do you think is going to go on there? Are they accusing them of something here? What are you guys thinking? Do y'all understand what they're saying? Welcome in, all you latecomers. Well, you're not really late. It hasn't started yet, but thank you to all the new members that have joined. Should not play. I'm closing out everything. I just wonder about this. I think that they're trying to say, yeah, that's what I was thinking, Yana. They're counting the paralegal. I don't. Are they trying to say that there's some kind of under the table deal going on, or like it's publicity stunt, or yeah, it's like a financial conflict. What? I don't know. I can't wait till they. And of course, Owens, he stalled. Yesterday, you guys, it was like, remember the big fuss that he put in about all of the medical paperwork? Remember they did like they call the docket dump the other day, where they dumped all the medical records, and he asked him about it again yesterday, and they were going to narrow down the 119 pages from Winter Park Medical to 12 to 15 pages, and they were supposed to provide that to the court by noon. And then they had some hospital records that still hadn't been taken care of that were supposed to be whittled down, that Dr. Harper was supposed to use to reference. And, James says, we're working on that, Judge. We're working on that, Judge. And they had until 5 p.m. yesterday to get it done. One of those items, and I'm not sure which one it is, I've got to go back and double check. One of those, the defense came back and said, well, I know what it's referenced to. It was in reference to George's injuries, all of his medical records. I don't know if that's the 119 or the other, but they said at the last minute last night, they were like, yeah, we're not going to be able to get them, and we're just not worried about that. So they're not going to bring them in. The defense isn't. Just so you guys know, I do have let me take this banner down. I do have the sound on. They just haven't started it yet because they're not on the record. I want to turn the sound all the way up too. All right. I am adjusting my microphone this morning because somebody had said that I was really loud when that, like, compared to what the court sound is. And you guys were having to adjust your microphone yesterday. And so I wanted to make sure that you guys hear me okay. I'm not too low, but I'm not like blaring your ears out either. So just kind of give me a heads up in the chat if there's ever an issue with it. Okay. I would appreciate you doing that. I was telling Laura last night I want to take a course on how to do the audio for these things because that's I don't have the equipment. I don't have anything, all that goes with it. But Ginger Snap, am I lower than normal as far as sound goes? I should be. Judge, we're not ready yet, Judge. Wait, who is this? Who is this little guy? Oh, it's probably a different case. I think that the judge ended up having to move some stuff around, and because like yesterday, somebody came in and he had to redirect them to somewhere else. Well, y'all didn't say anything, was it Jen Marie? Why didn't y'all say anything to me? I didn't know I was that loud. Did I scare y'all? And yesterday I was like getting way excited at the end of the day when the motion thing was going on. So, or the suitcase thing. I was blowing some ears out over that one. What's she wearing? She's got her gray suit on. You guys have your coffee, your tea, everything ready to go this morning? I've already had my coffee and I'm now drinking a Diet Coke. Get your Pop-Tarts out. Good morning, Ozzy. How are you? I'm much lower than normal, Cass, but I'm not too low, right? Carrie, you are, and you are much easier to understand. Well, why didn't y'all say something? I'm just kidding. It's not your fault. But feel free to tell me if I am, because when I go to reset my computer, sometimes it puts the volume back where it used to be. So I have to adjust it every time, and I don't always remember. Trying to learn how to do all this stuff to keep going. Everybody's in court. I wonder what they're over there. So I wonder if they had that deposition they were supposed to have, or is that supposed to be later? That's what's been going on is this Kevin Beck guy. He hasn't been in court. You haven't seen him just every now and then. He's been out trying to schedule depositions at the last minute with all these people that they'd had a hard time getting in touch with. As the defense witnesses were coming off the table, off the stand and headed back out to their car, you got Kevin Beck out there chasing after him going, "Excuse me, wait, I need to get your contact information. We're going to need you to come back." I'm just kidding. That's not what happened. I like to make things up. I am so cold this morning. I like to drop a couple of videos or try to make some new videos or whatever after we do like a live stream that's so long. Even though I do go back and timestamp everything for you guys, be aware that if you ever want to go back and try to find it on my stream, it should be easier because I do that. But every now and then I'll pull like a video out and then I'll drop it, right? And I was trying to get some of those together and I saw on the one, I was like, should I put her whole thing on the stand up? And I'm like, no. If people are like me, they're sick of seeing her and hearing her. So I just chopped out just the piece with, what's his name only, with just the prosecution questioning her. You saw on X last night about her. I've been hearing a lot about that with the girlfriend in the gallery. I've been hearing a lot about that West Coast mesh fighter, sorry. I don't know. Y'all think she's more than just a friend? They say she's just a friend. Oh, thank you, Laura, for reminding me. What is the phrase of the day? What did I say it was going to be yesterday? We were picking all kinds of good stuff from yesterday. What did we say? Owen's shut up? Was that the new one? But there was another one that came up too. What do y'all want the phrase of the day to be for the giveaway? We're doing for any of you guys that are new coming into the channel, Every day of the trial, we've been doing earbud giveaways. We were going to do Damn It, Margaret. That's right. All right. Owen, Sit Down. That's the other one. Thank you, Twill. Twisted Quill. Twill. All right. Let's do, don't do it yet. Don't put it in yet because I got to set it up real quick. I got to open another stream and other window and start it. I'll tell you when it's set up so you can put it in. Okay, it's Damn It, Margaret with an exclamation point. So you guys can start typing it in the chat. So to enter into the earbud drawing, all you have to do is type this phrase into the chat and you will automatically be entered. And then when we do the drawing, I don't ever tell you guys when I'm going to do it. You have to be present. Woohoo. It's how I hold you hostage all day long. We usually do it I think yesterday we did it at lunch. Or we might have done it during the first morning break. Judge must have some stuff he's wrapping up this morning. Or you know what, you guys? It might be another jury delay. Because everybody seems ready to go in the courtroom, don't they? Wonder what the holdup is. Let me pull up X. See if we got any notes from the courtroom. Yeah, Jules did a great job. Notorious Jules on Twitter. She does a pretty good job about updating everybody. So, yeah, they're expecting to have the 2 deputies come in today. Is it just 2? And then also Dr. Brannon. And before Dr. Brannon comes in, I'm going to show y'all his video. But some of you might have already seen it. But if you, I think he's going to be after at least the first break. Oh, sorry.
Good morning, everyone. Madam Clerk's going to go ahead and call the case to order.
Case number 2020 CF 2603, State of Florida, Sierra Partisan updates for the record, beginning with the state.
David Ketchner on behalf of the state. William J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck, we have Sarah.
Ms. Boone, raise your right hand to be sworn. Please be swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Ms. Boone is seated at counsel's table wearing a dark gray suit jacket and a maroon blouse. She is in custody. However, she's not in any restraints. So we will be continuing to stand as our jury enters and exits. State, are there any housekeeping matters we need to address this morning before we bring in our panel? Defense.
Judge, I don't know if you got the email last night of the potential witnesses we're going to call.
In addition to the one I received this morning. Yes, sir.
Dr. Harper did get in last night after midnight. She's over at Koepsell, but in addition, we may recall the phone extraction expert. She's not on the list.
Okay, understood. All right. Are we ready to bring in our panel?
Yes.
Okay. All right, very good. Let's go ahead and stand and bring in our panel.
Yeah, it is always something with him, isn't it? I guess they're going to bring in the new the lady again that did the phone extractions, Uwanda. I can't say her dang name. She's pretty. Because they were asking for her report. Yeah, make sure you put the exclamation mark behind Margaret. I wonder what they're going to say. I guess they aren't going to address it this morning. I thought they would address that whole financial conflict thing. Maybe they'll do it on break or something. Yes, thank you, Ginger Snaps. Bring in a makeup artist to explain the fake black eye that was shown yesterday. So if they're going to be bringing up the cops, we're going to see some body-worn camera footage today. We're going to have... Oh, by the way, you guys, somebody in the comment section said it was Mr. Thyru24. He goes, in the comments, he said, Owens may fake a medical emergency to get more time. Like, that is so true. That is so true.
All right, jury's entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? Yes. All right, everyone can be seated. Members of the jury, good morning. Welcome back to 12 Alpha of the Orange County Courthouse. I hope you had a great evening. If you could, again, just by a show of hands, you complied with the court's instructions for the overnight break. Record reflect all hands have been raised. Members of the jury, at this point in time, the defense is going to continue with their evidence and testimony presentation. And I'm going to ask them to call their first witness at this time. Mr. Owens, you may proceed, sir.
At this time, the defense calls Deputy Ramirez-Delgado.
Let me adjust the captions for everybody.
Please swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God. I swear.
Good morning. You can be seated. And can you please state and spell your name for the record for me?
Yes, sir. My name is Jessica, first name Jessica, Jessica. First last name is Ramirez, Ramirez. Second last name is Delgado, Delgado.
Thank you, ma'am. You may inquire, sir.
Good morning, ma'am.
Good morning, sir.
Ma'am, how are you employed?
I am a reserve deputy with the Orange County Sheriff's Office.
And how long have you been employed with the sheriff's?
7 years.
Back on July the 25th of 2018, how were you employed at that time?
I was a full-time deputy sheriff for the agency.
On that date, ma'am, did you have the occasion, due to your duties, to report or to go to 4748 Franks Lane, apartment number 3?
Yes, sir.
Do you recall what you were going there for? The purpose?
Yes, sir. I was a backup deputy for a call involving a male kicking a female in the face. So it came out as a domestic call.
Okay. And was it another officer who also responded?
Yes, sir. He was the primary.
Okay. Ma'am, while you were there, did you have contact with Sarah Boone?
Yes, sir.
While having contact with Ms. Boone, were you able to observe any injuries?
Yes,
on
sir.
her person?
Yes, sir. She had swelling and bruising in her right eye.
And ma'am, were you able to make contact with Mr. George Torres?
Yes, sir.
Were you able to notice any injuries on his person?
Yes, sir. He had red markings and some abrasions around his neck.
Ma'am, at a certain point in time, did you place Ms. Boone under arrest?
Yes, sir. I detained her and placed her in my vehicle.
Ma'am, at that time, do you recall or remember Ms. Boone asking you, why am I in trouble?
Yes, sir.
And without saying what you said, but did you respond to her?
Yes, sir.
After that, ma'am, do you remember Ms. Boone asking you why? Because I fucking fought back.
Yes, sir.
I can have one more.
Yes, sir.
No further questions.
Thank you. Any cross-examination?
During the course of your investigation, you or the other responding deputies spoke to Mr. Torres as well.
Yes, sir.
After concluding all of your investigation, which involved talking to both Mr. Torres and to Ms. Boone and making your observations of the two of them, did you all make final decisions about how to handle your investigation?
The other deputy, which at the time was Deputy Zito, was the one that made that determination.
Okay, but that's collectively what you all looked at was statements from Ms. Boone and Mr. Torres, correct?
Yes, sir.
And your physical observations of both persons?
Yes.
And then whatever else you may have observed on scene?
Yes, sir.
And do you take into account people's demeanor when they are giving you statements when assessing their credibility?
Yes, sir.
No.
Any redirect examination?
No, Your Honor.
Can this witness be released?
Yes, Your Honor.
Yes.
All right, thank you.
Thank you.
I'm surprised that was it. Henderson said, "Here, Mr. J, let me get that door for you." Is that what we're going to be doing all day today? I think it is. Opening doors.
Defense, call your next witness.
At this time, the defense calls Deputy John Alden.
Yeah, I wanted to see the video too. I don't know.
You swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Sir, good morning. Can you state and spell your name for the record?
John Alden, John Alden.
All right, thank you, sir. You may be seated. Mr. Henderson, you may inquire.
Good morning, sir.
Morning.
Sir, how are you employed? How are you employed?
I'm employed with the Orange County Sheriff's Office as a corporal.
Back on August the 28th of 2019, how were you employed?
I was a deputy in Uniform Patrol Division in Sector 2.
As a part of your job duties that day, did you have the occasion to respond to 4748 France Lane, number 3?
Yes.
What was the purpose?
There ended up being a battery call.
And sir, were you the lead officer on this case?
Yes,
Were there any other backup officers there?
I believe so.
Sir, on that date, August the 28th of 2019, did you come in contact with Sarah Boone?
Yes,
Sir, on that date, did you observe any injuries on Sarah Boone?
I observed redness on the left side of her neck and what to be an old injury to her right eye.
Sir, on August 28th of 2019, did you come in contact with George Torres?
Yes,
And did you notice any injuries on Mr. Torres?
Yes, he had some redness on it by his left eye.
Sir, on that day, was Mr. Torres placed under arrest?
Yes.
Thank you. I have no further questions.
Any cross-examination?
Yes. Is it fair to say that Mr. Torres had quite a few marks on him?
From my report, I remember marking the left redness by his left eye.
And did you have your body worn camera activated when you responded to this call?
I believe so.
And so that would be the best evidence of both video and audio as to what occurred while you were on scene.
It would, especially since this happened 4 years or 5 years ago now.
And did Mr. Torres refuse to say what happened that day?
He did.
Based on the conclusion of your investigation, which involved talking to Spoon and attempting to talk to Mr. Torres, as well as your visual observations of both them and the scene, is that how you all reach your conclusions?
Yes.
No other questions?
Any redirect?
Oh,
Can
man.
this witness be released?
Yes, Your Honor.
Mr. J?
Yes, sir.
Thank you, sir.
Thank you.
Play the video, you guys. What is going on here on this day? I don't like that.
Defense, you can call your next witness.
Okay, so I'm assuming that the jury's going to be able to watch these body cam footage items in private when they go into deliberation. Because that's all they talked about yesterday in the motions or the.
Yes, may we approach him?
Yes.
That's all they kept talking about yesterday morning was, you know, they were flipping through the body cam footage and they were talking about the portions that they were going to redact. Is Mr. J hinting to the jury that the defense is avoiding the videos? That's a good point, Rachel. I don't know. I don't understand why they went through all of that to bring it up because they did I thought for sure they were going to play August 28th because we haven't seen that one. And I thought there was a reason why it had been redacted. But that was the incident, if I'm not mistaken, that's the incident where on the report it had said that he refused to
Defense,
call
you
the
can call your
police on
next
her.
witness.
Judge, at this time, the defense calls Deputy Koepsell. Or Detective, excuse me.
Detective Koepsell's back up. Koepsell. Maybe they're going to play it while she's on the stand, the body cam footage. No. He did say Detective Koepsell, right? Koepsell. He's as bad as pronouncing their names as I am.
Good morning again. Could you state your full name and date of birth for the record? Or, I'm sorry, full name and spell it for us.
It's Chelsea Koepsell, Chelsey. Last name is Koepsell.
All right, thank you. Counselor, you may inquire.
Good morning, ma'am.
Good morning.
In relation to this case, on February the 26th of 2020, did you have the occasion to interview Abraham Marino?
Yes, I did.
Was that interview recorded, ma'am?
Yes, it was.
You remember as part of that interview that Mr. Marino told you that he had contact with Sarah Boone on February the 24th of 2020.
Are you asking the night of the incident when police were called out?
Yes, the next morning.
The day that we were called.
That you were called out.
Okay.
The 24th.
So yes, he did have contact with her, but it wasn't in the morning. It was while we were there.
While you were there?
Yes.
What time did you get there? That's probably what's wrong.
I got there around 14:20 hours, which would be 2:20 in the afternoon.
Okay. So the afternoon on the 24th.
No, it was later. I recall, I believe I was doing paperwork in my vehicle. So it would have been at some point during the investigation, but it wasn't, I didn't notice him until, I'm not sure if I noticed him until before or after Sarah was interviewed.
All right. But to his interview part, the interview, did he tell you in the interview that he had contact with Miss Boone on that day?
Yes, he did.
Did he tell you at that time that Miss Boone had made a statement to him?
Yes, he did.
Do you remember what that statement was?
I don't wish to quote what he stated. So I don't know the exact verbiage, but he basically replayed what, I'm not sure if he replayed what exactly occurred that day, but I do know he mentioned something about, she mentioned being dragged down the stairs a couple days prior.
Did he say to you during that interview that Sarah Boone told us that a couple of days ago they had gotten into a fight where he grabbed her by her hair and dragged her down the steps?
I would assume that he's reading my report, and that does sound similar to what my report should say.
So this statement was given on the 27th of February. I'm sorry, the 26th of February. Would you agree with that?
Yes, I would.
Okay. The contact and the statement that Ms. Boone made to Mr. Moreno was on the 24th of February. Is that correct?
Repeat the question, I'm sorry.
When Mr. Moreno is saying that Ms. Boone came up to him and made this statement that we just talked about,
Yes,
that was on February the 24th. Is that correct?
that is correct.
So when she said a couple of days ago, that would have brought it back to February the 22nd. Is that correct?
Potentially, yes.
Ma'am, during that interview with you, did Mr. Marino ever indicate to you that when he had contact with Ms. Boone on the 24th, that Sarah Boone told him what happened was an accident? Did he say, Sarah Boone stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
I don't recall the entirety of that being accurate. Yeah, I don't recall the entirety of what he just said being accurate.
Do you remember him saying that at all?
He did say that she had, I believe he said on the recording, passed out. So that's why, like, part of the statements might be accurate, but.
Ma'am, would it refresh your memory if you were to see the recorded statement?
His recorded statement,
Yes.
transcription?
Yes.
Sure, yeah, great.
May I approach the witness?
You may.
Now take your time. Wait for that.
Okay.
When you are ready, just let me know.
Okay.
I love how he talks down.
I don't
to him.
recall all the statements that you asked or the way you asked it, but
Would it help if I repeat it?
sure, yeah.
Okay.
You asked, like, you said multiple statements, so
Yes, ma'am.
this was a 11-minute interview.
All right. The statement would be that Sarah Boone stated to Mr. Marino that she was teaching him a lesson and things got out of hand and that she fell asleep. And I'm wanting to know.
Did you say, okay, I thought I heard you say passed out the first time. I'm not sure if you said passed out or fell asleep.
Fell asleep.
Fell asleep, okay.
And what I'm asking is there any indication that he told you that statement on the date of that interview on the 26th?
Sorry, I'm trying to go to the part where we talked about that.
Yes, ma'am. Take your time.
Shouldn't you have marked that for her? I mean, we all know, the reason I ask is because we all know that these attorneys on the defense side just, they don't pay attention to details. I needed you to look through this 50-page document really quick while you're on the stand.
So, like I had stated, there were certain things that I thought was accurate from your statement. He stated, do I just read exactly what it says? Do you need like the number next to it or anything?
Yes, I have no problem if you reading what he said.
Okay, then she,
Approach.
Ah, that's what they want. Why don't they just play his interview?
Ma'am, you cannot read the statement at this time.
okay.
Thank you.
Okay.
You may continue, Mr. Henderson.
He described,
Hang on.
No.
Just wait for a question,
so
okay?
sorry.
It's okay.
Yes, sorry.
Ma'am, anywhere in that interview, do you see reference to this statement that Sarah stated that she was teaching him a lesson and things got out of hand and that she fell asleep?
No to the first two parts of your question. I heard passed out the first time you asked me this question, and that's why I said that part of it was accurate, because he did say that she passed out in his statement. That was what Sarah told him.
Okay, did she say she was teaching him a lesson? Is that in there?
No,
And things got out of hand. Is that in there?
no, I don't recall that.
May I approach the witness?
Yes.
I'm going to explain this a little bit further when they pause for a minute. Okay, guys? Because I think I know where he's going with this.
And again, ma'am, this interview was on February the 26th of 2020. Is that correct?
Yes, it was.
Thank you. I have no further questions.
Any cross-examination?
No other questions, John?
All right, thank you. Can this witness be released?
Yes, Your Honor.
State?
Yes, Your Honor.
All right, thank you.
Okay, so in the interview with Marino, they did an audio interview. And in the audio interview, he did not mention running into Sarah the day on the 24th in regards to her saying that he pulled her hair or something, that George had pulled her hair and drug her down the stairs. So that wasn't in the audio
Defense?
portion.
Go next witness.
But the detective did write something about him saying something like that in the written report.
I believe Dr. Brandon is here.
So I thought that the defense was going there. Okay, they're bringing up Brannon, Dr. Brannon. I thought the defense was going there because they were going to try to discredit her by saying, you know, why wasn't this done or why wasn't this on the report in the audio? So for any of you guys that are not familiar with Dr. Brannon, he's pretty famous for being on court TV a good bit. He's a psychologist. And I'll play you, when we go on break, I'll play you a video that I did on him of what he did before. Now, he supposedly has a very, very, what's the word I'm looking for? A good reputation. Thank you, Joanne Poole.
Judge, may we approach?
Yes, sir.
Dr. Brannon just texted me and he's running late. There's no telling. He took a wrong turn. He's still stuck in the drive-thru at Chick-fil-A. He had to get him some mini biscuits. I have no idea. James Owens will use anything. Can we get James Owens like, where? You're at Chick-fil-A. Hey, why you go ahead and grab me a biscuit while you in there, okay? They still serving breakfast, aren't they? Okay, good. Yeah. Get me. She's passing notes to this woman. Is her name Pena? I see what y'all are talking about in the chat. Y'all are all about the gossip. That has nothing to do with the trial. Look at y'all getting into the gossip. I want to see what this woman looks like. They showed the jury one time, or the gallery one time yesterday.
Members of the jury, we're just waiting on a witness. They are using the facilities outside. So as soon as they're done, we'll bring in our next witness. Thank you for your patience.
Judge, he's in the bathroom. Good gracious. How embarrassing. Coffee's kicking in. Who needs a Chick-fil-A when there are Pop-Tarts in the... I love those little Chick-fil-A mini biscuits. They're so good. I am curious to see what he says about Sarah. Now, this guy, like I said, he has a good reputation. I don't know if he's going to address her directly. Now, he was on Court TV, and he did speak on this case prior to being hired by the defense. But what he spoke on it was very generic. It was just like, well, if the defense is going to do this, this is what they're going to need to do here. This is what we're going to need to see here. He never said anything about Sarah Boone this or Sarah Boone that. So just because I know there's a lot of people talking about it before, like, why are they bringing him up if he's already been on Court TV? I didn't think his Court TV thing was that bad. Like, I didn't think it was anything directed at Sarah Boone herself. So is Koepsell no longer, I guess they released her completely. They're not going to be bringing her up anymore. Oh, yeah, that's one of our rules here in our chat, y'all. Y'all can't talk about politics, please. Politics divides people. We don't want to be divided. You do you, I'll do me. Let's just don't talk about it in the chat.
Dr. Michael Brannon.
Very good.
Someone attending trial said a gaggle of Owen's friends are seated behind Boone, specifically driving up the trial to make it look like Sarah has a lot of support. Oh, really? I heard that. Where did I hear that from? Here's Dr. Brannon. All right, go on.
Doctor, good morning. Could you state and spell your name for the record for us?
Michael Brannon, Brannon.
Thank you. Counselor, you may inquire.
Dr. Brannon, good morning.
Good morning.
Spry, having just traveled from Miami to Orlando.
Yes.
Is that not correct? Okay.
It was a good drive.
Would you please describe for the jury your background, training, and experience, both in forensic psychology as well as battered women syndrome?
Sure. So I'm a psychologist licensed in the state of Florida. I have a bachelor's degree in psychology. That's from a university called Nova University. I also have a master's degree in psychology. I received that in 1980, also in psychology. And I received my doctoral degree in psychology after a year internship where I worked with severely mentally ill individuals in Hialeah, Florida. In 1988, I finished my degree requirements for my doctorate in psychology. And in 1990, I was licensed as a psychologist. I've been operating as a psychologist since then, since 1990. Originally, I started off doing the work that most people kind of think about when they think about psychologists, doing therapy, counseling with people, helping them through with their problems, things like that. In 1994, I began on a career almost quite accidentally as a forensic psychologist when I testified in my first case in front of a jury. And from that time on, I've been doing mostly forensic psychology. My practice very quickly changed from that time on. I'm currently the co-director of the Institute for Behavioral Sciences and the Law, and anywhere between 80 and 90% of all my work now is related to some legal or court-related matter in the ways in which mental health interfaces or impacts or helps to give opinions about various legal issues. I've taught rather extensively in the area of forensic psychology. I teach to mostly legal audiences, but oftentimes too, I speak to groups of psychology students wanting to sit up here and do what I'm doing as well. I make long drives and then come up here and talk to people about cases. I also currently on the staff, the adjunct faculty staff for the School of Psychiatry at Florida Atlantic University. I help to train their forensic psychiatrists, so not just psychologists, but psychiatrists in terms of doing this work as a psychologist or as a psychiatrist, a mental health professional who gives opinions in the courtroom.
And are you also required to update your educational background and knowledge as a forensic psychologist?
Yes, sir. So sure. So every 2 years, we're required to get 40 continuing education credits to maintain our license. And part of that is we have to, on a regular basis, update our work in domestic violence or battered women syndrome. So we have to take those courses. We're all required, whether you're a forensic psychologist or not, to take that coursework. So as part of our requirements, we also have to take separate coursework in regards to domestic violence as a general term, or intimate partner violence. But along with that comes discussion as well with battered spouse, or what's oftentimes called battered person syndrome now.
And I apologize. I'm kind of bouncing around here, Doctor. I apologize again. For the uninitiated, just exactly what do you mean by forensic psychology?
So forensic psychology is a division of psychology. Most people don't think about that as often when they think about psychologists. But forensic psychologists are individuals who have degrees in psychology who are working to help to answer questions that come up in the legal system. It could be in criminal cases like we're here for today, answering various criminal questions, giving opinions about those questions. Or it could be in other settings like family settings, divorce proceedings, or some civil settings like personal injury. Someone's claiming some emotional damage or something has happened to them. So forensic psychology is really the way that we use the science of psychology to help give opinions about various legal matters.
Now, what is the DSM or the DSM-5?
So the DSM it stands for Diagnostic and Statistical Manual. It's kind of our code book, if you will, to help us to know what the different symptoms are for different mental health disorders, whether it's major depression or schizophrenia or anxiety. So it gives us a code book of here's the criteria you have to meet in order to have that diagnosis. And then we're able to utilize that in terms of either treatment, so even insurance billing, but being able to inform patients too about what condition we think that they're suffering from. It's been updated many times over the years. It started just DSM, and now it's at the Diagnostic and Statistical Manual 5th edition, text revised. So we've gone through a lot of revisions over the years to kind of fine tune in an empirical or scientific way what the elements are, if you will, of various mental health conditions.
Now, you've been asked to testify today in regards to battered women syndrome. Is the battered women syndrome identified or located within the DSM-5?
So it is not. It is not a diagnostic category in the DSM-5 or other coding books as well. There's others besides the DSM. That's just the most popular one. but it's not a formal diagnosis that it is contained within that book, that classification manual that I just told you about.
Within your field of forensic psychology, however, is there a subcategory that is located within the DSM-5 that experts would recognize as a DSM diagnosis?
Yes, sir.
And what is that, sir?
So that category would be in the trauma section of the DSM-5 TR. There's a whole category on trauma disorders, and it's most closely related to something that we call post-traumatic stress disorder. That isn't the only trauma disorder, but that's the one that what used to call battered women syndrome. Now I refer to it as battered person syndrome, but all of it really is more connected to a trauma disorder like post-traumatic stress disorder.
Now, testify that you testify on criminal matters. Do you also testify? You indicated also on personal injury cases and emotional. That would be civil, correct?
Yes, sir.
Okay. In your experience, you've testified as an expert, as a forensic psychologist. Have you testified for, and today you're testifying for the defense or were called by the defense. Do you also testify for the state of Florida or other states within this country?
Yes to both of those. I've testified in other states, but I also testify for both the prosecution, the state or government, depending if it's federal or if it's a state case, and also for the defense. So I really get appointments and hired by both sides.
But how many times have you testified?
Wow. At last count, it was about 1,500 times. It's over that, way over that now. That was from a few years ago. I testify in a lot of different kinds of hearings and trials over the course of, mostly in Florida, but in other states as well.
Now, you're familiar with the fact that there is a special jury instruction that's been recognized by the Florida Supreme Court.
Approach.
Ah, looky. What's this about, kids? Tony hasn't been in the courtroom. He doesn't know all the rules yet. He's been out trying to deposition a bunch of new witnesses. They're wrangling up over at the previously known as Tillwood Park Apartments. Yeah, so they're categorizing it under PTSD, fear or panic when George was there, but it definitely wasn't when he was in the suitcase, was it? Tracy, thank you Tracy for letting us know this and giving us your insight on it.
Objection is sustained.
If it's that bad, you can't talk about it. You can't.
I apologize. Doctor, you testified as to battered women syndrome, battered person syndrome. Are there other synonyms or similar names for what you're describing, in particular battered spouse syndrome?
Well, we talk about it in terms of trauma disorders like post-traumatic stress disorder, but the way when it's applied to the legal system, it's called battered wife, or that was the original terminology for it, battered wife syndrome or battered person syndrome. So really depends on your setting. So in this setting, we oftentimes talk about this particular condition that I've been asked to talk about today, is really referred to as battered spouse syndrome.
And have you been asked to give your opinion as a legal expert and on battered spouse syndrome?
Yes, sir.
How frequently have you been asked to do that?
I've been involved in about 100 cases of just that alone. I've been involved in some sort of testimony about 50 times.
And you indicated that you testified for the state, you testified for the defense, you testified in state cases, federal cases. Could you break down on a percentage basis the number of times you testified for the state versus testifying for the defense?
It's really close in terms of last time we looked at it, it was about 50-50. On most cases, like for instance, if there's a case that involves battered spouse, potentially battered spouse or battered wife syndrome, I'm usually called by the defense first because they raise the issue. If you're called by the prosecution, whether it be federal or state, what oftentimes happens is it's in response to a defense expert that's been called. So do I agree or disagree with that other expert? So I'm usually, the call usually comes first from the defense, but in terms of who I'm hired by, it's pretty even. It's about 50-50.
Now, This time, Your Honor, I'll proffer the witness as an expert in the field of forensic psychology.
Yes, approach.
Oh, did I call him Tony again? I'm sorry. I meant to call him Kevin. Kevin Beck. Thank you for catching that, Yana. Kevin Beck is the one. He's like the third co-counsel guy. He's been in and out of the courtroom constantly since day one.
Objection is sustained. Wait.
Wait, hold on. Come back. Y'all, if I was in the courtroom, I'd be sniffing pepper so that I would be constantly sneezing so the judge would interrupt everything and say, bless you. Bless you.
Objection is still sustained. Mr. Beck, you may continue.
It'll throw the witnesses off.
Has battered spouse syndrome been accepted, to your knowledge, in the Florida court system?
Yes, sir.
Objection. Legal conclusion.
Sustained.
Can you describe the classic system or systemology wherein an individual might necessarily suffer and then exhibit symptoms of battered women syndrome?
Yes. So battered spouse syndrome is a woman, usually a woman's response. Doesn't have to be, but that's a classic historical research went into how women respond in situations in which there's intimate partner violence when they've been the victim of violence. Now we know, of course, in other kinds of relationships, men can be a victim of it as well, or as, whether it's a heterosexual or homosexual relationship, that both men and women can be victims. But we still know the majority of those individuals that are diagnosed with that condition or given that condition, classified with that condition, are women.
Bless you.
We do know that it's a reaction, a strategy that's developed by the person who's being abused to someone who's abusing them in an intimate partner situation. And essentially what they're doing is they've made a determination that they can't effectively escape from the abuse. They can't just leave for some reason. They feel in danger or they've been threatened if they leave that something bad will happen to them. So it's a cognitive or thinking strategy on the part of the person being abused that I have to develop some coping skills or ways of protecting myself or maybe even loved ones as well from some form of imminent violence or danger or lethality. Something bad will happen to me if I don't develop a way of handling this abuse, this constant abuse that's coming towards me. So the battered wife syndrome is really a way of thinking. It's a psychological change that happens with a victim in terms of the way they cope and strategize to stay safe for themselves and other loved ones as well, oftentimes.
I'm going to ask a really silly question, if I may, doctor. I don't know if you've noticed a bruise across the bridge of my nose this morning.
I did see that when I come in. Yes, sir.
Okay. This weekend, hypothetically, if an individual was digging around in the garbage, the lid fell down and cut his nose, the bridge of his nose wide open, would you as a forensic psychologist anticipate, or a psychologist in general, anticipate that there might be a physical or a psychological reaction or response to that degree of trauma?
So I don't know if it would be trauma or not. It could be, depending on the degree of the injury and the pain and things like that. But certainly you'd view that garbage can differently as you approached it. So it changes your psychology or the way that you look at that particular situation or that particular object. So by viewing it differently, you may engage in different behaviors. You may approach it differently. You may have somebody else approach it. You may approach it with both hands up. So it changes your behavior and your thinking about that garbage can.
Does that also apply to interpersonal relationships?
So it certainly can. No two people always react the same way to every situation. Trauma, one person's trauma is not a trauma to another person. But for people who do develop battered spouse syndrome, they do begin to change the way they view the person who's abusing them and what they have to do in order to maintain either their life or their safety, their physical safety in terms of their behavior and interactions with that person.
Now, is there a specific set of criteria that a psychologist, forensic psychologist, would necessarily rely upon in attempting to make a diagnosis or assessment of battered women syndrome?
Yes, sir.
And what are those criteria?
Well, you'd want to see one, if some type of abuse has occurred. That abuse can be physical, it can be sexual, it can be emotional, or it can just be the threat of abuse or bad things that's going to happen to you. So there has to be something bad that's happened or that's threatened to be happening over a period of time. So abuse has to be present in order for this to be underway. Without abuse, there's no battered wife syndrome. But that's not enough. There also has to be what's called coercive control. Coercive control is really keeping the person's social interactions, overseen on a regular basis, controlling money, controlling preferences, even TV preferences, sometimes social media, looking at social media that the person is accessing or looking at, who they're talking to on Facebook, who they're texting. So it's a combination of abuse and coercive control that results in a person feeling victimized, but that's still not enough. That person then has to feel like they can't escape from that. They've either been told, if you leave me, you're going to die, or a family member is going to be harmed, your children, your mother, whatever it might be. And as a result of that, they develop strategies to cope with that, acquiescing, pleasing, doing anything they're asked to do, demeaning themselves, allowing themselves to be controlled, all of the things that would fend off, if you will, some abuse or attack or threat to them or someone who surrounds them. So those would be the components that you would need to have, and that dance continues to go on usually repeatedly throughout the course of that relationship.
So I think what you're describing is, in a sense, a subjective nature to the syndrome that's being described.
It's both objective and subjective. So objective in terms of the facts, like what's really happening. A person's being abused, they're being told certain things, there's control over them. But then a subjective part is the person's interpretation of that, their perception of that. So there's really both going on, and they have to kind of work together in order for this syndrome to be formalized and properly diagnosed.
You indicated that there's sometimes maybe some defense mechanisms that are, or strategies that are devised by the battered individual, the abused individual.
Yes, sir.
In your experience and your training, do controlled substances, alcohol, drugs frequently appear in your analysis or assessment?
Yes. And the way they appear is they can appear either from the abuser or the abused or both. What can happen from the abuser standpoint is they may only be abusive, or abuse may become worse if they abuse substances. From the abused standpoint, it may be self-medication. It may be a way of coping with the anxiety that there's going to be something bad that potentially could happen to them or somebody else. It's kind of a way of dealing with walking on the eggshells. So if I use substances, that can deaden the pain, if you will, for me, or help me to forget about it. So it's oftentimes, not always, but oftentimes part of either the abuser's behavior or the abused behavior.
Do they, in your experience, do they on occasion actually defend the individual that is abusing them?
That's a very frequent part of this syndrome. Not always, but it's very frequent. It's why interviewing them becomes difficult sometimes, because they're used to explaining away their behavior, the abuser's behavior, my black eye, my missing tooth, his screaming and yelling in the background while I'm talking to mom on the phone. So they're used to making excuses for it. It's part of the coping strategy, trying to explain away this behavior. He's had a bad day. She's, really upset about something else that's going on. She's really never like this at any other time. So defending that person is oftentimes a part of the battered spouse syndrome, and getting the person who's been abused to get them to stop defending them so they can talk about the actual abuse becomes a challenge.
Now, the DSM makes reference on occasion to rule outs, I assume for the diagnosis that's being applied. What is a rule out?
A rule out in our parlance says that we should consider these things before we look at other diagnoses. So, for instance, if we're going to consider schizophrenia, we should rule out substance abuse first, because oftentimes some drugs can create hallucinations and delusions and psychotic symptoms. So there's always rule out, just like there are medical conditions. So look for this before you consider this, is really what a rule out is.
Are there specific rule outs for battered woman syndrome or PTSD?
Sure. So there's rule outs for everything, because you're considering a number of different conditions before you make a differential diagnosis, or you pick that's the one that I think best fits this person. So yes, there's rule outs for both of those.
For my sake, what is the difference
That's how you decide which one. Whether it's your medical doctor, your psychologist, whoever. It's how they pick the right diagnosis. So you're going through kind of a card catalog in your head, and you're saying, all right, there's symptoms of this, but that's also consistent with symptoms of that. So is it schizophrenia? Is it bipolar disorder? Now I have to ask more questions. It's a decision tree. And that decision tree helps you to inform the person and either make a diagnosis in a legal setting or help to treat them clinically.
Now, if the individual, the psychologist who's doing the evaluation, identifies the presence of certain rule outs, what is their response professionally to those rule outs in establishing or assessing the patient?
You have to go down a decision tree. And we all kind of do decision trees in our mind every day about what we should do or shouldn't do in certain situations. It happens automatically. It's more structured when you're doing it professionally. So if you have a concern about substances, then you would kind of take that track and you'd have to ask a lot of questions in that area. So you'd want to know what kind of substances, how often are they using those substances? What kind of effect have those substances had on them before? I just picked one of many possible rule outs there. But every one of them you'd have to explore or ask additional questions because, of course, you don't want to come up with a wrong diagnosis because in a legal setting, that leads you to a bad opinion. In a clinical setting, it leads to bad treatment.
Now, I want to go back just a second. We talked about the subjective nature of the abused individual's understanding of what's happening. Does this subjective or does the experience that they have suffered result in, on occasion, their experiencing or they're anticipating or assuming or imagining a threat that others may not?
Yes, sir.
Yes.
See, all he's doing is he's coming in and saying, this is what battered spouse symptom or battered spouse syndrome is. These are the things to look for in it. These are the reasons why it occurs. This is their thought process. This man has not, they would have already said, have you met with Sarah, diagnosed her and all that? And they have not. So he's just laying the groundwork for what they're going to bring in Dr. Julie Harper for on the defense side to say that she met with Sarah. She's talked with her over several times, visits, and she now has diagnosed her as having this. Which I gotta say, I've lost some credibility in Dr. Julie Harper. The thing is with some of these things, though, it's like these women can only, or these doctors can only go by what the patients tell them. So this is one of those types of things that you could say, oh, I've got this. This is what I have. And all you got to do is do like Sarah did and read up on Medical MD or through these books and pamphlets they have and know just how to act so that you can make it look like you have it.
Doctor, from what you described this morning, I think we're talking about a complex and sophisticated process for assessing and diagnosing PTSD, battered women, the matters that you described. Is that a fair statement?
Yes, sir.
And in this instance, this particular matter regarding the state versus Sarah Boone, were you approached about the possibility of doing an assessment as to Sarah Boone?
Approach.
Go ahead, throw it up there. Do the carry your muted emojis. Go ahead and do it because I was just a talking. I was just a going on. And I've already forgotten half what I said. Thank you, Miss Rose, for your gifted memberships. If you guys got a membership, you received it from Miss Rose. And she doesn't get to choose who gets the memberships. That's chosen by YouTube. So it's totally random. I like how they asked it. So you were asked or you were approached about doing a diagnosis on Sarah Boone, and then they do, wait, objection. Is he trying to confuse the jury? He might have been, but I don't think you guys, I don't think this doctor has assessed her. He's a very good speaker, isn't he? He's a very good speaker. Thank you, D. Lumley, for becoming a member. I know your picture. Don't you go by another channel name? Or don't you have another name for, or did you change your channel name?
Objection sustained.
Sustained. Sustained.
Doctor, when you are retained to do an evaluation in these matters, what is your practice in regards to the assessment proceedings, the assessment efforts?
Well, I'd first want to know what type of an assessment that it is, because there's different methods of approach that you'd use to analyze and be able to give an opinion on whatever question's being asked of you. So the very first goal for me as a forensic psychologist is to isolate what the question is. So what are they asking me to do? Because I want to know, A, can I do that? Am I qualified to do that, or should I refer that to somebody else? Or B, is that something I'm going to have enough time to do and enough resources to do? And the next thing I would do is start asking questions about specifically what do you already have or what can you get to help me answer this question. So right away, I'd start to find out what's available. As forensic psychologists, we're supposed to do comprehensive evaluations of whatever the legal issue or question is, and it's supposed to rely on multiple sources of information. So depending again upon the question, I'm trying to then define early on what are those multiple pieces of information I'm going to need to help to try to give an opinion and an educated opinion about that matter.
Have you done an assessment in this particular case?
No, sir.
Can you tell us very briefly whether that was your decision?
Objection, relevance.
Okay, that's fine. That's fine. I can move on.
Objection sustained.
In your experience, doctor,
thank you very much.
Can battered women syndrome rear its ugly head? For instance, when there are threats to other members of the family, two-legged or four?
So yes, sir, it's very common that it's not just the person. It increases the terror from someone who's doing the abuse to mention other family members that they might also suffer abuse. So whether it's emotional or physical, those type of things are very common. Not always, but it's very common in the course of domestic violence cases or intimate partner violence cases.
And that fear is developed by the abused individual may exist contemporaneously with other issues, alcoholism, schizophrenia, and the like. Is that correct?
Yes, sir. They can all be combined together. And certainly that increases if there's other family members that are threatened or live in the same home or close by. That can increase the terror. The purpose of that is to increase control, to make sure the abuser has more control over the person who's being abused.
1 second, Your Honor.
Yes, sir.
In doing an assessment, doctor, do you look at outside materials?
Yes, sir, always.
And what kind of outside materials do you necessarily review in order to make this assessment?
Specifically to battered woman syndrome?
Yes, sir. Yes, sir.
So specific to this, you'd want to look at a lot of different sources of information because you're trying to, make a diagnosis if there's a trauma-related disorder, but you're also trying to figure out if there's the other elements necessary to make the diagnosis as well, like abuse that's been chronic over a period of time, and that the person feels they can't leave that situation, and if other people have been threatened. So you'd want to know things like not only what the facts are of the particular incident, usually some crime that's been committed, but you'd want to know the history of those behaviors. Has anyone else seen those? Are there people you can talk to? You know, friends, neighbors, bosses, anybody who's seen or heard of this abuse before? Have there been medical visits where the person has actually been damaged and shown up, made some other excuse, they slipped or fell or whatever it might be? You'd want to do psychological testing as a forensic psychologist, because we have very good tests that help us to determine whether someone's suffering from a trauma-based disorder or not. You'd want to know if the person who'd been accused of the crime for this type of evaluation made any statements to the police. If they did, you'd want to hear that statement. Or has there been a 911 call or calls? If that's happened, you'd want to hear that too. So any evidence you could collect, and these are some of those questions I was talking to you about before, you'd want to ask the person who's trying to hire you in the beginning, well, tell me what you have, because you'd want to see whether or not you're going to be able to make this analysis or not. So it's not good enough just to talk to the person, because that's just one form of information. It's almost like being a behavioral detective, if you will, as a forensic psychologist, because we're trying to get as much evidence wrapping around our interview with the person as possible to be able to guide our questions, but inform us and see whether there's what we call convergent validity. It's a fancy way of saying, does everything agree with each other? Does everything connect in a way that it all sort of makes sense? Or are these strange conflicting pieces of evidence that we need to explain away, or it just doesn't fit the criteria? So it's a rather comprehensive and complex evaluation has to be conducted to come up with this. And the final piece I'd say about it is that because oftentimes the abused person is defending still the person that they've oftentimes committed a crime against, it takes a bit of time to get to where you need to go. With all victims of trauma, whether you're talking about situations where you're doing therapy or you're doing an analysis in this type of setting, a criminal setting, it usually takes some time to break through that and get them to trust you to talk about the trauma, but to stop defending the person and talk about the abuse and how they felt about the abuse. Your goal, if you will, is to be able to see what's happening in that situation through the abused person's eyes. If you look at it through your eyes, often it doesn't seem to make sense. But if you look at it through their eyes, if it meets the criteria for a battered spouse, then you can better understand their world and what they're dealing with.
And real briefly, some of the things that you are evaluating when you examine, particularly the individual themselves, you're looking for anxiety and or fear.
Yes.
Low self-esteem.
Yes.
Are you looking for depression?
Yes.
Are you looking for any form of social or interpersonal withdrawal?
Withdrawal, especially if it's forced withdrawal, controlled withdrawal, if there's consequences to socializing with my family, my friends, calling them on the phone, texting them. So especially in that context.
Stockholm syndrome.
Sure, that can be part of it.
And what is Stockholm syndrome, real briefly?
So it's really adapting to someone who's captive or taking over a person, controlling their life, sort of adapting to that situation. The famous model of that would be many, many decades ago, a woman called Patty Hearst, who was kidnapped. But it's taking on the beliefs and taking on an acceptance, if you will, of a kind of a captive situation. And in these situations with women who have been abused, who meet the criteria for battered spouse syndrome, they oftentimes adapt, defend, and take on in an acquiescent way that this is okay and I'm part of this situation as opposed to opposed to the situation.
Will this syndrome exhibit itself in physical attributes?
It can, at times, even physical illness at times.
Inability to sleep, inability to keep food down, and those type of things.
Sure. Yes, sir.
Would that individual potentially experience hypervigilance?
Well, that's a large part of it. Of any trauma-based disorder is hypervigilance. What changes when you've been traumatized, any kind of trauma, not just abuse, but what changes is your perception of danger. So whether it's the lid of the garbage can hitting you on your nose, or whether it's someone being abusive towards you, those situations change your perception of danger. So you no longer see that object or that person in the same way. You have a foreboding sense of danger could occur. So other people may not perceive it with that person. He's so nice at work, or he's nice in these other settings, or he's so great on the softball field, but at home he's different. So that person who's being abused, their perception changes.
Does that include denial?
It could include denial, and oftentimes that's part of the explanation. The defensiveness of that person is the denial of how bad things are that are going on.
Any cross-examination?
Yes, sir. Morning, doctor.
Good morning.
Nice to see you in person.
Good to see you again.
So there's a subjective component to trauma, is what I understand you're saying, correct?
Always. Yes, sir.
And so hypothetically, a couple could be in a 3.5-year relationship with physical violence, emotional violence, even sexual violence, but either or both of those partners may or may not believe that is a traumatic experience for him or herself, correct?
Yes, sir. People mistake the stimulus about what happens as the trauma. The trauma is really the reaction to it. So bad things that happen, people don't always react in the same way to them. So yes, sir, that's correct.
So for instance, a homicide detective or a homicide prosecutor may go out to a scene and see a freshly dead body, and their perception of that environmental stimulus may be very different from somebody who works at Dunkin' Donuts and just gives us muffins in the morning coming across a dead body. Is that fair?
Yes, sir. That homicide detective may be able to go eat lunch right after it, and the other person who works at the donut restaurant may not be able to eat for a couple of days as a result. So yes, perception is a big part of how trauma occurs.
And I understand your answers today, and I'm not saying that they were different the other day. But I understand you to say that it's very important to do a comprehensive evaluation to get the full picture of what is going on in the perceived battered spouse's mind, correct?
Yes.
I knew he was going to do that. He's like, you need to do a full evaluation to see if that's really what's going on in somebody's mind. I think he wants him to elaborate on how long is it going to take to get this information out of people. And you know what I could hear Dr. Brannon even saying, and it might hurt the defense, is, yeah, well, you can't just, it may not be something you just diagnose overnight, because like I said, some people don't even know they're in the relationship. Some people they have denial of it all. They love that person. So they would never want to talk bad about that person. That's what I'm thinking. I could be wrong, but that's where I'm going with this. Thank you so much, Phyllis Ann, for gifting 5 more memberships. That's awesome. Thank y'all. Y'all are so sweet. So we got 10 people added to the earbud membership giveaway this afternoon. I just think he needs to just zero in on how long it takes to evaluate somebody with this. Are there telltale signs that people have when they're lying about it? Isn't this, I wonder if they could do that. I wonder if they could get up there and say, doctor,
The objection is overruled.
can this be lied about? Oh, it's overruled. Yay.
So we've been talking about the importance of doing a comprehensive evaluation with as many collateral sources as one could possibly have when making an assessment about the battered spouse syndrome, correct?
Yes, sir. Relevant piece of information. Yes, sir.
And would you agree that obviously the person who is accused of committing a crime, there are credibility issues that you do need to care for when relying upon that person's history provided about the events leading to that and the past events describing the relationship with the intimate partner?
Yes, sir. In every forensic evaluation, that's the case.
Is this particularly important if there's a comorbidity with an alcohol abuse disorder?
Yes.
And can you tell the jury what alcohol abuse disorder means in the DSM-5 TR?
Sure. It's the biggest part of it is it's not just the use of alcohol, it's impairment that happens as a result. So it's the excessive use of alcohol, but that could mean something different, just like the excessive use of marijuana might mean. But it's the use of alcohol to the degree that it impairs or affects a person's life. And with that may come a lot of other things like deceitfulness or aggression or unreliability, sleep or somatic problems, difficulties. So, but the important thing to remember there is that it's the use of a substance that impairs or affects a person's life.
And if there is alcohol involved in the histories being given about either the event in question or any preceding events, must the evaluator take that into account when evaluating the memories and perceptions of the person giving them that history?
Yes. So in introducing that new topic about memory, we know that substances can interfere and impair memory. So as a result of that, you'd want to know what they were using, how close it was. If you're talking about a particular event, like a crime, you'd want to know if there was substance usage, and if so, what the person's memory functioning was, and does that match up with other sources of information about what those events were.
Are you familiar with the narcissistic personality disorder?
Yes, sir, of course.
Is that something recognized in the DSM-5 TR?
Oh,
Yes, sir.
And can you tell us whether or not a person who is giving a history, whether it's the patient/client or whatnot, has traits, perhaps not a diagnosis, but even just traits of the narcissistic personality disorder? Is that something the evaluator should account for in evaluating the credibility of the history given?
Yes.
And why is that?
Well, because all forms of disorders or conditions or just traits may lead to inaccurate information, either not purposely or purposely. They may be deceptive. So certain personality disorders or traits can lead to deception or inappropriate or inaccurate information. That's why you need more than one source of information. Does what this person is saying to me check out with other sources of information?
And I don't mean to quiz you on it, but can you tell us some of the criteria for the narcissistic personality disorder?
And yes, sir. So it is a grandiose sense of self-worth. It's the consideration of yourself over anybody else. It's kind of operating in your own world. So it's an inflated sense of who you are. It's a misperception of how important you are to other people and your meaning to other people. It's a sense of specialness, that you stand out from other people in terms of special skill or skills, and that other people, if they don't recognize that, they should recognize that. So the heading, the biggest thing there is an inflated sense of self-esteem and grandiosity.
Are you familiar with an adjustment disorder diagnosis?
Yes, sir.
And is that in the DSM-5 TR?
Yes, sir. Correct.
Can you tell us about that?
Adjustment disorder is a person's reaction, and it could be emotional, it can be behavioral, or it can be both, to a situation that occurs. You broke up with your boyfriend or girlfriend, so you're upset about that. And so as a result, you're tearful, you're anxious or nervous or worried about what may happen to you as a result of breaking up with them, or you behaviorally may not start not going to work, or get into more arguments or fights with your children as a result. So it's a temporary reaction to a stressful situation that occurs in some individuals.
And hypothetically, if a person who is giving a history for criteria of diagnosis, let me strike that. If somebody is giving a history and that is being used to come to an evaluation conclusion of battered spouse syndrome, if that person has been diagnosed with adjustment disorder predating the traumatic relationship, is that something the evaluator should take into account?
You'd want to know any prior diagnosis, because it may not necessarily be exclusionary, but it could. So adjustment disorder is a temporary reaction. You're upset at a temporary period, and most of them just go away on their own. Whereas something else like a traumatic stress disorder is long-term. It's something that a person's stuck with for a period of time that usually doesn't just go away on its own. So yes, you'd want to know that. For that term I used before, that differential diagnosis, you'd want to know those things to compare and contrast them and hold them up against each other.
Now, hypothetically, if somebody says things like, I'm the best thing that has ever happened to you, and I'm the best you'll ever do, are those indications of narcissistic personality disorder?
Well, they could be. You wouldn't want just that alone. You'd want to see if that was happening in other settings. Is it happening on the job, with friends, with family members? Is it showing up on psychological testing? But certainly that would be a red flag. You'd go, I want to pay more attention to that. I want to investigate that further.
And is it important when evaluating trauma-based disorders, because they're based on emotional reactions, to do that rule out on alcohol or drug use?
Certainly you'd want to do that. It's not usually disguised as a trauma-based disorder. Alcohol and trauma aren't usually rule outs for each other, but it could exacerbate a condition. It could make you diagnose a trauma condition when it's just an adjustment disorder. I say just, I don't mean to minimize it, but it's not as serious as a trauma-based disorder.
Is it important to consider whether the abuser and or the abused behave differently in the absence of alcohol or drugs?
Yes.
And why is that?
Well, because you're trying to analyze a psychological condition. If as a result of drug or alcohol abuse, their behavior changes or their perceptions change, that's not a psychological condition, that's a substance abuse disorder. So that's why you'd want to know that. So if their condition remains the same, maybe it's a little worse when they're using drugs or alcohol, but it's the same perception of threat or danger, then you're going to diagnose a trauma-based disorder. If not, then you're going to diagnose a substance abuse disorder. You can have both, but you'd want to rule one out as opposed to the other.
And are you familiar with the classic three-step cycle of battered spouse syndrome or domestic violence?
Yes, sir, I am.
Can you explain that to the jury?
Sure. So there's a cycle of violence that was first developed by a woman in the 70s called Lenore Walker, Dr. Lenore Walker. She's a psychologist who's usually credited with developing the whole theory of battered spouse syndrome. And in the classic model, which we know oftentimes happens, not every time, but in the classic model, there's a period of tension buildup where things are happening, little arguments are happening, there's bickering back and forth, there may be some threats or some loud voices back and forth, but it's all things that are leading up to a possible violent episode. Then there's the episode that happens itself, the violent episode. It could be verbal, sexual, physical, but there's the violent incident that occurs. And then after that violent episode occurs, there's a honeymoon phase where the person who's done the abuse, they're apologizing, taking that person who was abused out to dinner, buying them things, saying nice things to them, complimenting them to sort of make up for the abuse. And it's it's called the cycle of violence. And the reason why is it tends to repeat itself in a lot of these situations of battered spouse syndrome, where you see this repeating itself over and over and over again. So people are kind of stuck in these revolving doors in their relationship.
And can one cycle be enough to traumatize a person?
Yes.
Does this trauma necessarily have to be coming from a man to a woman?
No.
And in fact, as times have changed, language has changed. And so when we keep referring to it as battered woman syndrome in the courtroom today, what we're actually talking about now is battered spouse syndrome or even intimate partner violence.
Yes, so I mean, interpartner violence can happen outside of legal settings, but it's really a kind of the large over grouping, if you will, to be able to talk about all of these other things that can happen as a result, like trauma-based disorders and battered spouse syndrome. And you're right. The later research has kind of pulled us away from thinking this only happens to women in heterosexual relationships. We know now there's all sorts of derivations, and that men can suffer also from battered spouse syndrome, battered person syndrome, homosexual couples. So we know it goes around to everybody, but still, women are more often diagnosed with battered spouse syndrome than anybody else.
Does the trauma have to come in the form of physical violence?
No, sir.
Does it have to come in the form of sexual violence?
No, sir.
Can it come in the form of emotional or mental violence?
Yes, sir.
And would examples of that include such as running the partner down and telling them that they're no good and, just general insulting and lowering their value?
It could. Remember, that's the stimulus, so it would depend on how the person who's receiving that responds to it as to whether or not it becomes traumatic. But yes, sir, that'd be the first red flag you'd want to investigate.
And you mentioned isolation before. So if somebody in a hypothetical intimate partner setting is trying to isolate the partner from his or her family members or friends or coworkers, can that be, and I'm not saying necessarily, can that be indications of intimate partner violence that could lead to battered spouse?
So sure, that'd be an example of coercive control. So if a person was doing that, that's consistent with that classification of battered person syndrome. Yes.
And hypothetically, controlling another person, the intimate partner's personal property or effects, such as a birth certificate or identification papers, can that be indication of emotional trauma towards the partner who is lacking the control over those identification papers?
So that's a stimulus that could result, depending on how the person subjectively perceives it, in some trauma. So yes, all of the things that you mentioned could be stimulus, if you will, that a person could perceive as traumatic.
And hypothetically, if one partner A gives partner B a gift, such as a bicycle, but partner A continues to maintain that the bicycle is his or hers because he or she bought it, even though it was a gift of B, can that be a form of emotional abuse towards B?
Sure, it sounds like control, but I guess you could interpret it as emotional abuse too, but it sounds more like a control mechanism that'd be consistent.
I'm not suggesting that it's legally or morally okay, but when one intimate partner does these hypothetical emotional things, non-physical violent things to partner B, if partner B has poor personal skills and coping skills and maybe consuming alcohol, is it unreasonable or unfathomable to hear that partner B responded with physical violence to partner A?
Objection, assuming facts not in evidence.
Sustained. Yes.
Oh, yes, he is going there. He's breaking it all down. The bicycle used like a control mechanism. I guess she bought him the bicycle too, huh? I didn't know she had his birth certificate and ID papers, though. I'll put away somewhere. This is stuff. These are little bitty pieces of things that we didn't know up until now. So he's going to have to now somehow bring it to light that he knew these items. He knew about these items. I don't know. I'm trying to think. Would Juan maybe bring in Juan into back up on the stand? Might be able to help put some of this in place to show that Sarah was doing this. Of all the way. Oh, and Brian Boone.
After hearing argument of counsel, the objection is overruled.
So let me respond to that.
If you remember the question,
Yeah.
please go ahead.
So it would increase the probability of physical violence. So if those things, in fact, were perceived as threatening or abusive in any way or insulting to the person who they were directed towards, it would increase the probability of physical violence.
And then again, the perceptions are all in the eye of the beholder, whether emotional things that are said to one another or physical things are done to one another, whether the recipient of that behavior views it as trauma is a subjective decision by that person. Right?
Yes, the perception is the impact. So that's how you would know that. It's just, water off a duck's back, or is it something that kind of sticks with me and I think about it all the time?
Now, you mentioned earlier anxiety, low self-esteem, and depression can all be components of battered spouse syndrome, correct?
Right.
Is it important as the evaluator to rule out whether or not these conditions predated the violent or abusive relationship?
Yes.
And why is that?
Well, because where things start is important diagnostically. So if all of those things were in place, all of the symptoms that were just mentioned are in place, then you wouldn't attribute those to the abuse. You'd say those things were pre-existing. Now, abuse could make it worse, but in terms of your diagnosis, you need to know where things started. So if those symptoms didn't start at the time where there was abuse that was alleged to have occurred, then it's unlikely that it's attributed to that abuse.
And independent of any narcissistic personality disorder traits, would you agree that anybody in a certain legal setting has a motivation to present themselves in a certain way?
Yes, to do impression management, either depending on the outcome. So if there's punitive sanctions, they may lie to make themselves look worse, or as a result, if they're in other settings like divorce settings, they may lie to make themselves look better. So there's always some impression management you have to kind of look through in your evaluation.
And that's important for an evaluator.
It should be looked at in every evaluation.
Thank you.
Yes, sir.
Oh,
Can you redirect
yeah.
examination?
Just want to, one more time, in response to the state's questioning, you indicated that where an individual's credibility may be in question, there's a necessity that the individual who's making the assessment corroborate whatever they're being told. Is that correct?
Yes, sir. In a number of different ways. We have psychological tests that assess for things called malingering or faking mental health problems or difficulties. So you'd want to do that. You'd want to look at other evidence to see if it's all consistent. So it's very important you don't just rely on self-report.
It's possible that an individual may exhibit one or two attributes of a particular DSM diagnosis, but not actually qualified because it's simply not there.
Right, sure. So sometimes like social isolation can be because we're introverted, or it could be part of depression. So you need to kind of follow it out and see how many of the symptoms are there to see whether or not it meets the criteria.
So I may exhibit one or two symptoms of narcissism, but not qualify because I don't meet all of those, or a significant number of the indicators that you would rely upon to make that diagnosis.
Yes, sir. Or it can be situationally based, like we may display narcissistic features here in a courtroom, but may not do that in any other part of our life.
Now, in your experience, have you determined, learned, either through your studies, experience, and so on, whether or not the abusive behavior may begin based upon an individual's perception of things occurring to him as a child or her as a child? In other words, if they grow up in an abusive household.
Okay, I understand.
Sustained.
You've indicated that there are things that, I think in response to the state's cross-examination, that there are things that may add to or may contribute to a particular psychosis or symptom. Would an individual's background as a child include those type of criteria?
Yes, sir. You're more vulnerable to certain psychological conditions based on your history. So if you've been traumatized before, or bad situations have happened to you before, if you've suffered from depression before, it makes you more vulnerable to those conditions or other conditions later on.
Finally, one question or one symptom that we haven't discussed, I don't think, or maybe it was discussed by the state, was learned helplessness. What is that?
Learned helplessness, I've really spoken about it a little bit, but now we have the fancy term for it. Learned helplessness was really researched by someone named Seligson, a doctor named Seligson, a psychologist, research psychologist. And just real briefly, what it is, it's when someone kind of gives up and feels like there's nothing that they can do to change their situation. It was originally done with laboratory animals. But where a person really feels that no matter what strategy they've taken, like leave, stay, fight, whatever it might be, it won't work. It usually leads to depression or developments of other strategies, like I have to appease or please or make sure I do everything correctly or apologize. So it's really believing that no matter what you do, it won't be effective.
Doctor, thank you for your testimony. Thank you for
Sure.
traveling up here from Miami so early in the morning.
No problem at all.
Thanks for the rest.
Thank you, sir. You can be excused.
Thank you, Your Honor.
Can the parties approach for a moment?
So they've been at it for what, an hour, not even 2 hours yet. I don't know if they're going to take a break. They've already gone through the 2 officers that they spoke of, or the 3. Now they've got Brannon. I'm not sure who they're trying to pull in because Dr. Harper is not going to be available until tomorrow. So who else do we think they're going to bring in? I don't think they don't have anybody. They can't. All of their witnesses have to be paid. Nobody's going to stand up for Sarah without a paycheck involved in it. My goodness. Ashley said, Gary, you do such a great job. Oh, thank you, Ashley. That's so sweet. That's so kind of you. Thank you for the super chat. Dorothy Lupe, even though it's not always prevalent, there are no psych recs regarding PTSD to confirm anything she is saying. PTSD text. Thank you for that super chat. I'm trying to break it all down here. Yeah, so we're going to have to hear
Members of
from
the jury, it is 10:40 at this time. We're going to go ahead and take that mid-morning break. Similar instruction I've given you over the last couple of days. I'm sure you're tired of hearing it, but I got to keep telling you. Please don't have any conversations among yourselves or anyone else about the persons, places, things, or charge involved in this case, and do not conduct any independent research on those things. We'll see you back here in about 15 minutes at 5 till 11. Thank you very much.
Oh, Margaret says, thank you for the membership, Miss
Y'all may be
Rose.
seated. Thank you. All right, we'll be in recess for approximately 15 minutes. Thank you.
She said, Margaret says, I refuse to say. Damn it, Margaret. She said, I'm really an RN, not working for Joe. Gratefully love it here. Oh, thank you. Thanks, Margaret. Yeah, I'm glad that you heeded our warning when you first came in to learn about how we were going to be here. Oh, and Miss Laura wants to come up and say hello to everybody. Hey, good morning. Good morning, Miss Laura.
Good morning.
What's going on?
I just wanted to come up and chat and say hi, see how you're doing today.
Good, good. I wanted to ask you about what was going on with Gacy, your Gacy stuff, because you had started a couple of those, and I didn't know what level you were. What series are you on now?
The next one that's going is going to be on Halloween,
Okay.
and that is the 7th one.
Okay, so you guys, I think Bama can probably put your link in the chat, but so Laura has her own channel, you guys. It's called Interesting Captures, and she is doing a whole series on John Wayne Gacy, and she's got like the major insight on this. Her family basically grew up around them. So this isn't just another documentary series on this. So if you're into all that stuff, I highly recommend you go check this out when you get done here, and subscribe to her channel so you can. You've got a lot more to do. You're not even. How do you think you're coming to the close on it, or do
No,
you feel like
not even close. I'm about halfway.
Wow.
Yeah, most people might recognize the fact because it's more recent in the news is them investigating an apartment building in Chicago. That actually is where my grandmother lived and Marion Gacy lived. And my grandmother and Marion Gacy, which is John Wayne Gacy's mother, were very good friends and had been friends for many years. So I grew up around Gacy till he got caught. I've been at his house. I've interacted with his family. I knew his sisters. I knew his children. I knew many of the victims. And yeah, it's been a lot to deal with over the years. So that's kind of what I'm releasing through these series.
Oh, yeah, that's good for you though to get it out there. You've been holding it all in.
Yes, I have intentionally denied interviews time and time again. I've let some other family members do a lot. We got very, very, very lucky in that situation because 3 of my brother's closest friends were Gacy's victims.
Mm-hmm.
I grew up around them. I hung out. followed my brother around. And my brother was the prime age. When Gacy got arrested, my brother was 18. So that kind of fits into, the age groups of all these things and everything. And Gacy was a piece of work.
Mm. Well, your brother probably didn't even, I mean, I guess after the fact, did he ever look back and go, oh, there's a time when he tried to, what's the word they use? Pull him in or get him to work.
Yeah, like lure him in or.
Lure him in.
The only thing that my brother ever said about any of it was that Gacy did offer him a job. But my brother didn't want to deal with that. I was the one that spent majority of weekends and summers at my grandmother's place because I wanted to. And I'm going to be point blank. I was a spoiled brat in my grandmother's eyes, and that's why I wanted to be there.
Yeah.
Whatever I wanted, she let me do. Whatever I wanted to go to the store and get, I wanted to go to McDonald's. My grandmother's like, okay, let's go. So that was my choice. It wasn't because of any other issues, but I'm also the youngest of the grandchildren. And so, most of my older cousins were male. And so Gacy
major
did
disadvantage. Major advantage.
But my brother, my actual mom and dad and my brother, they lived in the suburbs. So they weren't at my grandmother's as often. They were out there every Sunday, basically to pick me up, but they were out there every Sunday. So my brother was friends with a lot of these boys. I got to know a lot of these boys and everything else like that. But my brother was offered a job, and my one cousin was best friends and went to York High School with one of the victims as well in Elmhurst. So that affected him. And then one other cousin was offered a job by Gacy, but none of them ever took the jobs. Jesus. So, any one of them could have been
a victim. Yeah.
Exactly. And I know it haunted my grandmother to the day she passed that she did not see this.
Can you imagine being like looking back and going, I saw the signs, or I thought I saw, I didn't see them, or I didn't recognize them, or beating yourself up over something like that? That's awful.
Yes, exactly.
Okay, so let me ask you, let me see what she says here. Julie says, Carrie, I prefer to listen to this trial on your channel, but compared to even the judge, when your voice comes on, it's super loud and I just can't take it, but only during this trial. Please. Julie, I've turned my mic all the way down.
Yeah, she's awfully quiet compared to normal.
I don't know. Are you on buds? Are you on earbuds? I mean, am I louder than Laura right now? If you compare me to Laura, I mean, I could go all the way down to here. Can you hear me?
No, I can't even. I could barely hear you, and I have my headphones on.
Yeah, so I'm like at 50 right now. So I don't know what to do with that. I'm sorry.
I think it's just because the court audio is kind of low. So when you talk, it's a little bit louder, but you're much quieter than you have been.
Okay. Well, that's good because I do come across as a loudmouth sometimes. So how's the chat doing this morning, Miss Laura?
Well, that's kind of why I wanted to come up here. You have no idea why I asked you if I could come up here, but I wanted to talk to the chat for a minute because I wanted to kind of give you a little insight into a few things. You guys have been very good today, and we very much appreciate that. But I don't think that you guys realize all that Carrie is dealing with as this is going on. She's doing a lot of this by herself. And when you guys are asking questions and you guys are getting upset because she's not answering them, she's not necessarily seeing them as quick as you guys would like. So just kind of have a little bit of patience. You guys have gotten much better today. I will say that. But she is working her butt off. You guys have no idea what goes into doing these marathon things that she is doing and these live streams. She's on 11, 12 hours nonstop, everything else like that. So Carrie doesn't realize a lot of the comments in the chats where you guys are showing her the love and the support, because we do get the hecklers in there. So I also want Carrie aware that you guys in chat love and adore her, and they
Aw.
they really do realize the work that you put into this.
Thank you. I don't see a lot. Like yesterday, I kept trying to like whenever I want to put one of you guys up on screen, I just click on your chat message, right? Yesterday it was flying by so fast, I'd go to click and it would already move on me and I'd end up clicking on the wrong chat message. So I'm trying to get to everybody, but I mean, I've still, like I said, I've still got people over here with I'm not gonna, I will tell you this. I don't know. I guess you guys just aren't used to me being on here and being in a trial, but there's a lot of people that are just watching and not in the chat, and those people want to watch the trial. So I'm not going to put as many messages up during the trial, and I'm not going to stop and pause and all that, and I'm not going to talk over the trial. So, I mean, the trial is made, that's why we're all here. So, yeah, just bear with me on that. Speaking
No, I am
of
not
which,
Sam, by the way. I am not Sam. Sorry.
yeah. Oh, did somebody think you were Sam?
Yeah, I've got a couple of people asked that, so I just want to clear that up.
Says Buzzman asked me about the motion about a conflict of interest because Dr. Harper and Owens might be friends. I don't think that. No, I don't think so. I don't think that has anything to do with it. I'm not worried about that. They still have an oath in their duty of their profession to be fair and impartial. So I'm going to say no to that one. Buzzman. Tabitha Don said, I talked to her brother. He said, no child essay. You did talk to her. Really? How'd you get a hold of her brother? Look at Tabitha. Are you a little PI and we didn't know it? Thank you for your super chat. We want Carrie on the stand. Put me up there, Mark.
Mark,
Put
you
me up
just
there.
want
I know
Carrie,
just what to
period.
say. I know just what to say, Mark. I'm going to say your name out loud, too, while I'm up there, Mark. Mark Leach did it. Thanks for your super chat, Mark. Gladys oh, I can't see that name. Loreno? Is it Loreno? Am I saying that right?
Loriano?
Loriano. That might be, is that French or Italian? I don't even know. Welcome to our crazy little train that we have here. Thank you for coming in. Okay, now I'm done with super chats. So now I can go over here to the stream and talk to people in the chat and see what you guys are talking about and doing.
The link to my channel should be in chat now. It's been asked for a few times, so.
Yeah, Laura just put the link up for her channel, so you guys can go in and click on it over there while we're on break. Go over and click on it and subscribe, and that way you'll be reminded when she goes live. We tried not to we try not to like conflict with each other's schedules. It's impossible sometimes, but we do our best.
Oh, absolutely. I will go out of my way to not go up against Carrie at any point, and I will not cover the same things like she is covering it, because it's because of her that many of you are on my channel, so I'm not going to go against her ever. So you guys could feel free to subscribe. Both Carrie comes first.
Well, thank you. I appreciate that, but you're the reason they stay on your channel. Don't
work
forget
around your
that.
schedule.
You and your content. Dorothy Loopy said it's going to be a great snapped episode. I think they're going to do more than just a snapped episode on this trial. I see a movie, and I said this before, you guys. I see a movie coming out of this, and it not really saying her name, but everybody's going to know what it's about. You know? It's going to be one of those movies where they don't use the same names. The characters are similar, but not exactly similar. And it's going to be kind of like the same scenario. I mean, let's face it, the movie's probably been done millions of times already, right?
I'd be surprised if it's not.
I mean, Sarah's not the first one to do this. She's just the first one to be so bold and obnoxious about everything. What time did they say they were coming back? I wanted to play Dr. Brannon's video, and it's about a 7-minute long video. Do we have time? I don't know if we have time. Does anybody know what time they said we're coming back? I think we have.
I don't remember. Sorry.
Let me go.
Yana's saying no time left.
Yeah, I didn't think so. Okay, let's see. Let's go over who else do you think is going to come up, Laura? Do you think it's going to be who are they going to have up today now? Because Dr. Harper cannot come in until tomorrow unless she was able to change her schedule.
Your guess is as good as mine. I'm wondering if they're gonna. You know what? I'm not gonna say what I was just gonna say. So, your guess is as good as mine. I'm not gonna stir up arguing.
It says there are 2 police officers they've already had 3 deputies come up. I don't know if they're going to do something that's going to call into play us watching a lot of footage today. I really wanted to watch some of that body cam footage so bad. I, I wanted the jury to see some of that, but I also wanted to see the stuff that we haven't seen. I wanted to see the body cam footage of George's side because all the body cam footage that we've seen, they've redacted every interview with George. And it's like that I never understood why they did that. I couldn't get it. I mean, he was the one that was arrested. So they show Sarah, the victim, supposed victim, but they don't show him. It doesn't make sense.
I honestly don't think Owens has a clue what he's doing. I made a joke in chat of a little bit ago, and it was just a joke, but I made the comment about the judges, and it looks like they're coming back, so I'm gonna leave it alone and let you go back to what you've got to do.
Okay, thank you.
You're welcome.
Thanks for all you do in the chat, y'all. Be good to Laura and Bama in the chat.
Yes,
and Mel.
please. Bye, guys. I'll see you in chat.
Bye, Mama.
Bye.
I got timed out by YouTube for a reason I can't think of. What happened, Regina?
We are back on the
What'd
record.
you say, girl?
2020 CF 2603, State of Florida versus Sarah Boone. State. Defense.
James Owen from Sarah Boone.
County Henderson for Sarah Boone.
All right, Ms. Boone is still seated at council's table. Yes, Mr. Owens.
Judge, we had several late witnesses that were scheduled. We've excused Detective Scott Lowen based on the testimony of Detective Koepsell. We've excused Abraham Marino, who was going to be recalled based on the testimony of Detective Koepsell. You've heard from the 2 deputies, you've heard from Dr. Brannon. Maria Gallup-Holy is a young lady that's outside. She was a witness as a neighbor in that complex, and she would testify about observing physical injuries to Sarah Boone. We've spoken with her over the break that, in our opinions, collectively, Tony Henderson and myself, that it's not necessary to call Ms. Gallup-Holy because we have other evidence of injuries. There was disagreement about that, but I believe that Ms. Boone is now in agreement that we're not going to call Ms. Gallup-Holy. So that leaves now calling the Orange County Sheriff's Department phone extraction expert.
Ms. Uwadden.
Yes, back to the stand. We've got 2 short videos. These are the short videos relating to George Torres with a bat and then striking the TV. They're less than a minute apiece. The problem with that is because we've excused so many witnesses, that's our last witness. So we're going to be done here in probably 11:15. And then
But Ms. Walker is supposed to be here at 1 o'clock?
that's correct.
Okay, all right.
And then I haven't had a chance to meet with Dr. Harper, but I'm going to meet with her at lunch over next door. And we anticipate Dr. Harper this afternoon.
Oh, okay.
And we may be really close to ending the defense's case.
Okay, great. Thank you for letting me know that.
We're going to have a gap here.
Okay, so
early lunch.
well, yeah,
Long lunch.
that may, well, if you're saying that your presentation with Ms. Uwadden is 15 minutes, I don't know what the cross is going to be. It may be de minimis, or you may be saving her for rebuttal. I don't know. Mr. J or Mr. Cacciatore? As it relates to Ms. Uwadden, CSI tech. You're not calling her in
She already
rebuttal?
made a predicate during her trial testimony during our case in chief.
Okay, awesome. So what we can do is we can proceed with Ms. Uwadden, and we could just take an early lunch and ask them to be back here maybe 12:50. So that way, if we have any issues, we can address them before we start at 1 o'clock. Ms. Boone, you were sworn this morning. I just got a couple of things to go over with you. There was a list of witnesses that was provided to the court last night and again this morning as potential witnesses that may be called in your defense. One of those witnesses was Maria Gallipoli. Your lawyers have advised that they may not be calling that person as a witness in this case. Do you understand that?
I do.
And again, similar to other conversations we've had, I don't want to go into any specifics of any conversations that you've had with any of your lawyers, just whether or not you've had them. Have you had conversations with your lawyers about calling Miss Gallipoli as a witness?
Yes.
Have you had conversations with your attorneys about why they are deciding not to call her as a witness? Yes. And similar to what we discussed yesterday, do you understand that your attorneys make the trial strategy decisions, including what witnesses to call or not to call?
Yes.
Okay. Are you still satisfied with their representation of you in this matter? And are you still on board with the strategy that has been employed in your defense?
Yes.
Are you in agreement with the strategy not to call Ms. Gallipoli as a witness in this case?
I am.
Okay. All right. Thank you very much, ma'am. Then let's go ahead and bring our jury back in and we can call Ms. Uwadden and go from there.
Mr.
All right.
Lane, can you excuse Ms. Gallipoli?
All right. Thank you very much. Let's go ahead and stand and bring back in our panel.
Mr. Owens, how do you spell Gallipoli?
What I have, Gallipoli.
Gallipoli. Pronounced Poughkeepsie. I just saw that, Chad. So the judge, I love that he's like documenting all this stuff, y'all. So now he can't say that it's ineffective counsel if he's got all this stuff on the record. So, yeah, Rose, CYA. CYA Kranick. Bring the jury, Mark says. Was Judge Kranick referring to the apartment complex manager? No. I don't know if they can find her. I don't know what's happened with her. I don't know if she'd have been a good witness for the state. Veronica said, after the defense rests, can the defense call up previous witnesses like Brian? Yeah, so I can go over with you guys the different people that are like open to recall. I can tell you that I know Moreno was open to recall, but now they're saying they're not going to call him back up. But the state can call him back up still, I guess. To go back to my day one notes here. The other person was Brandon Motes. He can be recalled. Juan Torres, George's brother, can be recalled. Brian can be recalled.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury? Yes. I think you all could be seated.
The first on scene
Members of the
arrived.
jury, once seated again, if you could confirm that you complied with the court's instructions during our break by raising your
I'll
hands.
talk more later.
Record reflect all hands have been raised. Defense, you may call your next witness.
Judge, we would call forensic phone extraction officer with the Orange County Sheriff's Department, Officer Wadden.
Okay.
To the stand.
Thank you. We'll bring her in.
Owens, it's called a digital forensic technologist, analyst. Oh, my bad. That's her proper title. Can I get an eye roll in the chat? So the other person they can recall is Melissa Roughgarden. She was a CSI. She's the one that did all of the lead CSI on the case. And that's all I have for recalls right now that I can see. I assume they can recall Sarah up there if they need to. I think we've seen enough of her, but I don't know.
do you swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, ma'am. Could you state and spell your name for the record for us?
First name is Janella, Junella. Last name Wadden, UAD as in Delta, AN.
Counselor, you may inquire.
This one, again, your official title,
Digital forensics examiner.
and are you referred to as a detective or what is your?
Just an examiner.
Okay. Ma'am, Judge, can I approach the witness?
Yes, of course.
Ma'am, I'm going to show you what has been marked as identification defense exhibit AA. And you recognize that video or that CD of the video?
Yes.
Well, I think we kind of prepped you on it ahead of time. That was extracted from the Sarah Boone phone that you were asked to extract.
Yes, one of the media files, yes.
Okay, and is that video a fair and accurate depiction of one of the videos that was extracted from Sarah Boone's phone?
Yes.
And then identification Z, defense identification, same type question. You've had a chance to review that video, and is that one of the videos that was extracted from the Sarah Boone phone?
Yes.
Judge, this time I'd like to have these introduced in evidence.
Any objections?
No objection.
All right, what was pre-marked as AA will be received into evidence without objection as defendant 17. What was pre-marked as Z will be received into evidence without objection as defendants 18.
I hope we're not surprised by this video, you guys. I'm kind of worried about it. Debbie's worried too. But the state's not objecting to it, so I don't know.
We're going to play exhibit 17 first.
You may proceed.
And is there a volume? Judge, do you have control of the volume?
Volume is on.
You're gonna help me take this shit out. Real shit. You're gonna help me take it out. You're gonna help me take this shit out. That's that one, so.
Judge, I'm asking to publish exhibit 18.
You may proceed.
Oh, that doesn't look good, y'all.
Say again, sir.
You spoke about it earlier.
Yes, understood.
They're tendering, no
All
problem.
right, thank you very much. This witness can't be released, correct?
Yes.
State. Thank you. All right, can the parties approach momentarily, please?
Yeah, that wasn't good. That didn't look good, y'all. At the same time, he wasn't being aggressive with her, but
Members
still.
of our jury, at this point in time, it's 11:08. I know it's a little bit early, but due to the pacing and how quickly we've been moving through the evidence this morning,
and how the defense has teed up their witnesses for this afternoon, we do not have anyone until 1 o'clock. So at this time, we're going to go ahead and take our lunch break at this time. I'm going to give you a similar instruction that I've given you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or with that, members of the jury, I'm going to ask you to return here to 12 Alpha at 12:50, and we'll pick up shortly thereafter. Thank you so much for your service.
I mean, it could have been a lot worse, right? It could have been that he was being aggressive with her, but he wasn't. For all we know, she handed him the bat and said the TV's messed up and here, beat it up or whatever, take your aggression out on it. And he was saying that because
Thank you. State, anything we need to address?
he told her he didn't want to clean it up.
All right, we'll see you all at 12:50. Thank you very much. Court's in recess.
You know what I mean? Like he could have said, I'm not cleaning this up by myself. You're going to help me take it out. I'm not saying that's what happened. I'm just saying it's a possibility. We could sit here and all day long and say that after that, he took the bat and hit her upside the head with it too. You know, I mean, there's just you don't know what the context around everything is. Just like we don't know what the context is around her pictures that she took. Again, this is Sarah Boone we're talking about here. We don't know what the truth is. George, or Twilight Mist, thank you so much for becoming a member. Glad to have you. Glad to have you. And I love the image that you have up there on of George on your avatar. That's awesome. Blanco, George's bat video was George watching your channel, Carrie Jr. Carrie what? Huh? Just kidding. George watching. Oh, I get it now. Haha. Yeah, yeah. That would be anyone watching my channel. No, I mean, like, let me just set the stage here. What if George came in and the TV had been messed up? It had been broken. For all we know, the son could have busted it or something before George got a hold of the bat. And then she's like, here, take out your, you know how we know shit. Here, take out your aggression on the TV. And he's like, but I'm not going to clean all this up by myself. You're going to help me take it out. I'm just saying that's what I thought of. But I still don't see him. That's the most aggressive I've ever seen him in all the videos that we've seen. But I still don't think that I still want context. And I wonder if the jury's going to feel that way too. That they're going to say we're missing too many pieces of this. Could that be a possibility? Am I trying to be too, am I being too lenient on George? Y'all think I am? Am I too biased? You want me to rewind it? You want to watch it again? Thank you, Blanca, for your chat. I want to go back to the first one. Hang on.
And is there a volume? Judge, do you have control of volume?
Volume is on.
You're gonna help me take this shit out. Real shit. You're gonna help me take it out. You're gonna help me take this shit out.
What'd she say? Hang on. I'm going to screen record real quick. Hang on. I'm going to watch it one more time, and I'm going to screen record both of them. Then I'm going to put it in my captions, and we're going to see if I can't figure out if the captions will pick up anything. It didn't hear, so it probably won't, but...
We're going to play Exhibit 17 first.
You may proceed.
And is there a volume? Judge, do you have control of volume?
Volume is on.
You're gonna help me take this shit out. Real shit. You're gonna help me take it out. You're gonna help me take this shit out.
Something about something want to. It sounded like she said like something like I don't want to or something like that. I wonder if we're going to see more videos on her phone that are like completely the opposite of this, that they've got in the rebuttal.
Judge, I'm asking to publish Exhibit 18.
You may proceed.
He knew she was recording. That's just odd.
Say again, sir. Yes, understood.
They're tendering, no problem.
All right, thank you very much. This witness can't be released, correct?
What time did he say?
Internet, website, chat room, or blog. Means it all. Jury circuit about the place discussed during the trial.
Hang on.
Device. 1 o'clock.
1 o'clock.
And how the defense has teed up their witnesses for this afternoon. We do not have anyone until 1 o'clock.
All right, 1 o'clock it is. Okay. I've got something I wanted you guys to watch. Let me check in with you guys before I play it. Check in on the chat, see how y'all are doing. Wit says that was probably one of their activities. There's no telling. I mean, you could, her voice was slow, like she was drunk too, but I don't know. I don't know. He was obviously drunk. And he sure was out of breath easily from just doing that. Thank you for your super chat. Ashley said, hopefully the jury sees right through these random videos. She clearly was filming and not saying a thing. Dead giveaway. You think he didn't know he was being filmed? I felt like he knew he was being filmed. That's one of the reasons he turned the TV towards the camera. I could be wrong, though. I could be wrong. I'll admit it if I'm wrong. I don't know. I feel like now I'm having to kind of like leaning towards making him not sound like a bad person, but I don't know. I didn't see him hit her, so she never screams stop it. She never says stop hitting me. The TV, I'm scared, you're scaring me. I don't think she would have to say all that. I don't know. It's just we got to think about what the jury's thinking right now. All right, so I have a video that I need to pull up on my channel of Dr. Brannon, which if you guys haven't seen this, I thought that you might enjoy watching this. This is the doctor that was up there earlier that had such a great speaking voice. He had an interesting career in his youth, and I thought we could play this and watch it together. Just gotta find it. Here it is. We've seen everything we could possibly see here. Something else happens. Let's take a look at this. I'm getting this from a GWA promotion, I think is the name of it. We're just going to play a few seconds. So take a look at this person right here in the red and tell me if this looks like, if he looks familiar.
There, a wild swing, and his whole emotion carried him over the top rope.
Over the top. I can't get it to go full screen. Anybody recognize this guy? And by the way, this video that I'm putting on here for you guys this is going to be about Sarah Boone's case. You really can't make this stuff up. So I got an email today from Laura, who everyone knows, Interesting Captures. She's one of our mods. And Alexis had sent something over to her to tell her to check this out. Well, come to find out, this person right here in the red is the latest JAC approved psychologist in the Sarah Boone defense. Now, with that being said, what he did here and the work that he did here with the wrestling thing, he was making money on the side while he was going to college. It says it in this article that we're about to read. So I wanted to read this article to you guys to kind of give you an idea. I'm like, what? Now you're going, wait, which one is he? Because we got so many doctors. We got one that's stealing body parts and everything else. So let me show you really quick so you get an idea of who he is. This is Michael Brannon. You've seen some things. You've seen some images of him, some videos of him. We've shown him recently on our channel. And I think he has a decent reputation. I thought he did. Let me read you guys this article that came from the New Miami Times. This was back in the 70s and 80s.
Introducing out of Melbourne, Florida, weighing in at 228 pounds, Ted Marshall. His opponent.
I'm trying to make it go full. Hang on. Let me refresh the screen. Oh, good gracious, you guys. You cannot make this stuff up. Just when I think we've seen everything that we could pop, like, what? Now you're going, wait, which one is he? Because we got some images of him, some videos of him. We've shown him recently on our channel. And I think he has a decent reputation. I thought he did. Let me read you guys this article that came from the New Miami Times. This was back in the 70s and 80s.
Introducing out of Melbourne, Florida, weighing in at 228 pounds, Ted Marshall. His opponent, weighing in at 215 pounds, from New York City, New York, Dr. Red Roberts.
Weasel, that's what the crowd is yelling at Dr. Red Roberts there. You see him there, a competitor who's certainly not.
Now, if you guys know anything about wrestling, you know that most of the stuff is a put on, and it's just good. It's a good show, right? A lot of people like it. This was the 1980s Florida wrestling. I don't know exactly what part of the wrestling. I don't know what their levels are and what the different leagues are and everything, but he got paid to do this while he was going to college. But there was some controversy around him. It says former pro wrestler Michael Brannon cost taxpayers. The fans love to hate him. He is his character on the wrestling circuit. It was a pro wrestling circuit from the late 70s to the mid 80s. It says, but hunkering beneath this Mr. Hyde was an actual Dr. Jekyll. Roberts was the wrestling persona of Michael Brannon, who's now a Fort Lauderdale psychologist. While body slamming his way around the world, Brannon earned his doctorate from Nova Southeastern University by the 90s. He had swapped the ring for another theatrical battle zone, the courtroom. There, he was a financial success by the mid-2000s, earning up to $600,000 a year. $600,000 a year on the state's dime as a forensic psychologist. His reputation grew as he testified in courthouses in Miami-Dade, Broward, and Palm Beach counties in Florida. But after Brannon banked more than $1.5 million, his largest source of income, Broward public defender Howard Finkelstein cut him off. The fallout was as dirty as any WrestleMania matchup. So Finkelstein says, I wanted a system that was more fair. So it sounds like they were just bringing him in as a doctor every single time they had somebody up on the thing. But what Finkelstein says is that when he decided to bring his personal anger and resentment into the courtroom before a jury with one of my clients on trial for his life, that's when I was on legal notice. Now, when was this written? This was written in 2013. It says Brannon sued in a case that has been rumbling through the courts for the past 3 years and is currently on appeal. He calls the dispute a real-life death match with Howard Finkelstein. I don't know. I mean, this is an old thing, but I thought this article was interesting because of the fact that they're talking about him having issues down south. And I wonder if this is what's driven him to do more up, obviously in Orlando, up North Florida, and so on. And of course, we know that he's making a lot of money now on court TV. I mean, just as someone who can give great interviews, which to me, it's like, okay, so what? Who cares? But at the same time, I think it's interesting that he has this, he likes to act. He likes drama. Not that he likes drama. He likes to act. Someone that likes to act, it means that he could probably put on a show if he needed to. So anyway, I thought that was interesting. Thank you, Alexis, for sending that over. And thank excuse me. So my thought on that is that obviously there was nothing wrong with what him being a wrestler or anything. I just thought it was kind of interesting because he likes to get up and he likes to be in front of people. I don't know. It's just a certain personality. You could say I have that same kind of personality too. With all that being said, I found it interesting how you could tell that the prosecution found him to be a respectable witness as well. Just because of the way I think they've worked with him before, they probably still work with him. But I loved how he got up and he used their own witness against them on so many different questions. It was really cool. So how effective could his testimony be? Well, I think his testimony was more educational. Obviously, he did not assess Sarah, but they're setting the stage for what they want you to see or know about someone that is in this position. But I really think that Jay did a really good job on crossing him because he did bring up all of the inflated, grandiose self-worth, part of a narcissistic personality disorder. And should this trait also be considered? Adjustment disorder, is that a temporary reaction? It's a person's reaction to what occurs, like if they're, drunk or whatever. The doctor said absence of alcohol abuse. Does their condition change? And he said, yes, it could. And then I love how he said, well, what does alcohol abuse? What could it also, what could it interfere with? And he said, well, people can be deceitful. They can be unreliable. And I'm like, oh, and I know y'all were in the chat going, check, 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 Sarah Boone, check, check, check. So that was really cool. That was a good cross. I'm trying to look at what else I have for you guys. Well, I wasn't really planning on an early lunch. There's not a whole lot to look at here. I do have a video. Well, let me look at the chat. Let me just check in with you guys and see how y'all are doing. Chat is getting so small. It's so small these days to me. I can't see nothings. My ex-husband busted up his TV once when the quarterback threw an interception that kept his team out of the playoffs in front of his drunken buddies. They still talk about it and laugh. That was 40 years ago. Did you ever put him in a suitcase, Paula? I'm not, it's funny, but it's not funny. Yeah, it's like a guy being a guy. It was already broken. And so they did that to relieve stress. But, the thing that shows that he was intoxicated is if you were going to do something like that, you wouldn't have done it right there in the living room where you got to clean up all that glass and everything. I hope the dogs were put up when he did that. Dogs get so upset over stuff like that. If you look for the existing damage to the TV, it's not consistent with the damage produced by the baseball bat. I noticed that delete LOLs, and I thought it could have been the bat, or it could have been something thrown at the TV prior to. It could have been a ball that maybe they were playing with something, and it got the end of the TV there. I mean, there's a lot of different things that you could do. And then you've also got, let's see, like poking of the bat, as Owen says. Emily says, behavior records, please. Also, Hub's joke with song. Oh. Okay. So Emily sent me an email last night. I gotta look at it again and remember what he said. Oh, what'd I do with it? Okay, let's play the song first. I'll play the song. I haven't played it today. Emily's husband asked her, she's like, after he listened to the song, she said, so what do you think about it? Isn't it it's got a good ring to it. It's catchy, right? He said, it's catchy. All right, here you go, guys.
Morning light through the blinds is creeping. Eyes on the clock while the world keeps sleeping. Coffee cold as my nerves keep twitching. Long crime will soon be switching. On and on are all the eyes on the live stream. Just my need to switch it to trial TV. Sarah Boone's in the camera's glare. Suitcase secrets creeping through the air. All she cares about is her suit and jailhouse hair. A bag of letters and made up face. I'll save a smile, no from any grace. When the jury finally comes to see, she deserves craft singles and a first degree. Ooh, I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on the feed. Grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangle, it feels so heavy. Will the testimony be true and pure? I'm on edge and I can't be Cacciatore sure. Rightful truth. Courtroom drama unmasking proof. The defense getting credit and giving us hope that the jury sees Boone trying them for dopes. Sarah's guilt is plain for all to see. Intentional for suitcase, second degree. Justice for George amidst the misery. Lost patience tried on attention's weight. Verdict coming, well we must wait. Echoes of doubt make my heart beat wild. I just need the facts untouched and mild. YouTube's glowing, don't let me down. In this court we'll see who wears the crown. I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on the feed. Grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangled, it feels so heavy. Will the testimony be true and pure? I'm on edge and I can't be Cacciatore sure. Ooh, I'm waiting for truth to unfold. Every whisper, every word so bold. Waiting for Carrie to switch on my feet, grabbing the Pop-Tarts and getting ready. Fingers crossed, the stream stays steady. My thoughts tangle, they feel so heavy. Will the testimony be true and pure? I'm on edge and I can't take much more.
Thank you, Amber R, for the song. She created that all by herself, y'all. She did the well, she said it was AI, but it was music. She did everything and put it all together like that, wrote the lyrics and everything. Isn't that awesome? We have a talented person amongst us, you all. And Miss Amber Rachel. Damn it, Margaret. Yep, keep doing that. I'm gonna draw here in a little bit. Okay, so I've got, if you guys don't mind, I'd like to go over here to Court TV, or not to Court TV. I'd like to go over here to X, formerly known as Twitter, and look at what Jules is saying of what went on in the courtroom just in this little bit of time we've been in there. She said that when they showed the video of George smashing the TV, that the jurors watched it and took notes. They said that, she said that she knows that she's certain the defense is resting later this afternoon after Dr. Harper testifies. She said something about, in my opinion, Dr. B's testimony could help Sarah, or the flip side, it could hurt her because he never assessed her. And then she said that while that he was giving his testimony, that jurors were still paying close attention and they were taking notes. Intimidate and George is the better spouse. Oh, Jay just made us thing like, okay, yeah, that's what is going on in court. We've been there. Okay. The only thing about Jules's notes is like she makes notes so that if you're not watching it all, you can be caught up on what's going on. So I'm trying to skip those notes that we already know about. Juror 13 was nodding her head in regards to trauma. I just put a video up this morning about Juror 13, you guys. And she said that during the sidebar, several jurors in the back row are laughing and conversing. The first row are fairly quiet, with one or two of them glancing at Boone. That was it from today. Oh, I guess somebody is sitting behind her. That Body Language 01 is sitting behind her. I'm probably going to be embarrassed myself on break by fangirling her. I met her at the Take Care of Maya trial. Notice taking as well as the jurors. So Sarah's, of course, taking notes, but so are the jurors. Jurors are paying very close attention to the doctor while he gives his education and background. 8 jurors are taking notes. They are paying close attention. Oh, her name is Susan Constantine, the body language person. While they were waiting for Dr. Brannon to come in, some of the jurors are looking at Sarah Boone and the gallery, and 2 are talking amongst themselves. Let's see what else. She's talking about the next witness. Juror 13 hasn't taken Juror 13 has not taken her eyes off of Sarah Boone. Interesting. Very interesting. All jurors were taking notes when the officers were on the stand. Let's see. Some jurors took notes when the first officer was up there. I don't know if they I don't know if we really learned a whole lot when they came up. That was just weird to me. And I think that's it. I was looking to see if she said anything yesterday. Yesterday, she said one male juror had not taken his eyes off of Sarah during cross-examination. She is zipping the suitcase and it appears difficult to zip. She said that while they were doing that, everybody in the gallery was standing up trying to get trying to get sight of what they were doing up there with the suitcase. And this is when she said that George's daughters were in the courtroom yesterday. Some of the jurors were rubbing their eyes late in the day when Sarah was testifying because it was so late, we were all tired. It appears that the first row of jurors are taking notes now. This was when Jay was cross-examining her. And what else did she say? Juror 13 nods her head in nodding her. Wait. Juror 13 nods her head in agreement with Sarah Boone. Something that Sarah said. Oof. Three female jurors seem to be having a reaction to all the photos that they were showing yesterday. They were all standing up looking at her leg when she was up there, sticking her leg out and showing everybody. George's daughters didn't show much emotion during any of that. The jurors were writing notes and taking notes during Sarah's testimony still. One female juror appeared to be upset. And Sarah Boone completely turned in her chair facing the jury while testifying. Yeah, I'm telling you guys, that body language that she was given yesterday did not come across to me as low self-esteem. It was not the cookie cutter, I'm a victim thing. It just, I think, so I guess that's it. I just wanted to read y'all what was being said about what was going on in the courtroom because I think it's important, especially when, yes, juror 13 is the domestic violent victim. And if you haven't seen it, I did a video on that this morning. I was kind of hesitant on putting it out at first, but then I saw a lot of people talking about it on YouTube and on Twitter, and I was like, well, screw it. I'm just going to go and put this video out then because I didn't know if it would be something that they would say would be bad, tainting the jury or something by putting something like that out. And I definitely didn't want to call out that woman, but nobody can tell who she is. Nobody knows her name, none of that. We haven't seen her face. We've just heard her voice. So a lot of people don't think that number 13 should be there. Jury 13 will be the cause for a hung juror. I don't for a hung jury. Yeah. Could be. Could also work both ways. She could also say, I don't see her. She doesn't come across to me as a victim. But, Sarah had Melissa, who was also a DV victim in the apartment complex. She had her bamboozled too. She also felt like George was getting beat on as well, though. So is this a special, maybe, we keep trying to look at it both ways, like one way or the other. It's either she was the abused or she was the abuser. I think in this situation, I think the proper way to say it is Sarah was the aggressor and they were both abusing each other in different ways. And we have to be able to say, is the jury going to see it that way? I feel like in watching the trial, that's where I'm going with it. Does that mean, but let me just show you guys one real thing really quick that's super, super, super important that I want y'all all to keep in mind while we're watching this. And we may have already played this, but it's a 1-minute clip and I think we're going to play it again. Goes back to what is the jury looking for? Something that the prosecution said early on in his opening, and it's something that we need to keep in mind throughout this entire trial. She had malicious intent. She showed no regard for his well-being, no regard for whether he lived or died. Those are the key factors that we're looking for in this. What is proof of second-degree murder in Florida? A prosecutor must prove a defendant acted without regard for human life. They lacked premeditation and planning and acted with a depraved mind. Well, we're going to see that when we listen to the videos, right? So they don't have to show that she planned all this, because I know a lot of people were like, oh, she's in it. They don't need that. Forget that. They don't need all that. They do not have to prove in second-degree murder, they do not have to prove intent to kill. That is huge, you guys. And that is where the defense has to combat that. Florida statute outlines second-degree murder as the unlawful killing of a human being when perpetrated by an act infinitely dangerous to another and evincing a depraved mind regardless of human life, although without any premeditated design to affect the death of any particular individual. So does that help you guys? I mean, does it help you with the remembering of it, what we're looking for, what they're going to be looking for? Let me show you this really quick. The best part about the entire, that's not it. It's up here. So Ginger Snap did this. And a tribute to George. I got it. I put it on our Buy Me a Coffee membership boards. The photos are up there. But I thought that was really nice. And it's beautiful. She made that. Thank you, Ginger Snap. It's a beautiful way to honor him. Okay. So you guys want to listen to the inmate forms. I know you do. Okay. Well, let's go over here and look at them. We stopped on page 27. Do you want me to look at the chat before I do that and check in with you guys? Do y'all need anything? Everybody good? Can I get you a drink? Anybody need a Dr. Pepper? I don't see any questions in the chat for me in any way. I think you guys are more or less talking amongst yourselves. I'm so used to you guys doing that. I'm not used to having questions. So CB doesn't think they've done the whole shown proof of the burden of proof. I don't know though. If you just look at if you take out all the BS and you look at it this way, she left him sitting in the suitcase overnight. She left him sitting there. He said, I can't breathe. And she just walked away. Maybe that's all we need. Maybe at the end of the day, that's all we need. I thought I already read this page. I think I did. Oh, you remember how last time she got in trouble because she told the faith-based worker that that person needed to be in their car by 9 a.m. or something? So I guess after that occurred, it says that she was removed from the faith-based program on today due to several complaints of intimidation, bullying, and antagonizing inmate workers in the dorm, specifically dorm workers. I spoke with her approximately 3 weeks ago due to complaints from an inmate worker assigned to dorm trustee. I advised her she would be removed from the faith-based program and relocated if she continued this negative behavior. Her negative behavior has continued, and therefore she was relocated to a new housing dorm to resolve the issue. You know what's when they were talking about earlier what the doctor said about the being taken away from friends and not having what was it, how he said it, solid, I don't know if he used the word solidarity, but you just kind of you get to where you just kind of you go inward. Anxiety, depression, fear, forced withdrawal, I think is what he was saying. Forced withdrawal. Sarah doesn't have any of that. She doesn't have any friends because nobody likes her because she's a pain in the ass to be around. and for those of you just coming in, I'm reading the inmate behavioral notes of Sarah Boone in jail. This next one is dated September the 29th of 2021. And again, they just noted that she's been removed from the faith-based program. It should be noted that inmate Boone is one of the most improved program participants with no discipline issues, respectful, and always willing to help. Wait, what? Chaplain was notified by email after that. Isn't that weird? Some people like her and some people, maybe that just shows how manipulative she is, that some people really like her and other people see her for what she is. Again, she's constantly refusing breakfast. She doesn't want to eat their breakfast. Inmate is receiving the negative failure, and this is November of 2021. This negative failure to follow up to CDC guidelines of social distancing and wearing a face mask. Inmate was observed with her face mask hanging from her chin, not over her nose, and not properly on her face. It should be noted that she was not eating, drinking, or in the shower at this time. And then on the same day, it says she got another negative for talking in the bunk area. All inmates were advised of the dorm rules and that non-compliance would result in a negative. She will not shut up. Then this must be a big one. On November the 9th of 2021, she approached the officer desk and asked if any mail had come in today. I told her no. Inmate Boone didn't like that answer, so she got an attitude and continued questioning this officer about the mail. She stated that she finds it very odd that the mail hasn't come in 3 days and demanded that I call to check to see if B dorm has any incoming mail for today. I then explained to inmate Boone that I am unaware about the past few days because I wasn't the dorm officer. I can only speak for today that there is no mail for B dorm today. And lastly, I don't need to call anyone regarding mail. FDC has a system put in place for mail. Inmate Boone then demanded an inmate request form. The form was made available to her and she stormed off. Inmate Boone constantly questions the officer's authority and gets an attitude when she doesn't get her way. On the 11th of November, all inmates were given my dorm expectations and advised several times there would be no talking at any time in the bunk, shower, and bathroom areas. After ensuring all inmates understood the verbal orders given to them, while conducting chores of the dorm, the inmates continued to talk in the bunk area, disregarding the rules of the dorm. All inmates in the dorm were informed that they would remain in their bunk for 2 hours, which was documented in my IMS. Inmate Boone approached the officer desk stating that she had to contact her attorney before 2 p.m. I advised her that once the 2 hours are over, the phones will be available for her. Inmate Boone then started to become argumentative, and it said it was not fair. This was cruel punishment. Inmate Boone requested an inmate request form to speak with a supervisor. She writes him up constantly, and she's asking for a supervisor constantly. Oh, Lord have mercy. Inmate is receiving this negative for talking in the bunk area. That was on the 22nd. She's refusing breakfast constantly still. Now she's refusing dinner on the 5th of December. She refused her lunch tray on the 6th of December. And then on December the 6th, it says that on today, December 6th of 2021, inmate Boone approached the officer desk with an inmate request form along with 2 handwritten pages that were attached stating that she wanted to grieve video visitation regarding her visit that took place on yesterday, December the 5th of 2021. Inmate Boone stated that her visit was cut off for no reason. Officer Veal made it very clear to inmate Boone that her visit didn't get cut off for no reason. I'm sure it was a reason. I then asked her if she addressed her concerns with the officer that was on duty yesterday, and she stated she did, and the officer explained to her, being that her son departed the home visitation screen, her visit ended. Okay, so she was talking to her son in December of 2021. I then stated to inmate Boone, there is the reason. I'm not rude. I'm not sure what she is trying to grieve. I took it upon myself to landline video visitation. I spoke to Miss Stanford and advised her of inmate Boone's concern. Mrs. Stanford asked me to place the phone on speaker so that I'm sorry, so that inmate Boone can hear the rules on how her video visitations works, and the rules were no different from an on-site visit. Inmate Boone was still a bit upset, but appeared receptive and now understands how the visitation works. She still insisted on speaking to a supervisor. Let's see. She walked the chow line and verbally refused her lunch tray on the 7th. Refused breakfast. Refused lunch again on the 12th. On the 14th, she was called for a visit. Inmate Boone arrived for the visit without a mask on and asked for a new one. Inmate Boone was asked for her old mask to verify the nose clip was intact. Inmate Boone stated that she threw the mask in the trash and was unable to provide one. Inmate issued new mask and reminded that a mask must be shown intact in order to be issued a new one. So on December the 15th of 2021, she had an attorney visit. Mauricio Padilla, that was her attorney for the first 2 years. Mr. Padilla requested to see Boone in person in the staff briefing room or some other room. His request was denied, and he was advised that he would be allowed to speak with her via the attorney interview room. I personally don't have knowledge of any official directives that allows Boone face-to-face visits at FDC with her attorney. Lieutenant Loranza was notified concerning this incident. So the next day, inmate Boone approached this officer while conducting a visual and stated that she needed to speak with me. Inmate Boone then stated that inmate Ferpez, so Susan Ferpez, is going around dorm B discussing her case and calling her a murderer and yelling, "I can't breathe," per inmate Boone. Oh. So she was mocking the case, and she says that she knows nothing about, is what Sarah said. My first question to inmate Boone was, did she discuss her concern with the officer that was on duty prior to me? And she said no, because it just happened yesterday while I was on duty. So my next question was, why am I just now hearing about it today? And inmate Boone had no answer to that question. I told her that I would speak to inmate Ferpez in regards to this matter. Inmate Boone made it loud and clear that she did not want to speak with the other inmate. Instead, she requested me to remove that inmate from bunk number 40, and by doing so, the problem would be solved. Being that the would be solved by just moving one. Being that the problem would be solved by just moving one from one bunk to another, I decided to move inmate Boone instead. Inmate Boone appeared to be upset regarding this decision, so that she stated that everything was okay and that she did not want to be moved. She is comfortable where she is currently housed. It should be noted that inmate Boone is always trying to manipulate the staff to get her way, and being that this particular incident did not work in her favor, she is upset. Inmate Boone is fully aware if I hear anything else in regards to this matter, she will be relocated to a different bunk. Good gracious. Inmate Boone approached this officer and stated that she needed a new pair of slides because they are ripped. She stated that she has asked 7 different officers and no one has gotten her a pair. On December 21st, Officer Vale, gave inmate Boone a new pair of slides, but she didn't like the pair, so she declined them. She said that her current ones are so much nicer. I'm not sure what type of slides she thinks she should get, but they are all the same. Gosh, you guys, I swear. On December the 29th, she volunteered to assist with inmate worker duties such as washing personal laundry, setting up for lunch, and cleaning the bathroom due to there being no inmate worker assigned to dorm B. But she's still refusing her lunch. She refused to shower on the 24th. Oh, she's depressed during Christmas. January the 4th, she refused to come to the clinic for further medical evaluation. M.A. McKay was advised of her refusal. On the 9th of January, she was given a pair of slides. And it says that on the 13th, a dorm is currently on restricted movement and does not have a dorm trustee. Inmate Boone assisted with laundry and putting away the supplies. Refused her lunch tray. Refused to get out of bed for chow on the 14th. Refused breakfast again and again and again. Due to a medical emergency on the 16th, Inmate Boone was in the shower. Inmate Boone was given a verbal order to get dressed quickly and get out of the shower due to a medical emergency in the dorm. Inmate Boone was given several verbal orders to get out of the shower and return to her bunk. Inmate Boone proceeded to take her time coming out of the shower. Once the medical emergency was completed, Inmate Boone was given 2 hours of informal discipline and counseled about her actions and appeared receptive and understands that future incidents will result in formal disciplinary action. She refused her dinner tray on the 16th. Again, refusing breakfast all those days. Whew, feeling lightheaded. Okay, she is receiving this negative for talking. This was the 23rd of February. She was receiving this negative for talking in the shower to inmate Wright Robinson. I told her that both inmates several times that there was to be no talking in the shower, but to no avail. All inmates were advised of the dorm rules, and non-compliance would result in negative. Inmate is aware that if her negative behavior continues, she will be given informal discipline. She received a negative for failure to follow verbal orders from staff on the 23rd. She's constantly starts arguments with the other inmates in the dorm every time she volunteers to do duties around the dorm. It should be noted that Inmate Boone is not the dorm trustee, just a volunteer. I advised Inmate Boone that I do not need her assistance anytime that I am on duty because of this very reason. On the 23rd of February, Officer observed Inmate Boone approach Inmate Ward while she was standing at the kiosk. Inmate Boone was telling Inmate Ward that she is not doing a great job at being a dorm trustee because she gave everyone cleaning towels instead of bath towels. That she was referring to the towel exchange that was conducted the night before. The conversation between the two inmates had gotten loud, causing a disturbance. I advised both Inmate Boone and Inmate Ward to cease the noise and to return to their bunks, and both complied. Shortly after, I observed Inmate Boone still talking about Inmate Ward to the other inmates in the dorm. I then called Inmate Boone to the officer's desk and advised her I do not want to hear anything else about the cleaning towels. It is done and it is over with. And Inmate Boone decided she wants to continue challenging me by talking about the towels. It should be noted that Inmate Boone constantly tries to challenge and manipulate the staff. Inmate Boone was counseled in regards to her behavior. I made it clear that I did not need her to do anything in the dorm unless her name is assigned to a chore on the chore list. I also stated that there is nothing else to talk about in regards to this matter. She appeared receptive, but understands. She did not appear receptive, but she understands that future incidents will result in disciplinary action. So she's been in jail for about 2 years now, and they've all got her numbers. Sorry, I need to drink something. My throat hurts. Checking in with the chat. Carrie, do you think that Jay has done enough to prove this case? I feel like I do, but at the same time, I'm kind of like you guys. I'm having a hard time with, coming to a conclusion on it because of the fact that I don't know. I can't get in I can't get in the mind frame of a juror that doesn't know about the case because we know way too damn much about this case. So trying to think like a juror is almost impossible because we have such dislike for this woman. I don't know. It's difficult to say. I want to play something really quick because I need to take a quick break for my throat. just want to play a video for you guys. I don't think I've played it on a live yet. It's not a real long clip, but it's something that I found funny that I put together for y'all. Oh, y'all can't even see it. Shoot. Hang on. I'm sitting here playing it and I haven't switched the stream over. Oh, I need to eat something. I'm getting lightheaded. Hang on. This might be a little loud. I can either turn it on or off. I don't know how to turn it down. So be prepared for get your earbuds ready, you guys.
I never gave up on him. Why I'm here today, I'm still not giving up on him. I helped him. I took care of him. I never gave up on him. Why I'm here today, I'm still not giving up on him. I would do anything for him. I helped him. I took care of him. That's what I'm here for. I never stopped. I'm here now and I'm still trying to help him.
Oh, Lord. Okay, now, Miss, let's talk. It's time to grow up, ma'am. We don't fight. What is the point? You have spent time away from your child.
In all honesty, we have not gotten into it. The only thing I thought you were going to ask me about, which I was going to be honest with you anyway, I just scratched my husband's back. Everything else, I have no idea what it is.
All of this foolishness here. First of all, getting so drunk that you can't manage yourself.
I don't want to drink. I don't want to drink.
Start thinking like there's somebody more important in this world than yourself. I'm not going to jail on some foolishness.
I've been good.
I'm not going to be fighting in public because I'm too grown for that. What I need to be doing is finding me a good job so I can make sure that you have food on the table, clothes, and benefits. Where you working?
I don't have a job.
Okay. Well, see, instead of getting drunk and fight, you should have been looking for one. Stop acting like you're 12.
Everybody tells me that. All my neighbors don't tell me that. The office, property manager.
There's no alcohol so good where you got to get yourself so messed up.
I can't get drunk. Number one, I do not want to get drunk. Like being non-compos mentis.
You don't know.
Tell me and we'll both know.
You have a responsibility to that child.
I know.
Stop acting like you 12.
Well, I know.
Go out and find you a good job and then start thinking about a career path for you. You got two pending violent things. This right here and the one that hasn't even gone to court yet. What has fighting gotten you?
Nobody touched anybody.
Other than jail time, what have you benefit from all these fights?
Nobody touched anybody.
Okay, that's all I got to say. Go out there and act like a grown-up, okay? Go raise your child and stop getting into all these fights and foolishness.
Yes, ma'am.
While somebody else is raising your child who's forgotten about you by now. All right.
I just love Judge Tammy. I know. Oh. What I would like to do, guys, is replay what hits her cross yesterday, if you don't mind. I don't want to. Okay, let me do a thing because I want to play this because I need a break on my throat for a second. So I was going to ask you, do you want to do all of it where she's on the stand, or do you, because I don't know if we have time, it's an hour long, or do you want to just do the, well, this video is only 23 minutes long, so maybe we do have time for it. Here, we're just going to play with this video I've got.
We continue to, I guess, speak to one another, and his tone changed, and I knew the tone, and we ended up, I guess, arguing back and forth with one another, and it was the things that he was saying very much frightened me, and cursing at me and threatening me. And
Did he want you to let him out of the suitcase?
I'm sure so.
Okay. Go ahead, tell me your.
And it just got very heated very quickly, and he continued to push on the suitcase. And my fear was that he was going to break out of the suitcase, knowing that it was a broken suitcase. And his hand started to come through. His hand started to come through this way. And so I shook the suitcase. Trying to get his hand to go back in, shaking it, and telling him that, please stop doing this. Please stop doing this to me. Please stop doing this to me.
So his hand actually got out of the suitcase.
Yes.
And you went to the suitcase.
Yes.
And shook it.
Yes.
Did that force his hand to go back in?
No.
So you're shaking it. Were you shaking it to try to get the suitcase, his hand back in?
Yes.
How long did you shake it?
I don't know.
But his hand was still out.
Yes.
Was he trying to get out?
Forcefully, yes.
Was he angry at you?
Yes.
Were you in fear?
Always.
If he would have gotten out of the suitcase, what would he have done to you?
Like he used to tell me, he probably would have made me unrecognizable, or I would have lost my life.
Did you lose the grip on the suitcase?
Yes.
Where was the bat in relation to the suitcase?
It was leaning up against the dining room table right there.
How far was the bat from the suitcase?
3 feet, 2 feet.
Was his hand still out of the suitcase?
Yes.
And was he getting out of the suitcase?
He very much was trying, yes.
And so what did you do?
For the split second reaction that I had, I happened to see that, and I grabbed the baseball bat and was trying to poke his hand to go back in, to please don't break through, please. So I hit his hand.
Did you hit the outside part of his hand?
Yes.
We've seen the photographs of his left hand. Did you cause the bruising there?
I'm guessing yes.
Now, you've seen the bat. It's a youth bat.
Yes, I bought it for my son.
Is this the bat you used?
Yes.
And you said you poked him with it?
Yes, I kind of pushed, like I held it with the skinny part here, and then
So the grip here,
prodded at it. Yes.
you grabbed it with both hands here,
Yes.
and then the barrel of the bat, the big part of the bat is here.
Correct.
And you thrusted it into the different areas of the suitcase?
I started with his hand, and his hand, he was still trying to get out. He was still trying to do that. So I started to push on the suitcase around it, hoping to have his hand retract and go back inside.
You made those injuries.
I did.
We've seen the photographs.
Yes.
We see the bruising. Is that from that bat?
Yes.
Eventually, did his hand go back inside from you doing?
Yes, finally he had subsided and retracted his hand.
So in your mind, did you prevent him from attacking you?
Absolutely. Split second decision.
Now, once he retracted his hand, do you remember zipping it up some, or what did you do in relation? Because he was upside down, was he not, at that point?
Yes.
At some point, you flipped him back up.
I did.
Tell how that happened.
He wasn't cursing. He wasn't threatening. His hand was inside foremost. There was no more of him trying to break through the suitcase. So I felt safe enough to turn it back over. It wasn't happening anymore.
You went back to the video and the couch,
I did, yes.
and you saw the second video,
Yes,
the 22-second, and he's right side up again,
yes,
and you hear him say, Sarah?
yes.
Had you left enough room for him to get out? Zipper to zipper.
Yes, that's how his hand was trying.
That suitcase has 2 zippers, doesn't it? And they meet at various places along the line?
Correct.
How much room, when you flipped it over, how much room was between zipper to zipper?
I don't know specifically. I mean, it was enough to where his hand was coming out.
After you had hit him with the bat, was he not trying to get out anymore?
No,
Did you believe that he could breathe in there?
yes,
Did you ever believe he could die in there?
no, at all.
Were you trying to kill him?
Never.
Did you want to kill him?
I did not.
Did you walk upstairs?
I did, yes.
Why didn't you let him out before you walked upstairs? Were you afraid?
Terrified is more of the word.
As long as he was in the suitcase, he couldn't harm you.
Correct.
When he's Did you want him to calm down?
Yes, I wanted him to stop being angry because I know what it is for him to be angry.
You went upstairs. Where were the dogs?
The dogs ran upstairs with me.
And where did they go?
On the bed.
Did you have the phone with you?
Yes,
I know at some point you called your husband, Brian, did you not?
I did.
Do you recall how long that conversation was?
Not very long.
Can you recall what was said?
I don't remember exactly. No, I don't.
Miss Boone, Sarah Boone, you said that when he was in the suitcase, he was threatening you. Can you tell the jury what he was saying?
I don't know. Am I allowed to curse?
Yes.
But he was going to fucking end me. And that's what made me ask him please to stop doing what he's doing to me. That he was going to, I'm guessing, try his best that night to probably take my life.
But what, the threat you heard was he's
going to
say the
fucking
word.
end me.
Excuse me?
Fucking end me.
End you?
Yes.
Hold on.
Yes, sir.
Judge, can we approach the bench?
Yes. All right, members of the jury, it is 2:14. I have a matter that I have to discuss with counsel at this point in time outside of your presence. So I'm going to ask you to retire to the deliberation room. We'll bring you back in as promptly as possible. Again, similar instruction that I've given you. Please do not conduct any independent investigation or research as the person, places, things, or charge involved, and do not have any discussions amongst yourselves or anyone else about those things. We'll bring you back in as promptly as possible. Thank you.
Very interesting.
Y'all may be seated. Thank you. State, you can proceed with any argument at this point in time.
Judge, I believe that's pretty close to what we already knew from the deposition testimony, from the doctors relaying what she said for the proffer. What we have here is testimony from the defendant. Her timeline is she comes downstairs after having gone up to the shower and hiding, laying down after being declared to be it. She comes back downstairs, and before she gets back to the bottom of the stairwell, she can see that the victim is in the suitcase trying to get flat because the lid is flopping and he's not hidden just yet. And so she comes over, and I believe she testified she was moving it around before actually zipping the lid shut, but moving it around, everybody's laughing. It's all fun and games still. And then she zips it, and it's still fun and games, and everybody's laughing. And then at this point, she testifies that this is now her opportunity to get on her pulpit to express her true feelings about everything. And that's when she sits down on the couch and opens up her phone device and begins recording what later turns out to be IMG _1062.movie at 11:12:45 for 2 minutes and 3 seconds. During this period of time, the decedent is expressing meekly that he can't breathe. The only time he ever curses at her is, Sarah, I can't fucking breathe. Babe, I can't fucking breathe. He is demonstrating under the law that he is in fear of losing his life. She has committed an aggravated assault. She has committed false imprisonment. She was the initial aggressor. There was no overt act to justify these actions that she took against her boyfriend. She then goes on to say that during this period of time between the end of the movie at 11:14:48 seconds and before the next one starts at 11:23, that it's now at this time, while he's still constrained and clearly unable to get out under his own power despite having his hand out, she begins beating him with a bat, poking his hands, poking the suitcase with a deadly weapon. A bat is used for baseball, but it can also be used to harm another person. And according to the medical examiner's testimony, there was great harm caused to him, deep ecchymosis bruises. She can't start to do this out of fear, like the analogy I gave earlier. If I pull a gun to rob you, Judge, and you pull a gun, I can't shoot you in self-defense. She started this. She started this. There was no overt act, and therefore, we're asking for you to prevent, under the case law, any prior instances of violence, any reputation evidence, and any battered spouse syndrome evidence, because that's simply just what the case ended up being. Thank you.
Response.
Judge, this was a game by two intoxicated people. When people are drunk and intoxicated, they do silly and stupid things. The evidence is uncontroverted that George Torres willingly, by his own choice, elected to hide in the suitcase. By their interaction between the two of them, giggling and laughing at each other, he consented to her zipping up the suitcase. And the playful nature of what was going on during those few minutes prior to the video. When the video is turned on, there's a 2-minute period where they're talking. He's saying, I need to get out. I can't breathe. She's not taking him seriously. As you've seen from the videos, I thought it was the boy crying wolf. She did not appreciate the fact that he could be actually having trouble breathing. And this was a chance for him to be heard by her about how she felt about some things involving their relationship. A short time later, the video was turned off, and then that period has been testified to by my client. And that period is uncontroverted. That's a second period of time. We've got that time for the video. We got the 11 minutes, we got the 22 seconds. And there's no video, there's no audio, there's no eyewitness, there's nothing but Sarah Boone's testimony. And she's testified here today that they had words, there were threats. He got his hand out of the suitcase. She knew by the threats and him getting his hand out of the suitcase that he was about to get out of the suitcase and he was going to hurt her. A reasonable person under that scenario would believe she was about to be harmed. She was an imminent threat of harm. She blocked that attack by grabbing the bat, hitting his hand. When that didn't work, she started poking him with the bat in the suitcase. Eventually, she poked him several times. He put his hand inside the suitcase. She put the bat up. When she realized he was not going to do that any further, she flipped him over right side up. She still had a fear, knowing that if he got out, she would be harmed. He would beat her up. She went upstairs. That is an overt act based on the discussions, coupled with the fact that he threatened her using the word, I'm going to fucking end it for you, or some words to that effect. I don't remember her exact words, just before she went upstairs while he was still in the suitcase. If she would have let him out, and this is now this is an event involving an omission, failure to act, failure to unzip him at that point before she went upstairs. The failure to act, the failure to unzip, which would have let him out. which would have created a situation that she believed was imminent bodily harm to herself. And I guess I'll get a couple of examples. Let's say that a police officer is called to a scene and the only thing he hears is there is a suspect and the suspect may be armed. So of course the officer pulls out his revolver and he's walking around. Well, then eventually he finds the suspect and the suspect reaches for his waist. The officer doesn't see the gun, but the officer sees the movement to the waist. The officer fires and shoots the suspect. The officer is justified because there's an immediate threat of harm. The officer has to react instinctively. There's no time to think. Similar to the actions that Sarah Boone had to take. Another example, you're in a bar with your buddies and you've had something to drink and another group has had something to drink and one of your buddies gets into an argument with one of the buddies on the other party. And one of your friends, seeing that it's being escalated and the guy that's arguing with your buddy is aggressive, more aggressive than your buddy is. Your buddy's trying to settle the thing, but this other individual, maybe he's had too much to drink and he's more aggressive. So you go around behind this individual, and before he's able to strike your buddy, you grab him, you lock him up. That's physical restraint to block an attack. Or you grab him by the neck and you choke him. Physical restraint to block an attack. That's what she was doing with the suitcase. If she let him out of the suitcase, she was going to be harmed based on him trying to get out with his hand, based on the threats he made while he had his hand out, and based on the threats he made while he had his hand inside just before she went upstairs.
Thank you. Court's going to re-review all the case law that it's obtained in its research in this matter and come back with an oral ruling momentarily. Thank you.
And we know how that ruling went. He said, go with it. Go with the BSS. All right. So Dorothy was asking about hung jury in Florida. And let me show you. I Googled it. And here's what it says about it. Okay. Go away, little thingy. Okay. So in Florida, a hung jury, also known as a deadlock jury, results in a mistrial and the case can be retried. This is because Florida requires a unanimous verdict in court cases. Take this thing off the stream. Here are some of the other things that can happen when a jury is hung. The parties involved return to their positions before the trial began. So she goes back to jail. The prosecutor can decide to try the case, but a judge may disallow it in some cases. In a civil case, which we're not even going to read that because I don't care, the defendant remains legally innocent, but I wonder if that means she goes back to jail, though. A hung jury can be better for the defendant than a conviction. It's difficult to undo a conviction, and an appeal isn't guaranteed. Yeah, that's true. So I hope that answers your question. That's the best I can do. Probably pretty much on par. Do you guys, I notice a lot in the chat, you guys are, it seems like you're feeling like, oh, yeah, it's not looking good. I don't know. Retrial winning. Yeah, I don't know. I've never paid much attention to a retrial. So I don't know about that. That's, ugh. Please let jury have wisdom and clarity. Yes. Yes. Please, dear Lord. All right. So our Amber Rachel has written us another song because you guys were so receptive to this one. I don't have any music for it. Hang on. I mean, I don't have a background for it. And I haven't even listened to it myself. Do y'all want to hear it? I guess I can, let's see. Okay. Let me look at this really quick, make sure I'm not going to get dinged. Okay. Oh, and we get to see a picture of Miss Amber Rachel. Pink paper clip swing is what she's calling it. Can I get dinged by SoundCloud for doing this? I don't know. Can SoundCloud give me a copyright strike if I play this? I guess not, because it's her song, right? Sorry, I'm trying to read chat. I'm trying to read y'all's responses. You think I could get in trouble, Carol? Okay. Yeah, I better wait till I have it on something else. I can play it for y'all because I don't know how to do that. So I'll wait. Okay. Going to close that out, and I'm going to close this out. And now I want to go over to. We've got another 20 minutes before court comes back. Licensing rights, if she allows it. I think she does, but I don't. Is she in here right now? I think she would have responded if she was in here right now. Hey, I've got an idea. Let's do the drawing. Let's go ahead and do that. This goes back. Let me remove this. I've got too many things open. And can you see it? Here we go. K Alvey or Alv. Is it Alv or Alvey? K Alvey. I'm going to write your name up here so I don't forget. All right, K Alvey. Here's what you got to do. Go find my email address in the description of any video you can open up, including the one you're watching now, and email me your mailing address. And in the title of the email, if you would please put I'm a winner, so I know to give you the utmost importance when you email me. I'm getting a lot of emails lately. And people are literally going, damn it, Margaret. So that is the winner for today for our normal drawing. And then we'll have the member drawing a little bit later on. Okay. I had somebody send me an email that said that they think I should probably try to change the feed from Court TV to Trial TV Live because they said that the audio was better. Do y'all want to go that route? I guess I need to find out from y'all if that's what y'all want to do, because I don't want to do it unless y'all want to do it. My email's in every description. Every description of every video. Rebecca says she's in. It is better sound. Okay. I mean, I would love to support them. So that's fine with me if y'all want to do that. You're in favor of better. Is it that bad? See, the thing about it is like on my end, I can't hear. I think it's lower for you than it is for me. Captions haven't been very helpful. Worth a peek. They haven't. I haven't been paying attention to them. Cass, I didn't catch what you said, but let's go that route. Okay, Cass. Cass, I need $1,000. Okay. Cass says, let's go that route. Picture of George passed out looks staged. I don't know if it looks staged. It's so Amber Heard, though, isn't it? And Johnny Depp. And you know, we don't know, like, did it give us a date or anything of when that was done? Like, the way she is, she's just so conniving and she, oh, she plans out, and I'm not saying she planned to unalive him, but she planned out a lot of these things to get him in trouble. If things weren't going her way, she would do something to get him in trouble. It's like stir the pot. And it's crazy as it is, but I think that that's what she would do when she called the police. It's so odd. But then she's taking those pictures and she's taking those videos and she's going to use it against him. And she doesn't care what the outcome for him is. Like he said right out he didn't want to report her to the cops. He was probably worried about her losing custody or, partial custody or whatever, shared custody with her son. He probably didn't want to do that to her. Did she think about that with him? No, not at all. Not at all. All right, well, I'm going to go over to this stream, and instead of Court TV, I'm going to go to Trial TV Live. Because the only reason I had it on Court TV was because everybody was talking about they want to see the captions. But if we're not worried about captions, that means I can put up chat now when we're watching the court. The feed's back up in the courtroom right now. They've got the feed in the courtroom up. Let's see. Okay, there we go. So we'll do this time. How about that? They're more funny than accurate. Isn't that sad? Do you think it's because they're so on the fly like that? They're not. That's why they're so bad. Yeah, we can always switch back if it's not good. I just hate like trying to switch around on you guys without talking to you first. Okay, Carol. Send me an email. I'm getting a lot of emails, so if I don't respond right away, don't get upset. Buzzman says her actions caused his death and they were having a great day. The jury will also see how controlling she was. I think they got to take all that in. Did they, when he was talking to what's his name, did he pinpoint on that, the controlling factor? Now we still have that other doctor, Tanya. What is her last name? Tonya. I forgot her name. The one that's for the prosecution. She's going to come in and testify. So that's good. If Sarah gets taken out of the jail and moved around, yes, they're probably like, oh my gosh, take her, get her out of here. Thank you, Shanna. Or Shanna Shanna the banana. Thank you, Shanna the banana. I appreciate your super chat. By the way, I heard somebody was having a birthday in here. Thought I read it in the chat. Michelle, my belle. Well, happy birthday, Michelle. I would sing to you, but I don't want my viewers to go down. JPC is in the house. Good to see you, JPC. You're worried about Dr. Harper? Jenny, not Jeannie, Jenny. You're worried about her? I don't know. We'll see. I just feel like anything she says, they can come back and combat that with whatever their psychologist says. I have to admit something. I hope that they send everybody home early today. It's all Margaret's fault, JBC said. Yeah, that's Mark's new mantra. It's all Margaret's fault, not Mark's. Plus, no falling asleep though. Dr. Harper is shady? You think so? I know she testified in Margaret. No, she didn't testify in Marsha Thompson's case. She was supposed to, and she didn't. No, it was that other case we looked at where she was supposed to testify in and she didn't the last minute because the defendant didn't want to testify. So they didn't bring her in. Paid to play, but then again, aren't they all? Is Margaret? Are you gonna blame the AI captions on Margaret? Mark? I guess that's allowed. And I wonder, here's the thing too, if you guys think about this, I wonder if the jury thinks they're like, well, she's not showing remorse, but it has been 4 years. But do you think it's like the jury's wondering, why has it been 4 years? Why has she been in jail for so long without a trial? And I don't know if anybody could ever predict what she just done and gone through and all that, but I just kind of wonder if that's a question mark in their heads. All right, we've got 10 minutes. So here's what I got to do. I got to go run over here and let my sister's dog out real quick. So I'm going to leave this on with the sound on and everything. And I'm going to mute myself. So when it comes back, so you guys, let's take a bathroom break. We got about 10 minutes probably before they start coming back in the courtroom. So I'll be right back. Okay, I put a pot of coffee. I definitely need it. I've got the volume up on here. It looks like they're back. They're starting to move around the courtroom a little bit now. All right, Frankie, you can't come in and start panting. If you hear panting, it's not me. It's my dog. Just FYI. You're welcome, Michelle. Carrie, I said that I felt great about the case. The facts are too much to overcome. You think so? I don't know. I feel good about it. I just wish I could get myself into the mindset of where they're at, where the jury's at. And it's just you can't unsee what you've already seen. So all is okay, all Carrie is gone. Let's act up. Hey, Ginger Snap. I wasn't gone that long. I wasn't gone that long. I had to go turn off a crock pot too. My sister's doing a thing for dinner, and I promised her I would. I always hate going up there to see her dog because I always want to bring her dog down here with me because she's by herself and I feel like she's lonely. She's not, probably. She's probably fine. Hey, Tyler, how are you doing? Good to see you. I'm fixing to have some audio in the courtroom. So, Buzzman, he wishes the state could say something about her 9 attorneys just to show how controlling she is. On that.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
Chief Judge Strong, half of the state. William James, state.
Defense.
James almost for Sarah Boone. County Henderson, Sarah Boone. Kevin back over behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. She is in custody. However, there are no restraints as she will be standing as with the rest of us when our jury enters and exits. It's 12:57. State, anything we need to address?
No, sir.
Defense.
Judge, I've got something. Can we approach the bench?
Yes.
Why does everything have to be up at the bench with Owens? Why can't he just, unless they're talking about that matter that's going to be handled in a private video call about their financial status with Sarah Boone? He's like, Judge, see, I got a book deal, Judge. This is my swan song. I'm going to write this book. I'm going to give Kevin and Tony a cut, but I'm out. Shoot. I'm going to move to Key West, Judge. I don't know. They got to be we said it from the beginning. As soon as he got on the courthouse steps, when he first started, I was like, why did he say that about the flyer? Because I felt like maybe he got obtained some other way. And then he got on the courtroom steps after he first came in, and he started preaching, his spewing his stuff. And I thought, oh, okay, he likes to be interviewed. He likes the publicity. Okay, well, we know why he's here now. We know why he's here. And ever since then, he's been on TV. And I think there are a lot of attorneys that find it to be unethical when attorneys do get up and speak for trial, to do that whole. I think there's some shame in that. I don't know a whole lot about it, but it would make sense considering that, you could say something that could hurt your client. Just my opinion. Do y'all think I'm right on that? Margaret told him to take the case. You're right. It's Margaret. Damn it. It is her fault. Always, isn't it? Heather's nervous about a hung jury. Don't be nervous. We're not going there yet. We still got time for them to come back with a great rebuttal. He wants his face on TV, Rebecca. Wonder Joy says that interview with Vinny was weird. Both of his interviews with Vinny were weird. The first one, he was on the phone. The second one, he was on, it looked like Zoom, and he had really, really bad connection. And he didn't even look like, first, he's so cocky that he doesn't even it's like, oh yeah, I know you're glad you got to talk to me or whatever. He doesn't even look up at the camera or any. It's just, I'm just finding it to be weird. It's just weird. He's perfect for freaking Sarah. Yeah. There are filters you can use to make it look like you have a black eye. Oh, I didn't even think about picture filters. But I think that the CSIs could have pulled that out in that unit. To me, it just looked like it was so perfectly drawn. Like it was just so, yeah. Blanco, who are you sending a DM to? Meet me in the DMs. I'm closing out this now that we don't have time, which I'm glad we don't, because I didn't read any more of this. What page were we on? We were on page 37. Y'all remember that? I'm going to write it down. Inmate behavior form, page 37. Y'all didn't seem that into it, huh? Because you've already heard it somewhere else? Probably at this point. You sent me you sent me DMs too? DMs too? Okay. Shelly Evans. You changed. No, you didn't. Where have you been? I was thinking about you the other day. I saw something and it reminded me of you. I said, where has Shelly been? You haven't been here this whole time, have you? He's cheating on me. Blanco is. I know. Drunky the Bear. I know. I love that Sarah tries to manage everyone's job in the jail. She is a busybody. They used to call it a busybody. Now they call it a Karen. Y'all, I'm telling y'all, she is great for a movie. I hate to say it. I hate to say it. Okay. I cleaned the heck up out of my computer today, this morning. I got up early this morning, and that's what I was doing when I was getting ready. I cleaned out a ton of files. I'm like, I don't want anything else going wrong with my computer while we're online. So we should be good. I wonder what Sarah had for lunch. Oh, that's right. A peanut butter and jelly sandwich. Was it good? She probably turned it away. She turns everything else away. She's like, bring me my Pop-Tarts. I bet she's got those little girls sneaking her food in. Look, nobody's going to know if you bring me some Cheez-Its. Nobody will know. Know that. Know that.
All right, thank you all very much. Mr. Owens, if you could see to calling Dr. Harper at this time to advise her to be here at 1:30 for her testimony.
Yes, sir.
Oh, you think she had bologna today?
Just 1 second, sir.
I like bologna and cheese sandwiches every now and then.
I'm waiting for Mr. Owens to return.
That's what I was thinking about having today. I'm scared to eat though. I'm scared to get hungry. I mean, I'm scared I'll get sleepy. Sarah actually leaves it. The room lights up when Sarah actually leaves it. That's funny. She's trying to get him to sneak in all kinds of stuff. You know she is. She does not like rules. I bet in high school, she was like, I bet she was like a little mischievous little thing, and she was probably a little loose little thing too. She doesn't like authority. All right, so what are we doing here? We're gonna have.
Without Mr. Owens? Yes. Sure.
Where's Owens at now? What are we waiting on now? Okay, so we're gonna have we're gonna have Pearl Walker, I think, get to the stand, and then Dr. Harper is going to come up to the stand. But I don't see either one of those lasting for the rest of the afternoon. So I'm wondering if we're going to end up getting off early today, or if they'll go straight into letting the state do their rebuttal, because they could just rest today. Sarah made a deal. Isn't that February? Sarah made a deal with some shady local Girl Scouts to get their Thin Mints. She probably stole those Thin Mints from those poor little Girl Scouts. You know she did. Should have taken the deal, Sarah. Per Rose. I didn't say that, Sarah. Rose said that.
All right, as we've discussed, we're not going to be having the charging conference regarding the jury instructions at this time. That will be conducted tomorrow. I have requested the defense to provide any instructions that they are seeking to be provided to the court and to the state in Word format tomorrow, including but not limited to 3.6F or 3.6G and any portions thereof that the defense is seeking to utilize for the purposes of jury instructions. The court throughout the trial has been redlining the jury instructions that were provided initially by the state. At the end of the evidence and testimony presentation this afternoon, the court will email those to all parties. Once Mr. Owens comes back in from making, advising witnesses of when to be here, we will bring in our jury and proceed with the evidence presentation this afternoon. State, anything else we need to address? Defense, anything else we need to address?
No, you are.
All right, very good. As soon as Mr. Owens enters, we'll bring in our jury. The deputies will assist Ms. Walker in the wheelchair into the jury box.
Oh, she's in a wheelchair. Bless her heart. There ain't nothing wrong with yellow cheese. What's wrong with American cheese? Nana, what's wrong with you? Teresa, that's American craft, American singles. That's what I'm screaming. That's my favorite.
No worries. We'll cross that bridge at 1:30 if she's not here, sir. Okay. All right, let's go ahead and stand and bring in our jury.
She either that or she's tired. She might be pissed, but she might be tired. I'm not a robot. It's hitting me today. I'm really super tired today. They need to feed Sarah some tuna with onions, then let her do some whispering to. She doesn't have to do all that, Shelly. Shelly, she's got. Ask Tyler. She doesn't need tuna and onions. It's already bad. She's a total tattletale.
All right, Teresa.
Rules for yes, Sarah Starr. You're right. Rules for everyone else but herself. I was never much of a Spam person. So salty, but I mean, I'd eat it if I had to. It wouldn't gross me out or anything.
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, everyone can be seated. Thank you.
Oh, he went to go get the
Members of the
doctor.
jury again, welcome back. I hope you enjoyed your lunch. I see juror number 4 from the 5th from the right to left, second row. His hand's already up. He knows what's coming. If you can, just raise those hands, confirm you complied to the court's instructions. Record reflect all hands have been raised. All right, members of the jury, the defense is going to continue with their evidence and testimony presentation this afternoon. Thank you. Mr. Owens, you may call your next witness, sir.
Your Honor, the defense calls Mr. Parole Walker.
All right, I'm going on mute. Y'all read what Katie just said about the black eye. She's an ER trauma nurse. They're going to take advantage of this sweet old lady.
I'm approach the witness, Your Honor, just in case.
I think the deputy's got it.
Got it, okay.
Cookie, you don't think they're going to rest today?
Ms. Walker? Ms. Walker? Can you raise your right hand and be sworn, please? Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. Thank you.
Ma'am, good afternoon. Could you state and spell your name for the record for us?
What did you say?
Can you state and spell your name for the record
Earl
for us?
Walker. Pearl Walker, Walker.
Thank you very much, ma'am. Mr. Beck, you may proceed.
Good afternoon, Ms. Walker. Ms. Walker, do you know the defendant, Sarah Boone?
Yes.
How do you know her, ma'am? How do you know Ms. Boone? If you can't hear me, just ask me to repeat myself. And I'll do so.
Okay.
How do you know Ms. Boone?
She lived in the same apartment building that I lived in.
And can you tell us how long the two of you shared the same apartment complex, apartment buildings?
About 4 years.
And how is it that you became familiar with Ms. Boone?
My husband and I was sitting out on the porch, and we see her coming with her 2 dogs.
And what happened then?
Then I would call her over with, with her dogs.
And what do you mean by call her over?
When I see her walking with a dog, and I see her and I look at her, and I said, "Hey, Sarah, how you doing?" And that's it.
And would she generally respond to you?
Yes.
And how, well, I won't go there. Would you spend time with Ms. Boone?
Did I spend time?
Would you spend time speaking with Ms. Boone?
Yes.
How long would you speak with her?
About 15 or 20 minutes. That's all.
And was your husband sometimes involved in those conversations as well?
He just say hi.
So you and Ms. Boone were the 2 primary communicators?
Yes, sir.
Okay. In the time that you knew Ms. Boone, did you witness anything about her person or her body that gave you cause for concern?
Sometimes I would see it like she had been choked around her neck or her arm be hurt. Have a mark on her arm. And I just asked her.
And would she describe how that happened?
Just say, I had a.
Hang on. The objection is sustained.
when you would ask her that, how did she appear to you to respond emotionally to your questions about her injuries?
She just say, one of them days or something.
Objection sustained.
Just for the record, instead of telling us what she would say, would she demonstrate any emotion on her face?
Well, I would see the emotion that she was upset about something.
And did you ask about her obvious upset persona? Her upset, the fact that she was upset? Would you ask her about that?
Yeah. Well,
Okay, you have to just limit your answer to the question. Would you ask her about that issue, or why she was upset?
Yeah.
Okay. I'm sorry, I just can't go beyond that. Thank you. Now, how frequently would that occur?
I would say on the weekends when I see her.
Was that primarily when you saw her on the weekends?
Mostly I would see her walking through, going to her place, and I'm sitting on the porch and I see her then.
Now, strike that. While you were there in that apartment complex, and excuse me for getting ahead of myself, do you still live in that apartment complex?
No.
How long have you been gone from that apartment complex? If you don't know, that's fine. Thank you, ma'am. During the occasions that you had to interact with Ms. Boone, how did she treat you?
She was a nice lady.
Overruled.
Nice to me.
Did she ever act uppity?
Objection.
Overruled.
Did she ever treat you in an uppity manner?
What you mean, sir?
Did she ever look down on you as a person?
Oh, no.
Did she ever treat you with disrespect?
No.
I'm going to object. This is character.
Sustained.
May I approach on this, Your Honor?
Yes.
I have a feeling that this witness isn't going to be that big of a deal for them. They're squandering. They can't find anybody. Look at Sarah smiling at her. Thank you, Pearl, for stepping up when nobody else would. They've all abandoned me, Pearl. Once again, I'm a victim. Why won't these people stand behind me? I've had their back many, many times. I've talked to them over and over and over again all about me. Why are they going away? Yeah, what's the point? I'm there with you. What's the point in this? I guess it's a character witness. Quill says they're taking advantage of an elderly lady. I think you're right. That's what I'm saying, Drunky the Bear. She has no friends to call. You always have at least one girlfriend or one guy friend, that you've known for a long time. Y'all might not still hang out all the time. Marriage, kids, all of that's gotten in the way over time. But you have that person that's just known you and they can speak on your behalf. She doesn't even have that. That is very telling. And I can guarantee you she was with her friends the way that she was with her relationship with men. She was bully. She was a bully. They're going to get her on the stand for 5 minutes and then take her down. It's not worth it. Well, they wanted her to be, I will say this. They wanted her to be on Zoom. They did ask that, the defense did. And then they said no. Yeah, Jenny brings up a great point. In her TV interview, she said, those people who drink. She didn't say her name. She didn't, This woman might be thinking she's doing a good thing, I don't know. Yes, Roxy Franklin. Poor woman getting pulled into this mess. Yeah, Kevin Beck, Louise, he's hit or miss. He really is. He's either mean or like, what's the point? That's what his job's been, though, is pulling in all these extra witnesses that we don't have. The state said this morning early that they weren't going to be calling on Marino. Where's my notes? They weren't going to be calling on Detective Lowen. They were not going to call another neighbor. So it's just this lady and Dr. Harper.
I'm sorry, I'm back, Mrs. Walker. In the time that you and Ms. Boone lived together, on occasion, did you see law enforcement arrive at the apartment complex?
A couple of times.
And did you ever get involved in any of their investigation?
No.
Were you ever approached by law enforcement and asked for information, evidence, insight into what might be going on?
No, sir.
Now, in all candor, were there occasions when you believed that Sarah Boone may have been under the influence of alcohol?
No, I can't say.
Did you also observe George Torres during the time that you lived there in the apartment complex?
I didn't see him very much. If we're sitting on the porch, that's the only time.
Did you know Mr. Torres very well?
No.
Was there an incident when you saw Ms. Boone with a black eye?
Yes.
Did you witness a pattern between Ms. Boone and Mr. Torres wherein you observed signs of abuse?
Sustained.
You testified that you saw Ms. Boone on occasion with bruises, other injuries, and a black eye. Is that correct? Is that accurate?
Yes.
And was there any pattern to what you observed in regards to those injuries and bruises that you observed on Ms. Boone?
One time I seen with a black eye and like she had been choked one time.
Okay. Did Ms. Boone complain to you about those marks?
Yes.
Thank you, Your Honor. Nothing further.
Any cross-examination?
Hi, Ms. Walker.
Oh,
Is it fair to say you're not sure when exactly you saw any of those injuries on her, correct?
say that again?
You're not exactly sure when you saw any of those injuries on her, correct?
Once she come past the apartment, I'll be sitting out there because we always sit out there.
Right, but we don't know if this is December or 2018 or anything
I
like that.
can't remember, sir.
Okay. And is it fair to say you have no idea how she got those marks? Is that fair?
Repeat that again.
Do you have any idea how she got those marks?
On the weekends, I see him and her go in.
Okay. But you don't know who, if anybody, put those marks on her, right?
Well,
Just calls for yes or no.
I can tell when they must have had an argument or something. I hear the dogs barking.
Okay. And you're 5 doors down, right? Unit 8, Unit 3?
Yeah.
No other questions?
Any redirect examination?
No, Your Honor. Thank you.
Can this witness be released?
Yes, sir.
Thank you very much, ma'am. Ms. Walker, the deputies are going to come get you and take you out, okay?
You all done?
Yes, ma'am. Thank you so much.
That was just crap, and I think Jay did his job on that one, y'all. And you're 5 doors down. Okay, thank you, ma'am. Have a good day. Ugh. I felt like she was trying a little too hard to help Sarah. Up as a post. She's old. We're gonna be like that one day. I hope I don't get that way when I don't know. I don't want to be taken care of.
Defense ready to call your next witness. Yes.
Yeah, I mean, they just got Jade. Are you jaded? Jaded. Oh, that's sad. I could come up with anything at this point. Jaded. Jade. Jaded. There's a t-shirt. No, y'all had a great idea for a t-shirt. Was it Patty that put it in the comments? Patty, what was your idea for the t-shirt? On the front, you were going to say, shut up, Sarah. And on the back, it was going to say, sit down, Owens. She did her best. I just felt like she was kind of trying to help Sarah a little bit too much. Jay slapped Tracy. She was supposed to say she noticed the pattern on weekends, but she was late to say it because she was confused. You think so, Miss Washington? It could be. All they got. Well, they're waiting on Dr. Harper right now. I hope the state, the state's going to do a rebuttal, Carol, for sure. Whose idea was that for the Jade? You got Jade.
Yes.
Every time it's like, why? Is it just me? Is it just me, or does it happen this often? What's wrong now? Judge, she couldn't find a parking spot. She gonna be just a few more minutes. Can you just put on some music or something for the jury? I mean, since he thinks this is a show, right? Do you have any comedians that could come up and do a skit or anything? I've got all my talent out here on the floor working hard as it is already. Margaret, call the local comedian. If Sarah gets out and goes to visit that lady, Sarah ain't gonna have nothing to do with that lady. If Sarah goes to jail, she's gonna blame that lady. Upside the head.
All right, members of the jury, witness is running a couple minutes late. I think they may be stuck in the security line downstairs. So we're just going to be in a short recess for them to join us this afternoon. Similar instruction that I've given you, please do not conduct any independent investigation or research regarding the person, places, things, or charge involved. And do not have any discussions amongst yourselves or anyone else, and we'll bring you back in as soon as that witness arrives. Thank you again for your patience.
All right.
Yeah, Sarah definitely has no class, no grace, no sophistication. She definitely came out of somewhere.
Y'all can be seated. Thank you. We'll be off the record until Dr. Harper arrives.
And usually, you know, a victim doesn't go around telling everybody they're a victim either. I really wish somebody would zoom in on that whole thing and play around with that, because usually they're too scared to tell people because they're not supposed to tell people, because if they tell people, they're going to get hit again. Sarah told everybody she ran in contact with about her abuse. She probably made sure the woman saw her injuries. I mean, I don't know why she would do it, but I don't think it matters. I think she's just that way. Mark said, paging Dr. Harper. Are you in the loo? Get your case together, defense. Thank you, Miss Elise. I'm going to start calling you Elise. Get it? Elise. Zephyr, where you been? You missed a lot. Oh, you had to go to the doctor today, didn't you? You told me. I forgot already. I'm sorry. Everything I've read this morning, I've already forgotten. You think Twilight Miss says he thinks that Pearl wanted her TV time. I don't know if it was TV time. I think she just seemed kind and trying to help. That was what I got out of it. But you think she just wanted her TV time? It could be. It could be. We do need Damn It Margaret t-shirts. You are absolutely right. I'm just trying to decide. We don't want a picture on it, do we? We just want Damn It Margaret written across the front like I did the Cranick. I think you're right. I think I'd wear that one for show. Oh, I ordered a $5 t-shirt off of Walmart the other day because it had something about true crime on it or something. And it was only $5. So I'm like, oh, I'm going to get it. And maybe it's on sale because, you know, I don't know. And it came in and it's 100% polyester. Ladies, help me out here. Are you sick and tired of all these clothing items that are either so thin, if they're cotton, they're super duper duper thin, or they're stretchable, not really cotton, not really t-shirts? What happened to a good old t-shirt? I want a good old freaking t-shirt. Like you literally have to go. I told my sister, I said, you know what I'm going to do? I'm going to go to Walmart and I'm going to go over to the men's section and I'm going to buy me a regular old t-shirt because you can't find them anymore. I want a good t-shirt with a heavy cotton t-shirt. Food Lines said, oh God. Men's t-shirts. Yeah, they're just made better. And it's freaking polyester. That thing clings like there's nobody's business. I'm like, I don't want a clingy t-shirt. The whole point of a t-shirt is to have it to where you're just like, you know, I did not like it. So there goes $5 down the drain. So the next time you see a $5 t-shirt at Walmart, check into it before you order it. I'm just saying. Everybody does have a Margaret in their life, Sean. Good to see you, Sean. Yeah, you guys, I don't understand. This trial has been delayed so many times because of Owens and his unorganized antics. At the end of this, before they do the sentencing, I'm going to put together a thing, just like I'm going to do Sarah's contradictions, because I was going to wait till she got on the stand and we could do it all. I want to do a Sarah's contradictions, and I want to do an Owens antics video for y'all of all of it. And I don't know if you've seen some of my Daryl Brooks stuff, but it's like back to back to back to back. That's the kind of thing I want to do. It is ridiculous. I'm trusting Noribro. I'm trusting in Juror 13 too. I'm hoping she sees it. Oh, let me go back over here and see if Joel says anything about the courtroom and what's going on. Did y'all make any coffee? I had to get some coffee to wake myself up. Seems like we're just hanging in the courtroom. Girl, we are too. That's what Jules wrote. Dr. Harper isn't here. We wait again. The jurors all giggled when Miss Walker said, "Is that all?" Miss Walker is an elderly woman. The defense called her to establish DV injuries. In my opinion, it didn't help nor hurt Sarah. The witness that's taking the stand is, oh, well, she's already read that. Okay. She got to meet another favorite of hers. Susan Constantine was one of them. And Lawyer Schiff and Jack Rice. I don't know who those people are. So that's it. That's all she's written since we've come back from lunch. Whew. Oops, I meant to change that over. Well, if I'd have known it was going to take this long, I would have had a game for us to play or something. I got an idea. Well, no, I gotta set that up. So I gotta wait on that. I gotta put all the members' names in to do that drawing. I've noticed new t-shirts stain too easy. Do they? Oh, yeah, I guess. I don't know. It's just, I don't wear wife beaters. No. Sorry. Oh, the Life is Good t-shirts are good? Yeah. Abercrombie, super dry, etc. do no good. Do good ones. Yeah. Wit says Target has super comfy men's t-shirts. They're super soft. And then Cookie says Jockey makes the best t-shirts.
We are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State.
Judge, before we began trial, I had indicated that in the past, historically, in these types of cases, there are problems with cameras showing attorneys' laptops. It's been brought to my attention that is going on again. I'm asking the court to order whoever it is who has a camera, whether it be a phone or TV pool camera, that they not do that.
Okay. All right. Members of the gallery, good afternoon. And the TV crews as well. Information that's contained on both parties' laptop, be it the defense or the state, is protected by work product and attorney-client privilege. It's not something that's viewable, not something that should be disseminated, and not something that can be looked at unless there is a knowing, intelligent waiver, and that stuff's going to be put out to the public for consumption. So I'm going to ask you as best as possible not to view, take pictures of, or look at any of the laptops, be it the defense's laptops or the state's laptops, to avoid that. With regard to the camera, if we can, when zooming in on either the defense counsel's table or the state's counsel's table, if we can try to avoid their laptops, I would greatly appreciate you, sir.
Yeah.
and the podium. Thank you.
I didn't even notice it. Did y'all? I don't know what was going on with my computer, but I don't think we missed anything. I thought we were ready to go, and apparently we're not. What is wrong with these people? You've never seen a laptop? I think it's people in the gallery taking pictures. I bet it's people like on Twitter and Instagram and stuff like that. Am I wah-wahing? Summer Cranick, any relation? I notice you don't spell it the same.
All right, we are back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
Dave Kishore on behalf of the state.
Defense.
James Owens on behalf of Ms. Boone.
Tony Henderson for Ms. Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone is standing at counsel's table wearing a dark gray suit and maroon blouse. Let's go ahead and bring in our jury as Dr. Harper is here.
I just want to say something. It's probably not Dr. Harper's fault that she's late. I'm going to say that it's probably Owen screwing that up of what time she was supposed to be here. I would bet money that Owens would be the type of person that would say, you know what? I told her to be here at 1:30, Judge, or I told her to be here at 1:30, 1:15, 1:30. Judge, she's running late. Meanwhile, he's talking to her and he's like, oh, you don't have to be there till like 2 o'clock. I guarantee you, he's that kind of person. I used to know a bunch of salesmen that would be like that. It's horrible.
All rise to resume.
Yes, please keep your arms and legs inside the ride at all times. Face straight ahead at the screen.
State, you recognize our jury.
Yes, Your Honor.
Defense, you recognize our jury. All right, thank you. All could be seated. Again, members of the jury, if you could just raise those hands, confirm you complied with the court's instructions. Record reflect all hands have been raised. All right, defense, at this time, you may call your next witness.
We call Dr. Julie Harper.
So you think the defense is now going to use that whole laptop in front of the camera thing as a way to get around as a mistrial or something?
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth.
I hope she tells us she wants to
Doctor,
speak
good
at 2
afternoon.
o'clock.
Could you state and spell your name for the record for us?
Dr. Julie Harper, Harper.
Thank you. Counselor, you may inquire.
Thank you, Judge. Good afternoon.
Good afternoon.
I think you've already stated your name. Just introduce yourself to the jury.
My name is Dr. Julie Harper, and I'm a licensed psychologist.
Would you tell the jury your educational background?
I have an undergraduate degree from Oberlin College in biopsychology. I have a master's degree from University of Denver. I went on from my master's degree to earn a psychological doctorate. That's called a PsyD. That was also from University of Denver. In completing that education, I specialized in psychological assessment, which means I had extra coursework in that area of learning to administer psychological tests to other people.
Sorry.
I completed an APA-approved internship at Washington State University, which means that I was matched, and that was my site to practice being a psychologist for a full year, and that was between 1999 and 2000. And following that, I turned in my dissertation, which was in the passing of power in couples relationships. I then graduated and started my postdoc work in Pullman, Washington. As part of becoming a psychologist, you have to have over 1,500 to 2,000 hours of supervised work as a psychologist. The person that supervised me was a forensic psychologist. So during that postdoc time, that was my introduction to forensic work while I worked at a community mental health center.
Dr. Harper, how long have you been licensed?
I was first licensed in Washington State in 2002, so 22 years.
What type of position have you held as a psychologist?
Well, I was rehired at my internship site, so I worked at Washington State University College Counseling Center. I also worked 2 times at a community mental health center. The first time was in Pullman, Washington, and that was during the period of time where I was getting my postdoc hours completed, and then I stayed on after licensure. I also worked in Florida. When I came to Florida in 2005, I took a position in the Fort Walton Beach area at Bridgeway Center, which is the community mental health center. And while working there, I completed a variety of psychological assessments. I was directing the testing program. I also began working doing the Department of Juvenile Justice contract work for evaluating adolescents that had gotten into legal trouble and needed an assessment for consideration of program placement. I worked in that community mental health setting doing clinical assessments and the DJJ contract and Social Security evaluations, and continued that until about 2010. In 2010, I opened my own private practice, which is Northwest Florida Psychological Services. And in the beginning of the practice, it was a combined clinical and forensic practice, meaning that I spent a majority of time doing psychological assessments to answer questions from physicians about things like ADHD, depression, to make treatment recommendations. I had the therapy patients, and I also did, again, Social Security disability evaluations, so numerous kinds of assessments. And then over time, I began doing more and more forensic work, including receiving appointments from judges to do competency to stand trial evaluations, sanity at the time of the offense evaluations for Circuit 1 in Florida. And I continued to do the Department of Juvenile Justice contract briefly, but then that it came up for bid and I discontinued that contract. What I did is I slowly reduced my clinical practice, because when you do forensic psychology, it means you have to travel. Your individuals that you're seeing are not usually out in the community. A lot of times you have to see them in jail. So it's hard to maintain a therapy practice, and I scaled that back over time. Eventually, my practice became entirely forensic. And then in 2017, I took a job with the state of Georgia to be an evaluator full-time. I was working doing competency to stand trial and sanity at the time of the offense evaluations, and then assisting with risk assessments in the inpatient setting. I did that until 2021. At that time, my private practice was just it quieted down, of course, from COVID, and I was not in full-time practice. So I wished to return to full-time practice with my own company, and I did that in May of 2021. And since then, obviously the courts are busy again. We're all recovering from the COVID era and back to full-time practice.
Now, where do you live?
I live in Okaloosa County, and that is in the panhandle of Florida.
And is that where your practice is currently?
Yes.
All right. Is it fair to say you travel the state to?
Bless you.
Is it fair to say you travel the state to do assessments or evaluations?
That's correct. I travel to a lot of cities throughout Florida, as far south as like Miami, and then of course working along.
Is it fair to say that you testify in various counties throughout the state?
Yes.
And I know that yesterday you were set to testify in Bay County, Panama City.
That's correct. I was testifying yesterday in a death penalty case in Bay County.
All right. And when you finished, you drove here?
Yes, I did.
My understanding is you got here after midnight.
Yes.
What other counties have you testified in?
Well, I've testified here in Orange County, in Miami-Dade, in Duval. It might be hard for me to list everywhere. Alachua, Escambia, Santa Rosa County, Walton County, Bay County, Washington.
So just so the jury understands, the nature of practice is you have to travel throughout the state.
Well, I do work in cases where the person is at risk of, succumbing to the death penalty. And so those cases require repeated evaluations in different vicinities. And so I have been, traveling to work on murder cases. There are psychologists, I suppose, that do forensic work that might just confine their work to one circuit or stay, but I actually broadly travel.
You said that your practice is now entirely forensic?
That's correct.
What you said? And you've testified about what kind of forensic work you do?
Yes. So as a forensic psychologist, sometimes I am tasked with testifying about something very specific. So for instance, a person's ability to stand trial if they're knowledgeable and can go forward with their trial process. I've testified about a person's sanity at the time of the offense, meaning if they had a mental health condition that met the statute as to not being sane at the time of the offense. I've testified in sentencing here. Been an expert witness for Department of Children and Families. I've testified in vocational rehabilitation hearings as their expert, in what's called social investigation. That's what they used to call custody evaluations. So in numerous capacities.
And would it be fair to say that a lot of times you're appointed by the court to provide the service that you provide and you're paid by the state?
That's correct.
What percentage of your work is where you're paid by the government to do the work?
I would say that the majority of my work comes through with that court-appointed funding. Percentage-wise, probably about 90%.
Okay. I realize you testify on occasion by the state, but majority of your time, 90%, 95% of the time, you testify on the behalf of the defense?
Yes, the evaluation's complete and either side can call me for testimony, and the majority of the time I'm called by defense.
And so you make a living by traveling the state, and generally the court system, I think they call it JAC, pays your fees.
So I make a living by performing work as a forensic psychologist, evaluating individuals, most of the time that are incarcerated in a prison or a jail setting, providing consultation to attorneys who might just have questions that would, need a psychological expert to explain something to them. I also do fitness for duty evaluations for law enforcement, pre-employment evaluations for law enforcement and firefighters. So depending on the work that's needed, I do those.
Doctor, how is a forensic psychological evaluation different than a regular psychological evaluation? Can you tell the jury?
Sure. So if any of us went into a psychologist's office and had an evaluation done, it would be most likely for treatment. So things like if you qualify for surgery or you're going to have treatment, maybe you've got a condition that you want therapy for. A psychological assessment is very helpful in identifying a diagnosis and then setting a course for treatment. A forensic psychological evaluation has many of the same procedures, but the aim is really different. The aim would be to answer some kind of legal question that is posed. So as an expert, I might be in the position to provide some education or experiential descriptions of something that a person might be suffering from to people that are going to make a decision. So for instance, if it's a competency evaluation, I would educate the fact finder. In that case, it would be a judge about what is wrong with the person or if they had any deficits at all, or if they were competent to proceed. In a situation like this, a forensic psychological evaluation might be geared more to identifying, again, if there is a mental health condition present in the defendant I'm evaluating, and then to provide a jury with education about what I found in my evaluation.
How many forensic psychological evaluations have you conducted? Estimate.
So just as an estimate, it's clearly more than 4,000. I've been doing forensic psychological evaluations as far back as 2007.
Have you been qualified as an expert to testify in forensic psychologist in court as a forensic psychologist?
I have.
And you said you've testified for the prosecution.
Yes.
And you've testified for the defense.
Yes.
Is there any difference in the work that you do depending on who hires you? Which side?
Absolutely not. A forensic psychological evaluation is an objective assessment of what's going on with the person. So you should be performing the same kinds of procedures in doing the evaluation. It should not matter who's retained you. What you're trying to do is answer a question.
Are there times when you actually do an evaluation and assess an individual, but then you're not actually called to testify?
Yes, many times that's the case. You will provide your feedback to the attorney, and that's up to the attorney to decide if there's anything in there that would be useful to them, or if they're pursuing a certain kind of information for the court, they would choose to call you for testimony.
Dr. Harper, do you recognize Sarah Boone at the defense table with Tony Henderson?
I do.
When did you first get involved with Miss Boone?
It would have been in around June of 2020. It was the first I heard of her case.
And what were you asked to do?
A comprehensive psychological evaluation of Ms. Boone.
And did you do that in Miss Boone's case?
I did.
Okay. Were you given materials to review?
I was.
Is that standard operating procedure?
Yes.
You assess the client individually, one-on-one, and then there are collateral evidence or material that you also consider?
Yes.
Can you tell the jury about that?
Yes. So in forensic work, there are a variety of documents that are usually available in assessing a defendant. In this case, for criminal court, you would see things like witness statements. There might be body cam footage or just more information about the offense itself. Sometimes there's an interrogation video. So you would get kind of the legal description of the offense and the things that have occurred. I also will often get educational records of a person, mental health records, hospital records, things of that nature that would describe their biopsychosocial history to me.
And you were given materials as it relates to Sarah Boone to review?
Yes, I have it.
How many times did you meet with Sarah Boone?
So 9 times.
Can you tell the jury what you did as part of your evaluation of Sarah Boone?
Well, we had clinical forensic interview in which I reviewed her background history, so her early childhood. I also assessed her with assessments, meaning I administered 3 psychological tests to her. I reviewed her prior mental health records, her interrogation video, some prior information about her legal history. So she had been previously arrested. I reviewed that as well. We had an opportunity to review the transcript of her interrogation video. So there were a variety of things that would be considered what I did with her.
Okay. So you considered some medical records?
Yes.
And did you also consider some records from George Torres's records?
I did see his hospital records.
Now, do you consider in doing an assessment and forming any opinions, an individual like Ms. Boone's upbringing in terms of where they grew up and what their family environment was like?
Yes, that's part of gathering their background history, so biopsychosocial information.
And did you consider Ms. Boone's upbringing in forming any opinions?
I did.
Can you tell us a little bit about that?
Yes, so of her history, I found it pertinent that she was raised with.
Roach.
704 is what he said. Yes, with her history. Wonder if they're fixing to open a door here. And the state's just like, Judge, just want to let you know, they open this, we're going there. And Owens will be like, well, Judge, I don't know. Let me check with my boys. See what they want to do. Oh my word. You guys are cracking me up in the chat. I had to stop putting them up because Patty was trying to read the, and I know Patty's not, she's speaking for many. She couldn't read the captions. And I had to leave whatchamacallit because I kept getting a bad feed. So we're now back on court today. The court Cheve. She did she just say Sarah's previous arrest? Did she say that? No, she didn't. I didn't miss it. I mean, I didn't miss it. I missed it. I didn't catch it.
The objection is sustained.
Would you have considered, as part of her family background, whether or not some of her family members had passed away early in her life?
Sustained.
Do you consider the entire family background and history without going into the details of what she said or what you learned from looking at records?
Yes.
I'm sorry?
Yes.
And did you consider her relationship with her mother as part of her psychological development?
Yes.
Now, do you believe that Sarah Boone does have some narcissistic traits?
I do.
She doesn't qualify or meet the criteria for that diagnosis, does she?
I did not diagnose her with that.
Can you elaborate on or explain how you feel that Sarah Boone does have some narcissistic traits?
Well, in meeting with her as part of the evaluation, the narcissistic traits that I identified would have to do with, as she described, being a straight A student. She reiterated about her abilities, and I felt that that was evidence that she had low self-esteem, and her coping mechanism was to identify what made her stand out, and that would be consistent with a narcissistic trait.
Now, I know there's been reference in this case to a manual that all psychologists, all psychiatrists refer to. Do you have that manual with you?
I do.
And what is the name of that manual?
It is the Diagnostic and Statistical Manual of Mental Disorders, the text revision. So it's the DSM-5 text revision.
Now, Dr. Brannon testified earlier today, and there was some evidence relating to when you suffer from narcissism, there's a sense of grandiosity. But is that from this manual and your studies and your experience, where they require excessive admiration and whatnot, that there's a reason for that?
If I'm understanding your question, there's a criterion in narcissistic personality disorder related to that.
What I'm getting to is many times you may have these narcissistic traits, but really you suffer from very low self-esteem.
That's the underpinning of that criterion.
Would you explain that to me?
If I'm allowed to reference the DSM, then I can explain it best.
Just don't read from it. Just
all
if
right.
you need to review, if you need to read a paragraph and then explain it to the jury.
Just read the cliff notes.
So based on the description in the DSM, if a person's self-esteem is very fragile and they have low self-esteem, they may require more outside admiration or even appear more grandiose in their abilities, because at root, they don't feel secure and confident. And so it's what we would call a defense. And so that criterion is actually a way that a person tries to make themselves feel better.
Anything else you want to say about that issue?
Well, you asked me about why I didn't diagnose narcissistic personality disorder. And again, from the DSM,
Are there criteria?
there are criterion for each disorder.
And so when you're assessing someone, they have to meet all those criteria for you to form that opinion that they actually suffer from that disorder?
Well, the first, I guess, issue is, do they have the criterion that are listed? And then the second would be, is there a different mental health disorder that would better explain the criterion that you're seeing? The criterion within the DSM overlap considerably across disorders. And so there are some helpful guidelines within the DSM to remind you of that you may have what's called differential diagnosis. So if you're considering one thing, that you also are directed to look at other things. So that happened in this case, in this instance, that the DSM guided me to also look at other things.
But just for purposes, to make it clear, you did not diagnose her with narcissism, that disorder.
That's correct, because the DSM's description guided me that that would not be an appropriate diagnosis.
Why did you not diagnose Ms. Bing with a personality disorder?
Well, first of all, it has to be a pervasive pattern of distorted relational abilities. So basically, if she is demonstrating in a variety of settings that she has these symptoms. And then secondarily, the diagnosis of post-traumatic stress disorder is listed when you're considering personality disorders. The DSM guides you that if there are personality changes that are associated with the exposure to a trauma, then you should consider post-traumatic stress disorder and not a personality disorder.
Have you diagnosed her with anything, and we'll elaborate on that, but through your assessment, have you diagnosed her with anything?
Yes, so she has a diagnosis of post-traumatic stress disorder. She has symptoms of anxiety that would be consistent with post-traumatic stress disorder. So that is an anxiety disorder.
And you feel like she suffers from post-traumatic stress?
I do.
Now, at the time of this incident, this event, we're talking February 23rd of 2020, you were aware that she did not have much family support.
Yes.
Doctor, why do you administer psychological testing?
Psychological testing allows an objective measurement of what the person's symptoms may be as compared to sort of an average. So if we can see what the average range on a standardized measure would be for any person, if there is an interpretable difference, that gives me clinical information. So it's not just relying on what the person has told me. I've got an objective measurement that I can compare to other people. And then I also administer psychological testing in a forensic evaluation to help assist me in making sure that the person is intending to put in a good effort with me. In some forensic settings, a person may have a reason to present symptoms, like if they're in a custody evaluation, for instance, they might have a reason to minimize symptoms, or they may exaggerate something else. And so assessments as to the person's response to you and if they're validly participating are important.
So there are tests to see if you're faking or malingering or that type of thing?
Right. And so you would call it feigning mental health symptoms when the person is either far exaggerating a symptom they do have, or if they're pretending to have a symptom that they do not actually have.
Now, as it relates to Sarah Boone, what type of psychological testing did you administer?
I administered the inventory of legal knowledge, and that is a test that has to do with whether or not she was validly participating regarding her understanding of the legal process. I also administered the Miller Forensic Assessment of Symptoms test.
Now, explain to the jury what that Miller Forensic Assessment of Symptoms test is.
So that is also a test of feigning to identify if she's validly participating in the evaluation. So if she had endorsed psychological symptoms or psychiatric symptoms that would be unusual or not typical of a valid psychiatric patient.
What were the results of Ms. Boone's test on the Miller Forensic?
She validly participated. There was no indication of any feigning or malingering.
And as far as the inventory of legal knowledge case, what were the results?
Again, she was validly participating, and she did not even come close to the cutoff that would put her in the range of feigning.
Can you tell the jury what the purpose of the clinician administered post-traumatic stress disorder scale is?
Yes. So that would be considered a very useful assessment of post-traumatic stress disorder. It allows me to interview a person about exposure to a traumatic incident and then identify if there's a change in behavior that has occurred as a result of that exposure to trauma.
At the time that you administered that test, did Ms. Boone in fact have post-traumatic stress disorder?
Well,
or tell me the results. Just
yes. So the results would be consistent with a person having post-traumatic stress disorder. I do not diagnose from one test. That wouldn't be appropriate, but it is consistent with the background and the symptoms that I had previously, taken down during my evaluation of her. So the clinical portion, when we go through symptoms, that was consistent with the outcome of that test.
And would this testing, all the testing, help you determine if Ms. Boone had a change in functioning from before the alleged trauma to after the alleged trauma? And I'm referring to the trauma. We're going to talk about what the trauma was, but The trauma was the intimate partner violence?
That's correct.
Okay. But would that testing help to determine if she had a change in functioning from that trauma of the intimate partner violence?
Absolutely.
And did you determine that she did suffer from a trauma as a result of intimate partner violence?
That was my conclusion. Yes, that's my opinion.
Now, in considering all the available information, you don't just rely on what Ms. Boone tells you to
No.
reach your decisions.
I don't. I do interview a person as part of the clinical forensic interview, of course, but I also consider things that are reported, like in their arrest narrative, witness statements, all of the medical records. So there are a variety of sources of information, collecting data points and reviewing those to arrive at a conclusion.
So you did review Ms. Boone's previous diagnoses in her history?
Yes,
Did you consider the previous diagnoses in arriving at your own?
I did. Yes.
What did Ms. Boone, what had she been diagnosed with prior to you getting involved?
Roach.
I'm trying to figure out how she figured all this out. So she looked at the police reports, she looked at her medical records, and then she talked to Sarah. And in those three things, she read the witness reports. Those 4 items is what she came up with for that. Did she read Sarah's jail notes? I think some of you guys noted that here. Her jail letters to the judge. Did she look at anything? Like, I don't know. There's a lot out there that she could have watched a YouTube channel on Sarah. There's a lot of information on Sarah out there that she could have listened to form her opinion. I think she's been given limited opportunity to look at this defendant. And she doesn't care because she'll be gone tomorrow and she gets paid after that. I just don't understand how the courts allow these psychiatrists to get up and do this crap. And how does anything she's going to say here fit with what Dr. Brannon said earlier? She's manipulative. She's bossy. She has issues with authority. I think we could just diagnose her right here and now. With authority. I bet we know more about Sarah Boone than this doctor does. Oh, she has loyalty issues. Wait, no, what do you call that? Controlling. Thank you. Give me another word. I'm writing it all down. Controlling. Flat out freaking mean. Can I write that down? She's fickle. She's fickle. When is Jay going to trump this? In just a minute. He's going to come in there. She's codependent. Codependency? You mean on alcohol, right? Not on any man. Well, I guess she could be a man. Codependency. I got manipulation.
The objection is sustained.
But you would agree, and I think this is a fair question, you would consider prior other experts who may have diagnosed her with something.
So I would definitely consider her mental health records, diagnoses previous clinicians may have arrived at the time when I diagnosed her myself.
Okay, and given the assessment that you did with Sarah Boone, and considering the totality and the time you spent with her and the other records, did you diagnose Sarah Boone with anything?
Yes, so post-traumatic stress disorder. It's my opinion at the time of the offense, she had depression and she had an alcohol use disorder.
All right. I know we've talked about post-traumatic stress disorder. I don't know if I need to ask you anything further. I think the jury probably understands that. Is there anything else you wanted to add about that disorder?
I'm not sure what the jury's already been told about post-traumatic stress disorder, but in Sarah Boone's case specifically, because of enduring, she specifically noted the time that she was stabbed with the knife as being an extremely
Sustained.
You have viewed Have you viewed some exhibits involving her being stabbed?
I think that we have had exhibits in common. I'm not sure what was admitted.
Have you seen the physical scar from Sarah Boone being stabbed in the back of the leg?
Yes, I've seen her scar.
Overruled.
Just generally, without getting specific, I think I've explained post-traumatic stress, but if there's something else the jury you believe the jury needs to know, but it's a sort of trauma that occurs as a result of one or more events.
Traumatic stress disorder is the psychological after effect of being exposed to a very significant stressor or cumulative stressors that make the person's behavior, thinking, and mood change. And so the change can include things like the person becomes hypervigilant, is easily startled, has trouble thinking, has trouble sleeping. So their body is in a state of agitation. It can also include changes in mood that would include irritability, difficulty relating to others, and that they might be resistant to trust easily. So those are all features.
They have trouble sleeping sometimes.
Yes.
Not
Sleep
Sarah.
deprivation is a real issue.
It's associated with things like nightmares and having trouble settling.
Not on February the
Now, you mentioned
24th,
that you had
2020.
diagnosed her with depression. Can you just give us a general understanding for the jury of depression?
So the persistent sad mood, including feelings of hopelessness, helplessness, having difficulty concentrating, sleep problems, changes in appetite, those would be typical of depression.
And Sarah Boone suffered from that?
Near the time of the offense, yes.
All right, can you explain to the jury alcohol use disorder? That's a fairly new name. That's 5 or 6 years ago. The manual came up with a different name.
It did, right. And so that would be, in layman's terms, you might call that alcoholism. It's a tendency to drink too much and then have some kind of consequence in your life as a result of your substance use.
And alcoholism can be depending on how much you drink and then how often you drink.
That's right.
All that is something that you would consider in diagnosing?
Yes.
The many people who suffer from alcohol use disorder, I don't know how to put this, are they in denial?
I would say that that is one of the stages of alcohol use disorder and amenability to treatment. So in denial, it's because you do not want to acknowledge that there are consequences from your use, because in doing that, you might have to reduce how much you're using. So to deny means that you feel that you can continue your use without having to change that. So you want to maintain the access to the substance.
You don't have a problem.
That's right.
What is the difference between traits and a diagnosis?
Well, we all have personalities. And so you're going to have coping mechanisms that include personality styles. So for instance, even though you might not be diagnosable as something, there are times when if you're upset, hurt, frustrated, you have a mood state that's unpleasant, you're going to deal with that by using some kind of coping mechanism. So traits of personality disorders might be present in the way that you deal with inner pain, things that you don't like, feeling. So some people, for instance, if they feel uncomfortable, they may cling too much or become excessively bonded to try to escape a feeling that they don't like. And that might be a dependent personality trait. It doesn't necessarily mean that they have a personality disorder, because that would have to be pervasive across like all the environments. But when stressed or upset or not feeling good, you're going to use some kind of coping mechanism, and that might be one of the criterion, for instance, of the personality disorder. You would call that a trait.
And is it your understanding that this trauma that one suffers from repeat domestic violence can cause one to be considered suffering from the syndrome, we call it battered spouse or battered woman syndrome?
Yes, so the diagnosable condition would be PTSD, or post-traumatic stress disorder. That's how a clinician would label the response to trauma. The pattern between partners, the person's coping mechanism because of that trauma, that would be what's considered battered spouse or battered partner syndrome.
And you're aware that that concept of being traumatized by the battered spouse syndrome or the post-traumatic stress is relevant to a self-defense case?
Yes.
In criminal context.
Yes, I understand that.
Could you tell us a little bit about that?
Well, under the battered spouse syndrome, the person would experience a trauma or a situation in which they feared harm. And based on that fear of harm, they would react in a certain way that might not be understandable to other people. So their fear is based on the pattern of behavior between them and their partner. That might not be the case for another set of people.
Now, I know that Dr. Lenore Walker is the one who first uncovered this syndrome back in the 70s.
Her research study generated the term. She was interested in why battered women specifically at first, that was what was studied, didn't leave their partner because, of course, they're experiencing traumatic events, risks to their life, but then they didn't leave. So she undertook the original research study on that.
Just briefly touch on, because I know Dr. Brannon has this, there was a 3 stages that Dr. Walker developed for that syndrome.
I think you're referring to phases that a person may go through, or the cycle of the relationship. That includes the tension building phase, in which there is the first instance that tension is building within the partner. There might be a change in tone, a signaling that there's a difference in agitation. The second is the true battering event. So something has happened between the partners that's violent in nature. And then third, there's the honeymoon phase, which is to keep the relationship intact. The batterer would engage in what's like called honeymoon behaviors, like trying to repair the relationship, apologize, essentially keep the victim from departing from the relationship. So those are 3 phases.
And is it fair to say that psychologically the abuser, does alcohol often involved in the abuse?
Yes.
And as far as the victim that's getting abused, you say it's a cycle, is the victim, when they go through that last stage, the honeymoon stage, are they thinking, okay, it's going to be better?
Yes, the hopefulness in that, trying to believe that the behavior has changed, that they're not going to be abused again, the hopefulness to maintain the relationship, to forgive. That's part of that last stage, phase 3, is maintaining the relationship.
I don't think I've asked this. Why would someone who has been exposed to intimate partner violence perceive the likelihood of a new violent event about to appear? Why would they perceive the likelihood of that violence differently than, say, a normal person?
Well, it speaks to the pattern. So any relationship will have its own special pattern, that you have things that only your partner knows about you, or certain looks that you give that mean something, and you learn that over time. So over a period of incidents, basically, the victim begins to perceive cues that would signal impending danger. Those cues could be really subtle, just a change in tone or some small behavior that might not mean much to another person, but it has preceded other violent acts. So for instance, if your husband decides that he is not going out that night, he might put on different clothes to stay home. And that could be a signal, like abuse and violence has occurred in his stay-at-home clothes. For instance, that might not mean much to another person because, again, it's specific to that dyad. Those two people know those patterns. So the victim may perceive a small or subtle change in their partner as a cue because they've become hypervigilant. The body knows when it's experienced a threat to itself, and it will take note. We record memories differently when we're at risk. So these subtle cues become very well memorized by somebody who's being victimized.
Now, on this, and battered spouse syndrome is a subset of post-traumatic stress disorder, which you've diagnosed Sarah Boone with. When those personality changes occur and they persist after an individual has been exposed to this extreme stress, is that when the diagnosis occurs?
The changes would be as a result of the pattern. The person experiences a change like in their sleeping, in their hypervigilance. That's when you can diagnose it. You can have a trauma or an experience of a scary incident, but it doesn't mean that you will absolutely have post-traumatic stress disorder. You have to have those reactive symptoms that would suggest that it's present.
In your opinion, and I know you've gone over this event with Sarah Boone, this February 23rd, 2020 event, it is your opinion that she was suffering from battered spouse syndrome at the time of that event?
Yes, she had the patterns ingrained in her behavior that would be typical of a victim who's responding to traumatic events in a predictable way. So that would fit that.
And it's fair to say that because of the intimate partner and the prior violence, that you would have a heightened sense of when danger was about to occur.
Yes.
When a threat was about to occur.
Yes.
A threat of danger.
That's right.
Now I want to talk about placating the abuser. A victim placating an abuser. Are there predictive cues which an abuser may exhibit to a victim that result in a high level of anxiety arousal, in which the battered woman may attempt to reduce through several different means to delay the beating? Can you explain that?
Yes. So the phase of the relationship that starts with that tension building, that is a jumping off point potentially. So if you can stop the escalation, you might stay in phase one for a period of time. Phase one being that tension building phase and trying to reduce it and not allow it to escalate. So placating the abuser might include distraction. It could include substance use. It could include a change of scenery. There are a lot of things that a partner will learn to do so that they don't have the escalation into an abusive event, if possible. It doesn't always stop it.
Now, in reviewing all of the data, all the reports, medical records, and whatever reports you considered, videotape that you may have watched, as it relates specifically to Sarah Boone, are her words her power?
Her words, I would say, are the weapon that she has.
Explain that to the jury.
In reviewing the available videos that I had to review, you would see that when Ms. Boone is very stressed, when she's experiencing a high level of anxiety, she becomes short in her tone. You can hear that in her voice. There's a strain, sharper words come out. I think that that is the way that she would try to respond to Mr. Torres, you can hear that sharpness in her voice when she's very stressed out.
Now, would you agree that victims may exhibit a range of behaviors when they're suffering from intimate partner violence?
Yes.
Self-isolation?
Yes.
Suicidal thoughts?
Yes.
Substance abuse?
Yes.
And there are often physical signs of injury such as bruising?
That's correct.
Chronic fatigue?
Yes.
Learned helplessness?
Yes.
Can you tell I know Dr. Brannon spoke on it, but could you tell us a little bit about that?
So learned helplessness is when you start to form the opinion that nothing's going to make any difference. It comes originally from an animal study in which dogs were shocked. And the research study indicated that even when dogs were given an opportunity to escape the environment in which they were being shocked, if they were shocked enough, they just stopped trying to escape. So even though they had an opportunity to do so, they did not do that. That's called learned helplessness. It's the idea or belief that what your actions are going to do are not going to make a difference. So don't try.
What are intrusive memories?
Intrusive memories are an element of post-traumatic stress disorder in which you don't want to be thinking of a traumatic event, but it intrudes on something else you're trying to do. Like maybe you're folding socks or something like that, just doing something mindless, and that's what takes over your thought process. It's not something that you're trying to think about. We could plan what we're thinking about, or sometimes if you're just having this intrusive experience, that's not what you were intending to think about at all.
Is that one of the conditions that someone may suffer when they have this syndrome of battered spouse?
Yes.
I know there can be triggers that bring on these memories. Am I correct?
That's correct.
Are there also symptoms of this syndrome where like in the alcoholism, where you have denial that you're in the middle of this cycle?
Well, as part of the relationship, there's an element of pleasure. Like you have early on in the relationship something that binds you together. So you're remembering that, you're hoping for that, even though the repeated cycle is going through the phases 1, 2, and 3, you keep hoping for elements of that honeymoon phase, wishing that it was better. So it is like denial. You're imagining the way it used to be. You have a recollection of that person showing you positive behaviors, and you're hoping for that. I also think it is typical for victims to not reveal to other people that the abuse is going on. And it seems like denial. In other words, your coworkers ask you, like, are you okay? Did something happen to you? You're not likely to disclose that. That looks a lot like denial. It is a denial in public of some of the private issues that you're having in your relationship. And that's because it's embarrassing. It's revealing a loss of control to other people. It's revealing that things aren't perfect. You might even get feedback that you should leave your partner, and that's unwanted because you're already having that, concern in your own mind about it. And so, it seems like denial on the outside to hide it.
Would you agree many people who suffer from this, they're minimizing what is happening to them?
Yes.
And they're numbing their emotions to it.
Well, to stay present and keep that relationship, it's very difficult for a lot of people because they're experiencing physical and emotional harm. So they want to numb it, because numbing it means that you can keep that relatedness no matter how bad it's getting.
Does some people with this syndrome disassociate?
Relevance.
Approach.
Disassociate. Y'all, the first thing I heard her say that made me jump up was how she wouldn't want to tell people around her, or she wouldn't want outsiders to know what was going on, which is like, oh my gosh, that's all she did was run around the apartment complex letting everybody know she was telling everybody that she was abused. Look at my bruise. Look what, oh, he hits me.
Objection to relevance is overruled.
Do you agree that battered women often develop the defense mechanism of being able to psychologically detach from their body during a traumatic experience?
Some people do experience that.
Detachment, really?
I'm just going to list some of the symptoms that you find in battered spouse women, and just to see if you agree with these. We talked about intrusive memories and flashbacks of the past traumatic events. You agree with that?
Yes.
The severe anxiety and hypervigilance.
Yes.
The panic attacks.
That is sometimes present. It depends on how the person experiences anxiety, but some do have panic attacks.
Very low self-esteem.
Yes.
Poor body image.
Sometimes.
Feeling that they have no control.
Yes.
Sexual dysfunction.
It can be, particularly if the trauma includes sexualized attacks.
Short-term memory problems and confusion.
Yes, that's part of PTSD sometimes.
And they can actually have physical health problems from the chronic stress and physical violence.
That's correct.
Fear.
Yes.
Constant fear.
That's correct.
Now, the abusive partner, the abuser, part of the abuse would be hitting, kicking, punching, choking, burning, and biting.
Approach.
So now he's going to say, oh, yeah, all these people do this. They punch, they bite, they put people in suitcases. Yeah. Oh, exactly. That's exactly what she has. Oh my gosh. Doctor, thank you so much for coming in. What would we do without you? I hope the prosecutor's ready too. I think he is. This isn't his first rodeo on this, I'm sure. I thought lawyers are supposed to ask questions. I don't think Owens was held as a baby. No, I don't. I don't like it when people blame their parents. We don't know their parents. I did see somebody emailed me at her mom's obituary, and somebody had mailed it to me before, just this last couple of days. I've had it for a while. I just didn't see any point in putting it out there because I just didn't think it was relevant. I don't know if I still think it's relevant because all we have is Sarah saying her mother. Like, what did her mother do with it to her? What did she like? Shouldn't we be hearing all the things that have happened to Sarah over her lifetime that have made her become this way? Because all I'm hearing is that she's the way she is because of George. Well, you don't just become that way over one person. Like, it builds up over time. So how is she relating the way George makes her feel to the way she felt when she was around her parents? Like, there's something not going on right here. There's something missing. I want to know, what is it about her mother that, don't just leave it there and not talk about it. You said it. You said her mother. What's the relationship? Okay. And how did you get this from your multiple witnesses that you spoke with? Who told you about her and her mother's relationship? Oh, okay. Sarah did. Okay. And who else did you speak with? Oh, okay. I'm sorry. Nobody else? Okay. Did she say she spoke with her brother? Who mentioned her brother earlier?
You may proceed, sir.
All right, I'm asking about common things that occur by the abusive partner towards the victim that create this intimate partner violence or create this syndrome in the woman. Hitting.
Yes, that could be an overt act.
Kicking.
Yes.
Punching.
Yes.
Choking.
Yes.
Burning.
Yes.
Using weapons to hurt you.
Yes.
A knife.
Correct.
Curtain rod.
Yes.
Threatening to hurt you, your children, or your pets.
Yes.
Belittling and humiliating you.
That's correct.
Taking your car keys.
That would be considered a form of control. So yes.
Controlling your money.
Yes.
Control where you go and who you see.
Correct.
And who you can talk to.
That's right.
Force you to have sex when you don't want to.
Yes.
Stalking you,
Yes.
slapping you,
Correct.
you agree victims that suffer from this abuse experience feelings of anger,
Yes, that can be in some of the phases. So,
sadness,
yes.
hopelessness,
Yes.
worthlessness,
Correct.
intense feelings of fear.
Yes.
Abusers have a tendency to have low self-esteem themselves.
Overruled.
Abusers.
Overruled.
The abuser can have low self-esteem himself,
Yes.
have a desire for power and control,
Correct.
have a tendency to use alcohol or drugs.
Yes.
Abusers oftentimes have temper,
That's correct.
become jealous easily,
Yes.
very possessive.
Can be.
Is that exactly what you wanted me to say, Mr. Owens? Did I say it right? Okay, well, while I'm on
The
my way out,
victims
let me
can
hand you my
suffer from
invoice.
severe psychological distress.
That's correct.
Is that what Sarah Boone suffered from?
Yes.
Yes, sir.
What now?
Dr. Harper, I'm showing you Exhibit 14, this is 5 photographs. Did you watch the video of the TV, the Baton TV?
I did.
You considered that in your analysis and your diagnosis?
Yes, I did.
I'm going to show you some pictures. Exhibit 12. I believe she's testified that this is where the curve line. Are you familiar with that?
Yes.
Exhibit 11. Are you familiar with this photograph over here?
Yes.
Exhibit 10, which is her arm. Are you familiar with that photograph?
Yes.
Exhibit 9, picture of the bloody knee. Exhibit 8, picture of her black eye.
Yes, I've seen these.
Picture, exhibit 7, picture of her, Sarah's lips and eyebrow.
Yes.
And this is a composite exhibit 6, which is of the stab to her leg. Are you familiar with those?
Yes.
And I don't know if you've seen this exhibit 5 is where she spilled some soup as a result of his behavior.
I'm not sure if I've seen this photo, but I've seen a medical record associated with that.
Of that burn.
Medical records don't show anything. What she got the cold, a cold or the flu once a year?
Looks like exhibit 3. She was slapped.
Yes.
2. Picture of bruising in this book.
Yes.
Did you consider all those photographs informing your opinions that you've expressed here today as it relates to Sarah Boone?
Yes, under the substantiation that she has indeed experienced past instances of intimate partner violence against her.
Is it fair to say that it takes time, a number of times, to visit with someone like this to build trust?
Yes, traumatized people are slow to disclose information. You have to build rapport. You have to make sure that they experience you discussing other things without an emotional reaction. They feel easily judged, as we mentioned, have defensive denial, things like that. So you need to build good rapport in doing an assessment with somebody that's experienced trauma.
So a lot of times they're very slow to open up and tell you about the abuse.
That is correct.
And they'll actually often lie about it.
Deny it, yes, and just say that that's not the issue or they're fine. So oftentimes I'll have an evaluation request come from an attorney who's having difficulty interacting with their client, and then ultimately it's a result of trauma.
Now, I know that you viewed everything, and I know you've seen her 9 times. Is there did you feel like you had enough time? Was 9 visits enough time for you to feel like you had enough time and information to form the opinions that you've expressed here today and give it to this?
Yes.
That's all the questions I have.
Any cross-examination?
Yes, sir. Good afternoon, Dr. Harper.
Good afternoon.
So you have done some evaluation work on battered spouse syndrome for a prosecution in the past?
No.
All right. Have you done insanity evaluations for the prosecution in the past?
I have been called to testify about that.
So you understand when the government obtains a court order for their expert to come in and do an evaluation, it's for one evaluation, correct?
I believe that you're saying that the government can retain their own expert, yes.
No, man, what I'm talking about is you just went through that you had 9 visits with Ms. Boone, correct?
I did, yes.
And that was over the course of 8 different days because 2 of those visits were morning and afternoon sessions, correct?
That's right.
And what we are trying to help you have the jury understand is that when you get hired by the government and the court gives you an order to go evaluate somebody, you get one crack at the apple. Is that your understanding from your past work working for the government?
No, that's not always correct. There are many instances in competency evaluations where evaluators will request additional visits if they cannot determine their opinion on the first visit.
All right. Specifically, when it comes to an affirmative defense, such as battered spouse evidence and insanity, what is your understanding and your expertise?
What is my understanding of the issue? Oh,
Judge, the question.
Legal objection.
Objection.
Legal grounds.
He asked a question about battered spouse and
Approach.
insanity.
James Owens can't get out his legal discussion on it. Maybe they should just switch places. Maybe Owens should take the stand and she just ask him if he's been testifying the whole case. I swear, SR, you are so right on that. Oh my goodness. This whole trial has been written by James Owens, even the timetable on it.
Objection sustained.
When it comes to an affirmative defense such as battered spouse syndrome being used for self-defense or, not and, insanity, it requires a court order for the state to go have an evaluator go, right?
yes.
All right. Now, what are the agreed upon criteria for battered spouse syndrome?
Well, you would evaluate if the person is indeed suffering from a behavioral response like a mental disorder. So first of all, has the person demonstrated that they've got a behavioral change? And is it in response to a violent act? Do they perceive threat where they've been exposed in the past? So pattern of violence that has repeated.
Does control over another person in an intimate relationship have anything to do with it?
Yes, it can.
Does isolation have anything to do with it?
Yes.
And by control, I mean controlling who you go see, who you hang out with, so on and so forth?
Yes.
And could it involve controlling personal items of the other person as well?
Yes, it can.
So that's what I'm asking. Like in the DSM-5 TR, I believe you pulled up narcissistic personality disorder.
Yes.
And so when you do that, it pulls up and it says there's 9 criteria and 5 of those criteria must be met to make a diagnosis for narcissistic personality disorder, correct?
That's right.
Now, battered spouse syndrome is not recognized by the DSM-5 TR, correct?
No, it's not a diagnosis. You wouldn't use it as a diagnosis.
And what I'm asking is, even though we haven't written it down in the Diagnostic Statistical Manual, and I mean the, like the Ohio State University or something, is it written down anywhere? Can one psychologist or psychiatrist rely upon a recipe or a list of criteria that everyone else would be using in your field as well?
There is no standardized approach you must follow. In other words, sometimes if we have a statute, for instance, it would identify what we must investigate. It doesn't exist like that. There's no statute directing it.
And there's nothing written down anywhere that says, of these 9 criteria, these things must exist. Controlling your partner, isolating your partner, beating your partner, so on and so forth, correct?
That's right.
All right. Now, this kind of abuse can come in the form of emotional or mental abuse outside completely of physical or sexual abuse, correct?
So that is a component. You can have extreme mental abuse occur of a person, yes.
And if that person responds to that environmental stimuli of whatever it is the partner is saying or doing to them, they may internally view that as traumatic.
They could.
Or they may not.
That's right.
It's entirely possible for 2 people to be in a 3.5-year relationship that has physical violence and neither one of them feel traumatized by that. Is that correct?
That's right. If they have enough supportive or positive experiences that would negate that ratio, so of positive to negative, they may feel okay.
And a man can be subjected to this sort of trauma, whether it be physical, emotional, or sexual, by an intimate partner as well, correct?
That's right.
And it's basically it's unique to each relationship, right?
That is right.
But trauma is in the eye of the beholder. Is that fair? Whether a negative experience traumatizes somebody is going to be in the eye of the person who experienced that stimuli, correct?
I only partially agree with you. It's a complicated answer because some of the manifestations of trauma are behavioral. So for instance, when I evaluate veterans who have returned and they may not know that they've been traumatized, their bodily responses that include like difficulty concentrating, they can't sleep, they're hypervigilant. The PTSD diagnosis encompasses outward manifestations. So even though they don't acknowledge trauma, you can still identify it as a clinician.
But still, somebody like a homicide detective or a homicide prosecutor can go to scenes where there are dead bodies, go to autopsies where there are dead bodies, and not walk away with any trauma, correct? Whereas somebody else might.
Right. The environmental, I guess, cues for that person, and also working with law enforcement, they become seasoned to micro traumas. So almost every police officer can remember their first dead body they've seen. So it's in their memory. And then they become accustomed to seeing gruesome scenes. They have an increased tolerance over time because it's part of their job. It may not be part of their intimate relationship that they have with someone else.
Now, you brought up veterans. Is something common with PTSD with veterans, something like firecrackers may set them off because it reminds them of acts of war?
That's right.
You're not suggesting to the jury today that if somebody who returns with PTSD from service and hears firecrackers is justified in going outside and just shooting bullets everywhere, correct?
No, that's not what I said.
I know you did.
Okay.
What this battered spouse syndrome evidence is helpful for is not that subjective mindset, but rather helping to explain the objective circumstances that are presented to somebody and how it might be different from somebody with those experiences. They may view something objectively different.
I partially disagree with your question because I would say that there are incidents or actual events between partners that would be a factual thing, something has happened. And then the person subjectively experiences that as, intrusive or controlling or traumatic. So that is the person's felt or subjective experience. The objective part is what happened.
But again, as a forensic psychologist, you're familiar with the justified use of force instruction, correct?
I'm not a lawyer though, so I'm aware of it, but I cannot debate fine points of that with you. I'm sorry.
I'm just helping. I'm trying to understand what you said before, because there's a subjective component, whether or not a person believes subjectively that they need to use some sort of force, deadly or non-deadly. You agree with that, correct?
I do.
And then there's also a second component that it's objectively reasonable to the ordinary person to use force, correct?
I understand what you're saying, yes.
And what I believe I heard you mention earlier about battered spouse syndrome was originally it was meant to help understand why people stay in these relationships.
Originally, yes.
Because it may not just be intuitive to somebody who doesn't understand these things, why somebody who is abused time and time and time again would remain in that relationship, correct?
That's right.
And again, and I know you're not a lawyer, but if the law has evolved about retreat and not having to retreat and so on and so forth, that kind of changes some of the lens of this, correct?
Judge, I'm going to object.
Approach. Question withdrawn. You may proceed.
All right. So you would agree that hypothetically, if somebody is running down their partner, saying negative things about them, telling them they're unattractive, telling them things that would potentially hurt their feelings, that could be an element of control of a verbally abusive relationship.
It could.
Okay. Propping one up, hypothetically saying, I'm the best thing that has ever happened to you. You'll never do better than me. Is that a potential component of the control that one in an abusive relationship might exert over an intimate partner?
Yes, to try to not encourage their partner to leave them. Yeah.
Considering gifts, hypothetically, that one partner has given to another partner, but considering it still to be your property because you gave it to them, is that a form of a potential exertion of control over an intimate partner when you give somebody hypothetically a bike, but still consider it your own bike?
I mean, I don't think that's strong evidence of that. I think that it does happen in relationships and people do that in general, but I wouldn't say that's like really specific to this.
How about hypothetically exerting control over your intimate partner's identification papers, such as a birth certificate?
So that can happen. People will hide things that are required for work. For instance, like your driver's license or things like that.
Now I'm asking you no questions. If Mr. Owens would like you to elaborate further, he's going to have that opportunity in a little bit. Okay. Hypothetically, if one partner destroys another partner's belongings, is that a potential example of exerting control in a relationship?
Yes.
Hypothetically, is threatening to or actually using legal process as a threat against your intimate partner in a potential indicia of controlling your partner? For instance, X, Y, or Z, or I'm going to get you arrested.
Yes, I would agree that happens.
Now, I assume you would agree that this cycle of violence that we've described, the tension building, the blow up, and then the honeymoon phase, you would agree that just one of those cycles could be enough to give somebody a traumatic experience if they took it as a traumatic experience.
Yes.
The defendant described her first date with Mr. Torres to you, did she not?
She did.
And at the time of this first date, they had obviously just met that night at a bar, correct?
Right.
They were not financially intertwined, correct?
That's right.
They shared no children in common.
That's right.
They did not live together.
Correct.
And after this description that she provided you, which included him smashing her phone, correct?
Yes.
Hitting her, first time she'd ever been hit in her life, correct?
Yes.
And making her crouch in like a fetal position on the porch for several hours to the point where it hurt her back, correct?
Yes.
Threatened to sodomize her.
Correct.
And she described that she was all bruised up, correct?
Yes.
After that, this is the first time she had ever met him, correct?
I believe so. Yes.
There was a second date, correct?
Yes.
Despite not having any of that intertwinement that we went through prior to this description, correct?
That's right.
Now, it is possible under what we've discussed, right? Just that quick one date can be that buildup of tension and blow up, correct?
Yes.
But it's different hypothetically than saying a spouse who is financially dependent on his or her other spouse in a 20-year marriage with a house full of kids than a first date, correct? You would agree in severity, in the intertwinement, there's a difference.
There's a difference in intertwinement. The pattern can be exactly the same.
Now, of course, there are many different reasons why somebody will stay in a relationship that, when perceived from the outside, others would say is abusive, correct?
That's right.
The defendant described that she felt like she was making Mr. Torres a better person, correct?
That's right.
A better father, correct?
Right.
A better ex-husband.
With phone calls. Yes.
And she would tell him to call his children,
That's right.
make sure that he sent them Christmas gifts,
Yes.
and make sure he sent his ex-wife money when she asked, correct?
Yes.
So you would agree those are indicia, or indicators, sorry.
Understand.
I know you know. That perhaps she wasn't necessarily financially dependent on Mr. Torres, correct? I'm not saying conclusion, but those are indicators. If you're saying, please spend your money elsewhere, that I don't need your money, correct?
No, because even if there was money that was needed by Ms. Boone, her tendency to put the needs of her partner before her would direct her to do exactly that. Like make him better, make him have the availability to visit his children, send them presents, even if she's the one that needed the money.
And in her perspective, Mr. Torres needed her to do this to make him a better person, correct?
I believe that, yes.
How many years of her adult life did she describe working?
I don't think she gave it a specific quantity. We just went through a variety of her jobs that she had in the past.
And, you know, she was low 40s when she met you 4
Yes.
years ago?
That's right.
So she had been 18 for probably about 24 years. Did she give you a 24, right? 24 plus 18, 42?
You said for 24 years. And that's why I was confused. You can't be 18 for 24 years, but 24 years ago, I would agree.
Did her work history kind of flesh out to be 24 years is what I'm asking?
I'm not certain.
And at the time, in the apartment in 2020, she had not been working, correct?
That's right.
And had not been working for some time.
That's right.
And what she was doing was living off of the settlement that she had been bought out of with her husband, was lump sum plus $1,000 a month in alimony and $100 a month in child support, correct?
Yes.
It was Mr. Torres who would work, correct?
He worked at Ace Hardware, I think.
When he would show up.
Right.
Sometimes he didn't show up, is what she indicated, correct?
Yes.
Because of his drinking problems.
Yes.
Did she describe to you, well, let me strike that. She did describe to you one instance, at least, where violence occurred in front of her child, correct?
Yes.
and that her child had gone to school and reported it, correct?
Yes,
And you understand as a forensic psychologist that teachers are mandatory reporters, correct?
that's right.
Did you review any DCF records in this case?
No, I didn't receive any DCF records.
Did Miss Boone ever indicate to you at any point in time she became too afraid to let Lucas come over to the house?
Yes, there were times where she would ask Mr. Boone, so Brian Boone, to not bring him there.
And Mr. Boone was aware of this because she would say things like that, correct?
Yes,
And at different times, she told you that she would go over to Mr. Boone's house to escape the violence of Mr. Torres.
that's right.
And February 24th of 2020, the child was scheduled to be picked up by Miss Boone, correct?
That's right.
Despite everything that she was aware of and what Mr. Brian Boone was aware of, correct?
Right.
And you saw in her police interview that she swore on the life of her son that she was telling them the truth, correct?
Yes.
Yes.
Object.
Approach.
That's already in evidence. What's the difference? It's already out there. So, did you guys catch on with the whole she didn't know crap about this woman's work history? She really hadn't gotten into that portion of her life, which in most people's lives a lot.
I'll rephrase it. She swore on her son's life that it was not intentional that she ended up killing Mr. Torres, correct?
That
I object.
Approach.
Really? She did, though. Oh, they had that part redacted, didn't she? They redacted that portion of the interview. I think that's why they're saying that. Every objection, I know. Every objection, Mary Jane. And if the judge doesn't say approach, Owens will say approach. He don't want to talk about anything outside within the jury hearing. Seems like she just gave Sarah a bunch of tests, but didn't really delve much into it. How could she have? She didn't have any time to.
Objection sustained. Question is stricken. Members of the jury, questions are not evidence, and you're not to give them any weight whatsoever. Mr. J, you may proceed.
She's quote unquote swore on her child's life that it was not intentional. That, correct?
before I answer, I'd like you to direct me to that part of her interview. So
I'll strike it with you. It's on video. Some of Miss Boone's diagnoses predated her relationship with Mr. Torres, correct?
Yes.
And so when diagnoses predate a violent intimate partner relationship, there is an independent cause, even though they may then later contribute to the phenomenon we see, correct?
Well, I wouldn't say that all mental disorders have an independent cause.
Okay.
Sometimes they're spontaneous or biological in nature.
Well, let's talk about hers. I mean, you're familiar with her prior diagnoses and you went through her childhood, so on and so forth, correct?
I did.
So she was bringing some things with her prior to Mr. Torres' relationship, correct?
She had
Is also yes or no, ma'am?
Yes, she did.
Thank you. You reviewed some Advent health records, correct, of hers?
Yes.
And some Aspire records of hers, correct?
Yes.
And you would agree that there are times in the Advent health records where she goes to the hospital and then leaves before getting treated, correct?
Yes.
And there is a time when she goes to the hospital where she is described, their words, not mine, as having ETOH on board.
Yes.
Do you understand what ETOH means?
In a medical record, you would use that shorthand for alcohol.
Or ethanol, right?
Yes.
Drinking alcohol, not the other stuff.
Correct.
And in the records that you reviewed from Aspire, she came with complaints of depression in January of 2018, correct?
That's right.
And ethanol or alcohol is a central nervous system depressant, correct?
Yes.
And I know you're a psychologist, not a psychiatrist. So let me know if I'm pushing you too far and you're not going to answer. But you are familiar generally with the effects ethanol has on the body.
Generally, yes,
And you can and do make diagnoses of alcohol abuse disorder.
I do.
And in your professional life or personal life, are you familiar with the standard serving size of drinks when you're evaluating somebody's drinking? For instance, hey, I only drink 2 drinks a day. All right, well, are they 64-ounce mugs of beer or are they 12-ounce? So are you familiar in that context?
It might be a question I would ask during evaluation. What are you referring to? Is it a mixed drink? Is it a shot? Like, I try to identify that.
And you ever ask if somebody says they drink 2 glasses of wine, well, how big are glasses of wine?
Sometimes.
And is your understanding that 5 ounces is the standard serving of wine since it's about 12% alcohol?
I'm not sure what the standard size is, but I would ask regarding like a wine glass.
And in January of 2018, when she came in crying and complaining of symptoms consistent with depression, she had a blood alcohol level of 0.165, correct?
I believe so.
And in October of 2018, when she ended up going to Aspire, when she was found stumbling by police, she had a breath alcohol of 0.185.
I'm reacting to your description of her stumbling by police. I know she approached police for help. So
Why does she care what he says? Unless she's there to make sure something happens. That's strange to me, the way she just answered that.
So there have been 2 sets of records, but I believe you may have the same set that I received on September 27th, 24. Can you turn to page 21 of 57 of the Aspire records?
mine aren't numbered, but I will.
May I approach the witness?
Yes.
Exactly, Kova. She can't be neutral. And any good witness is going to go up there and be neutral. We've seen good doctors that do that. They get stuck on the stand and they have to answer the right way, right? This is weird. She's already gotten paid. It doesn't matter how it ends up. Just tell the truth.
All right, may I approach the witness?
You may.
What I'm showing you is what is page 2157 on records from Aspire that was provided to me by the defense on September 27th, 2024. And just at the top, you can read the first or the 4th lines.
All right, Judge, I would ask that she be allowed to read that entire paragraph. Other than rule of completeness.
Approach.
Y'all are right. It says in the report probably she stumbled to the police for help. I bet you money that's what it says. Remember, she's always a victim. Always a victim. If the fan lady says, but Carrie, if the defense loses, that will be less business for her. She has a vested interest. She's not the lawyer. She didn't lose the case. She's just there to testify. She can only do so much with what she's got to work with. At least that's the way she should be, right? If it's an apple, call it an apple, not an orange. The guy this morning was neutral, yeah, but the guy this morning also had not diagnosed or evaluated her. So the guy this morning, I don't understand why they brought. I don't understand why they felt like he needed to be there. But I guess they're trying to establish what to look for in an abused person. The thing about it is, though, is you're setting it up for the prosecution too, because we could flip the script on this and say, well, this is George that you're talking about. Are you reading about George? You're not talking about Sarah. You're reading about George. That's the victim. And all these private meetings, I'm so tired of it. Owen's promised her a bonus if she gets Sarah off. Yeah, right. We all need Jesus.
You may proceed, Mr. J.
Thank you. All right, October of 2018, or of 2018, there was a second visit to Aspire, and that was based upon her being found stumbling by law enforcement with a .185, correct? And that's
She
false
walked
arrest or
up. Okay. So I'd have to say no, the way you phrased the question.
Ma'am, Boone was stumbling due to her level of impairment, paren .185.
Yes, I would agree.
Is that part of the records you relied upon?
Yes.
Thank you.
Oh my gosh, that's so strange. That right there just sunk her. She is
When
not
you
credible.
talked to Ms. Boone about that, she kind of just described an event of June of 2018 and blurring those two events, did she not?
No, she told me she had two different Baker Acts.
Did she describe it as being June of 2018?
I'll have to reference my interview note to find that if you would like me to.
No. Do you remember giving a deposition on October 1st at the state attorney's office downstairs?
I do.
And at that point in time, and I'll ask opposing party, you want me to show her prior statement before I ask her?
I think she's got a deposition.
Do you have your transcript?
I do.
Okay.
Just
So for the record, it's page 34 that I'm referring to. Line 16 and 17.
Yeah, I want to know about these Baker Acts. I haven't heard about this. I bet it was Brian.
I'm with you.
Okay. She described that as June of 2018.
That's what I said in my deposition, that she was describing her experience in June of 18.
And she described this experience as going to the hospital to find a pastor, correct?
Yes.
And ends up going to what we call Lakeside Bend and Aspire now, right?
Yes.
And then what you described was she was talking about more of the violence that occurred specifically regarding a significant episode of Jorge driving her roughly in the car, so on and so forth, correct?
Yes.
All right. Those were two separate incidences. January, when she came looking for the pastor, correct?
So I'm just clarifying that there's a record that we started with this conversation from October of 2018. And there is a description of her trying to go to the hospital to seek a counselor. So those are two different instances.
In January of 2018, when she went to the hospital crying and signs of depression,
Bless you.
she indicated that was because her husband and son had gone out of town and she was feeling lonely and sad about having lost her job a few weeks earlier, right?
There were numerous stressors there, yes.
Nothing mentioned about any problems with somebody named Mr. Jorge or George Torres, correct?
You're talking about January?
Yes, ma'am.
Oh, come on, pay to play. You know this. Should have this right memorized. In Florida, if someone thinks you're a harm to yourself or others, they can Baker Act you for 72 hours, which means they can put you in a hospital institution / mental ward type situation. And anybody can Baker Act you. They don't have to be related to you. It's actually kind of a scary law. If someone wanted to get even with somebody, they could do that.
So the hospital records are not referencing her relationship with George on the January date.
Okay, is that what we're doing now? We're just going by the hospital records. Okay.
Now, in talking about February 23rd, 2020 with Ms. Boone, you talked to her about that on several occasions, correct?
I did.
And part of one of those conversations, at least, was about an incident that she indicated had happened the night before February 23rd, 2020, correct?
Yes.
She indicated and told you that she had been dragged down the stairs the night before the suitcase incident, correct?
That's right.
And in part of your review of this case, you reviewed all the crime scene photos, correct?
Yes.
Those include photographs of Ms. Boone, correct?
Yes.
And were there any indications in the photographs of injuries on her consistent with being dragged down the stairs of carpet?
I didn't see inside her scalp. So I didn't see photos of inside, her hair follicles and this area of her head. On her outward body, there were no indications of that.
And did you ask her how it was that she was injured during this dragging down the stairs?
I don't think I went through specific injuries to her, no.
Do you agree that alcohol intoxication affects the credibility of a historian that's providing history to you, patient or a client?
If they're actively intoxicated, yes.
We had talked, you and Mr. Owens, had talked about narcissistic personality disorder earlier.
Yes.
And that is a recognized diagnosis in the DSM-5-TR.
That's right.
And there's 9 of those, correct? 9 traits?
Are you talking about the criterion of narcissistic personality disorder? Yes.
Like page 761 on your hard copy?
Thank you. All right.
Was I close? I have a digital copy.
760, but that's fine.
One of the criteria is has a grandiose sense of self-importance. For example, exaggerates achievements and talents, expects to be recognized as superior without commensurate achievements, correct?
Yes.
2 is preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love, correct?
Yes.
3, belief that he or she is special and unique and can only be understood by or should associate with other special or high status people, or institutions, correct?
So 3, just caveat, it says believes, not belief, but the rest of what you said I agree with is the criterion.
4, requires excessive admiration.
Yes.
5, has a sense of entitlement, unreasonable expectations of especially favorable treatment or automatic compliance with his or her expectations, correct?
Yes.
6 is interpersonally exploitive, takes advantage of others to achieve his or her own ends, correct?
Is interpersonally exploitative.
7, lacks empathy, is unwilling to recognize or identify with the feelings and needs of others, correct?
Yes.
8, is often envious of others or believes that others are envious of him or her, correct?
Yes.
9, shows arrogant or haughty behaviors or attitudes.
Yes.
Now, believe that she has traits of that disorder, correct?
Yes.
Grandiose sense of self-importance?
There are indications that she feels like that or has expressed that before.
So that's a yes. Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love?
No.
You remember going to the state attorney's office on October 1st, 2024 and giving a deposition?
I do.
It was in front of a court reporter, like not a court reporter here.
Yes.
And you swore to tell the truth, the whole truth, nothing but the truth, correct? And referring to page 89, lines 18 through 20. Let me know when you're ready. Are you ready?
Yes.
Did you give the following answer to the following question? Preoccupied with fantasies of unlimited success, power, brilliance, beauty, or ideal love? And your answer was yes?
I did answer yes there.
She does not, according, in your estimation, does not believe that she is special and unique and can only associate with high status people, correct?
No.
Does not require excessive admiration, correct?
Correct.
Does have a sense of entitlement,
Yes.
is not interpersonally exploitive,
Correct. She is not.
and when discussing whether or not she lacked empathy or was unwilling to recognize or identify with the feelings or needs of others, you indicated that that might be the case, but it's not intentional.
In other words, she's not aware she's inconveniencing others.
So there was 3 of those
Awareness.
traits, correct?
Yes.
Not 5, which would be required, correct? For a diagnosis of the personality disorder.
If that were the correct diagnosis, you would need 5.
All right. During your conversations with Ms. Boone, the defendant in this case, she explained to you that cheating to her means when Mr. Torres would look at pornography, correct?
Correct.
Not a real life woman, correct?
No, not that he was engaging in sexual intercourse with actual women.
Part of the records that you did not review were the text messages that were part of the phone extraction of her phone device, correct?
That's right.
Ooh.
You indicated in your conversation with Mr. Owens that some of the traits that are commonly seen in abusers would be control, jealousy, easily angered.
This could be, yes.
What other traits just common for abusers?
Being a person who segregates their victim away from other sources of support, somebody that exhibits coercive control, meaning that they would prevent the person from engaging in activities that would be independent, so restricting their ability to have independent like life, job, money, things like that, that would be supportive of them being left, for instance. Other things would be using emotional expressions like rage to cause a physiological reaction in another person. So those could be additional descriptions.
Specifically, the materials you reviewed. I just want to make sure we're on the same page. Paperwork from prior cases involving Mr. Torres and Ms. Boone.
Yes,
Medical records for Mr. Torres.
that's right.
The medical and Aspire records for Ms. Boone that we've discussed.
Yes,
The crime scene photos from the incident in February.
that's right.
Pages 1 through 413 in discovery in this case.
Right.
A photograph of a suitcase and 2 videos involving a suitcase.
That's right.
And additional videos on that phone, correct?
Yes,
Such as baseball bat smashing the TV.
that's part of it. Yes.
And then did you review any other videos where there's conversations between Ms. Boone and Mr. Torres.
Yes.
One prior 911 call?
Yes.
Now, today you had indicated that you had reviewed the photographs from some prior incidents of violence, correct?
Yes.
When is it that you did that? Is that recently?
No, there are photos included with the
Prior case packages?
case packages. Thank you. I'm not sure what to call it. So
That's fine.
All right.
All right. And did you review any body worn camera from those prior case packages?
no, I did not. I didn't have that.
Anything else that you reviewed that I've not covered?
Are you speaking of documents only?
Yes, yes. Materials other than your 9 visits with Ms. Boone.
All right. Just checking with the
That's fine.
folders I prepared
just
for
wanna make
today. I don't know if, I guess that would be part of the discovery. The investigative report is within those 413 pages.
Did you interview anybody else personally besides Ms. Boone?
Yes.
Who else did you personally interview?
Melissa Sexton?
All right. Anybody else?
No.
You didn't interview Brian Boone, correct?
I did not.
You did not interview their child in common, correct?
No.
And you didn't review the phone text messages extracted from her device, correct?
No, I didn't.
Did you review any records from the jail?
No.
And Judge?
Yes.
What's wrong, Owens? You not feeling well all of a sudden? Are you having a medical attack? Do you need to call it a day now? That would be something James Owen would do right here, because he'd say that the doctor has to leave. She can't be here tomorrow, so we've got to finish this tonight. But Judge, I can't. I think I'm having a heart attack. Got to go to the hospital. Oh, see, that's what I was just saying. Like, he called out 9 visits plus paperwork, the medical records from George, the medical records from Sarah, the crime scene photos, the photos of the suitcase, the 2 videos of the suitcase, the 1 video of him smashing the TV, the 1 video of her coaching him on how to not get her charges dropped, the 1 911 call, a prior 911 call, and the investigative report that we've all looked through. She hasn't seen the body worn camera footage. She hasn't talked to anybody else other than Melissa Sexton, who herself was also a DV victim, who Sarah used to go to and claim all the time that George hit her. She's not looked at any of their text messages, no interviews with her ex-husband or her child, and she has not looked at the jail records, but she is certain that she is correct on all of this. All right, do what's right, Judge Cranick. Come on. Please take a second and hit the like button and show Carrie support. Thank you for remembering to do that, because I forget to ask y'all. Oh, is Sarah, don't look at the actual evidence. She's been watching YouTube channels to see what the state was going to bring up. Sarah she don't have any internet access. What you talking about, Wendy? She don't have any internet access. Remember, that was a big deal. You need to get in that courtroom. Do I? What do you want me to do? They'd throw me out. I wouldn't be able to shut up. I could do CPR on Owens. Don't let Sarah do it. Good Lord. This testimony is horrible. It's biased, or as Gerald Brooks would say, it's biased. And they're talking about me, Judge, and I don't like it. Yeah, she doesn't have any friends. What friends are they going to interview? And why all of a sudden is Melissa now not in the picture? Where's Melissa? Why can't Melissa be here for this trial if she's so important in this whole thing? YouTube has more access to Sarah than this doctor had. I do as a YouTuber. Okay. Are people not being respectful? Are you really thanking them for being respectful? We're getting towards the end of the day, you guys. We're going to be doing the drawing for the members only in just a bit here. Don't go nowhere. Yeah, she's not smiling anymore, is she? Brian should have been one of the first people she spoke with. He's known her the longest. He's been with her longer than anybody. He's absolutely necessary, Rebecca. You're correct. 100. Mark says, best chat ever. Yes, you guys are amazing. Y'all are so sweet to each other. They had a great day. They had a great marriage. So she cheated on him. Who is Melissa? Okay, co-vote. Melissa was the apartment manager. I'm sorry, I didn't even think about that. She was the apartment manager for a long period of time that Sarah and George lived there. Sarah would go up to the office all the time. You know, we know how she was, right? She's wandering around the neighborhood like a weirdo. And she would tell Melissa how she was getting beat up and everything by George. Now, of course, Melissa's stuck at work. She can't leave. So she has to listen to all of Sarah's stories. That's how she knows all this about Sarah. So again, you're talking about somebody who only has Sarah's side of things, not George's side of things. Now, Melissa did speak to George one time. And Melissa did admit that she thought that they both had been hurting each other. And that she did see a video one time where they were both hurting each other, but she didn't have it anymore because she had it wasn't on her phone. It was on somebody else's phone or something. And apparently the apartment complex has now changed ownerships. So since they've changed ownerships, the defense says they were unable to get any records from the apartment complex on all of the times that people called and complained about Sarah and George making too much noise. A lot of apartment complaints. Melissa may be a rebuttal witness. I don't know. I'm trying to think here. Like, why haven't we seen her? I feel like we would have already known she was coming in. I don't know why I feel that way. Nobody's brought her up. Nobody's mentioned her. This is the first time they've mentioned her in the trial. Wait to hear that one word from the jury. Guilty. Yeah, right? Please let there be a 6 total. We only need 6. We need 6 unanimous guilty verdicts to get justice for George. Be careful driving, Bama. Only listen. No looking at your phone. Melissa said she had been abused, so they bonded. Yeah, exactly. Melissa even had her own DV thing going on at the time, right before Sarah's. And so they bonded on that whole thing. But think about it. If you're the apartment manager and you work there and one of the tenants comes in all the time and talks to you, what can you do? Nothing. You can't get away from that person.
The objection is sustained in part and overruled in part.
You testified earlier in the normal course of practice of forensic psychology and psychiatry, you all do rely upon the diagnoses of other experts, correct?
You can inform my opinion, yes.
And you have not reviewed any electronic communications in the form of text regarding Ms. Boone's case, correct?
No, I did not.
Or recorded phone calls of any type, correct?
Well, 911.
Other than that.
No, other than that.
Now, let's talk about the February 23rd of 2020. She told you that they didn't really have anything going on to do that particular day, correct?
Yes.
It was a Sunday, correct?
Yes.
Did some chores, and then as a reward, they could rest after doing those chores, correct?
Right.
She indicated to you that she and Mr. Torres did not begin drinking till about 4 p.m., correct?
I'll have to reference.
Page 36 of your deposition, if you care to use that.
Great, thank you. 36?
Yes, ma'am.
Yes, paragraph 2.
All right, I'm with you. Around 4 p.m.
And you reviewed the crime scene photos of this case, correct?
I did.
That included receipts for some purchases that were made at Publix on February 22nd and 23rd, correct?
That's right.
And one of those receipts was a purchase for a 1.5 liter bottle of Woodbridge Chardonnay at 12:17 p.m. on February 23rd, correct?
Yes.
Did you question her about the inconsistency of them having purchased a bottle of wine at 12:17 that afternoon and not start drinking until 4 p.m.?
No.
And did she tell you that they had any wine left over from the day before that they consumed that day?
At some point, I'm not sure if it was the day that I was going through this line by line with you in my deposition, but I am aware, yes, that there was an unfinished bottle of wine from some other date.
And then, as the receipt showed, there was 2 additional bottles of 1.5 liters of wine purchased at 12:17 p.m. and about 5:30 p.m. on the 23rd, correct?
Right.
And were you aware of approximately how much Ms. Boone, the defendant, weighed at the time of this offense, February 23rd, 2020?
Around 100 pounds.
And in the first 413 pages of discovery, I believe, was the autopsy report, correct?
Right.
And so you're aware that Mr. Torres was 103 pounds at his death?
Yes.
Do you take into account this alcohol consumption when evaluating what Ms. Boone is telling you about the events of the day?
Yes.
Did she tell you whether or not she was intoxicated by the amount of alcohol she consumed that day?
Please silence your cell phone. You may proceed.
So she did not describe herself as intoxicated originally when we discussed this. So,
So the answer is no. She did not describe herself as
intoxicated, right?
Hypothetically, if she had told the jury that she was intoxicated at the time of the offense, would that affect your evaluation of her credibility in the history she provided you?
No, because that was also my opinion.
Did she indicate to you in describing the events of February 23rd, 2020, that there was any point in time she just simply did not remember?
Yes.
What points in time were those?
So she did not remember taking the videos of the suitcase or the incident in the suitcase until she was at the interrogation room, I guess, and then they were going through them with her. Then she recalled that.
I'm talking about specifically with you. Did she indicate that there were any portions of the night that, or day or night, that she did not remember?
I can't recall anything specifically right now.
Hypothetically, if she had indicated to the jury that she did not remember the 9 or 10 minutes immediately preceding the first video being taken, would that be inconsistent with what she told you then?
No.
Well, she didn't indicate to you that she forgot any part of the night, right?
Right. She just didn't say that. So
Would it affect your evaluation of what she told you about the events of February 23rd, 2020, if she hypothetically has testified that she did not remember 10 minutes before the videos?
not really, no, because the event and the course of events that she narrated to me occurred over several hours. So when you interview somebody about circumstances of an offense, it's the usual for someone to not remember every single minute for hours at a time. I can't imagine that anybody's memory could hold that much unless they have like photographic memory or something.
I'm not asking about hours and hours, itemization of her day's events. We're talking about the 20 minutes of the offense. Does that affect the weight that you give her history she provided you? Just yes or no?
No.
How convenient.
Now, what she indicated to you was the day had been going well. It was fun and games, correct?
Yes.
Conflict-free?
To her, she said it was a good day. So that's what she told me.
She said it was a good day.
Yes.
And there comes a point in time where the activities turn toward hide and seek, correct?
Yes.
And she goes up to the shower?
Right.
And when she comes down from the shower, that's when Mr. Torres is in this suitcase, correct?
Getting into it.
And she goes over to the suitcase and zips it, correct?
Yes.
And did she describe whether it was 100% zipped to you or just a certain percentage?
She said that it wasn't zipped all the way.
And still then, that was funny to the two of them at first, correct?
That's right.
And then there came a point in time where Mr. Torres was getting mad about being zipped in the suitcase.
She told me that he was getting mad.
And that, in turn, made her mad.
That's right.
What Mr. Torres was saying was, I can't breathe, correct?
That is what's recorded on the video.
Well, I'm asking you about what you recorded her saying.
Well, what made her mad was not that he was saying he couldn't breathe. It's what he was saying that was making her mad.
Well, what else was he saying?
At the time, she said that he said something that was making her mad. And so that's the extent of what we talked about at that moment.
So you didn't elaborate what something was that made her mad, correct?
Right. She said he said something that made her mad, and that started making her mad.
Just
You
minor
didn't,
details.
Find it important to learn what specifically he said that made her mad, correct?
I don't agree that I didn't find it important.
Okay, then explain. Why wouldn't you ask that question?
Because as a person who is traumatized is describing their experience as a trained clinician, you will allow open-ended discussion of that experience. And so it's not an interrogation. You don't go asking confrontational questions at the time of their first narration.
Well, you had 9 visits with her. Did you follow up on your 9th visit?
I asked her different questions about
Did you ever ask
being
her?
confrontational.
Did you ever ask her specifically in any of your 9 visits with her what it was that he said that made her mad?
No.
She never described him doing anything to make her mad, but it was words, correct?
Right.
And once she got mad, she decided that she was going to leave him in there for 2 minutes.
That's right.
Not 3, not 1, but 2, correct?
That's what she said.
And the reason she was doing that was because she wanted him to understand how it feels to be choked and what she had experienced.
That's right.
Did you ask her why she didn't let him out of the suitcase after 2 minutes?
Yes, I did actually ask her that.
And what did she say?
Well, she thought that he could get out himself. That's one thing. She said that when she was able to unzip it, it was not some significant thing. She was able to unzip it easily. So she said it never occurred to her that he couldn't get out.
You may proceed.
And you reviewed the still photograph of the suitcase as well as the 2 videos.
Right.
And did you understand what the metadata or what the timestamps were for each of those items?
I'm sure when I reviewed it, I saw the timestamp. Yeah.
Would you agree that 20 minutes is 10 times as long as 2 minutes?
I would.
And if Mr. Torres had not been able to get him herself out of the suitcase within 20 minutes. She didn't indicate that she let him out, correct?
She did not.
She described to you, Ms. Boone being the she, that she was helpful to the police.
Yes.
Do you agree with that assessment that she was helpful to the police?
In the sense that she was having conversations with them without counsel, I would consider that helpful to the police.
Do you think lying to the police is helpful to the police's investigation?
No.
Do you agree that she was not truthful with them?
Yes, I think that I would agree with that.
And when she described getting Mr. Torres out of the suitcase, she described stretching his little legs.
Yes.
And she stated to you there was no fight that day, correct?
That's right.
Just wanted him to be uncomfortable.
I need to clarify. Physical fight.
Right.
Yes.
Just wanted him to be uncomfortable.
Yes.
Correct. And then there was a description of a bat and her using it to nudge, right?
Poke.
Poke. And so do we agree that that means like poking out like this as opposed to swinging it like you're a baseball hitter?
I would agree with you.
And you reviewed the autopsy report, correct?
I believe so.
Did you get an opportunity to review the autopsy photos?
Yes.
Did you question her when she said that she only poked him with the bat?
No.
Not in any of your 9 visits?
Did I question her about whether, can you just repeat the question? I want to make sure I'm answering it correctly.
Yes, ma'am.
Okay.
Did you ever, in considering the autopsy report and the autopsy photographs that you reviewed,
Yes.
when she said that she nudged or poked with the baseball bat, did you ever question her about that, given the severity of his injuries?
So to answer correctly, I did question her
What did she say?
about how she used the bat.
Okay.
She reiterated that she poked and she gestured what she meant. So I did question her about that.
And did you have any questions about that history she relayed to you, given the other evidence in this case that you reviewed?
Just in contrast to the interrogation video. So that.
It didn't contrast to the autopsy photographs or report?
Judge, I object.
Roach.
Judge, he's making me look bad. Judge, call Margaret. She's gonna get paid. She's already been paid, probably. She's been approved for payment. Doctor's blind as a bat. She bought anything Sarah was selling 9 times in 4 years.
You may proceed.
Did she indicate all this nudging or poking with the bat was done while he was inside the suitcase?
Yes.
She never told you that there was any nudging or poking with the bat when he was outside the suitcase?
Right.
She indicated that she ended up flipping the suitcase over face down?
That's right.
Did she tell you about Mr. Torres calling his brother earlier that evening?
No.
Did she ever give you a history about a loud boom occurring inside of her townhouse that evening?
No.
And you never had the opportunity, obviously, to interview Mr. Torres about these things, correct?
Of course not. No.
No other questions?
Mm-hmm.
Any written examination?
Briefly, Judge.
Yes, sir.
I'll put in a request for you, SR. Thank you for your super chat.
The state attorney talked to you about power and control that an abusive partner will use power and control over the victim in a intimate partner violence situation?
Yes.
Threatening someone's dogs, is that an example of someone using control?
Yes.
Taking car keys from the other party, is that an example of control?
If they're withholding, yes.
Taking a phone and withholding a phone?
Yes.
A debit card?
Yes.
Destroying a home, TVs, putting holes in the wall?
Yes.
Not helping pay the rent and other bills?
So I would say that that could be withholding, that could go under coercive control of another person.
What about violating a court order to have no contact with the person?
Yes.
That's all the questions.
Thank you. Can this witness be released?
As far as the state is concerned.
Mr. Owens? Thank you, doctor.
Yeah, we're done with her.
Just allow me a moment to pack up.
Collect all your stuff, ma'am. No worries.
Collect all your stuff and get the heck out.
No apologies necessary.
We got an hour left. What are they gonna do? Are we gonna rest? Do you want to rest, Tony? Should we rest? Go track down Kevin. Is he in the hall? Ask him if we're going to rest. No, is that him right there? Maybe he's actually in the gallery right now. Okay. Look at Sarah. She's not happy. Nothing like she was the other day with her flipping her hair around and smiling at everybody.
Yes.
God, what is he trying to get his miles in or something with his little, what do you call that little bot you wear around your arm? He goes home and tells Margaret, I got in 1,500 steps today going back and forth from the judge's bench. Thank you, Matthew. I'm so sorry about your captions a while ago, you guys. I was steadily taking notes of what that doctor was saying. I was writing as fast as I could. And I didn't even know that y'all were like blocked. I'm so sorry, y'all. Thank you for your super chat. I'm sorry. Sorry you didn't get my attention. I feel bad.
All right, members of the jury, it is 4:01. At this point in time, we're going to go ahead and take that afternoon break. I got a couple things I got to address with counsel as well, so maybe a little bit longer, but we'll bring you back in as promptly as possible. Again, same instruction I've given you before. Please don't conduct any independent investigation or research as to the person, places, things, or charge involved in this case, and do not have any conversations amongst yourselves or anyone else about that. We'll bring you back in as promptly as possible. Thank you.
All right.
Y'all can be seated. Let's go ahead and take a recess, a comfort break for any of us, and then we can address any argument with regard to the any other evidence that the defense may be seeking. Let's come back here in about 10 minutes, so 13. Okay? All right, thank you. We'll be in a short recess.
Okay, so while they're doing that, we're going to do our drawing for our members only. Give me just one moment, please. I'm just want to make sure I got all my names in here real quick. Looks like I do. Okay, let me share the tab with you guys. Are y'all ready? Are we ready? Big money, big money. Everybody clap. Okay, here we go. Earbud giveaway. Michelle, isn't it your birthday today too? Oh my goodness. It's her birthday too today, I think. Oh, how perfect is that? That is awesome. Is she in the chat right now? Is she still here? I know she was here earlier. She's been here all day. Yay, Michelle. Michelle. Well, congratulations, Michelle. So email me in the grab my email out of the description box, please, if you don't mind. In any of my videos. Email me your mailing address and put in the title of the email that I am a winner, so I know it's you. Congratulations, Miss Michelle. And if anybody sees her out in any other chats or anywhere, please let her know she won. Because I know she's been here like all day. Pretty much, hasn't she? So, yeah. Watch her come back and go, I was in the bathroom. It's okay. She's not here right now. She'll be back. She always comes back. She always comes back. Oh, my goodness, you guys. Well, do you feel like the jury, what the jury just saw and heard, has affected their opinion of what's going on here? I think I think because of the way that she responded, it's not even what she said, it was the way she responded to Jay. How she had to make sure she wasn't sounding like she was talking against the defendant. It was just it was not neutral, it was not impartial, it was incorrect. And I just feel like they're going to see that and go, that that's not good. That's not good. And here's the thing, I mean, anybody knows anything about, you know, trials, which pretty much everybody does. Everybody knows that there's always somebody pay to play going on, right? This woman just confirmed it in her testimony, in my opinion. Mary Jane, what do you think? When you say nope, do you mean I don't agree with you, or I totally agree with you, they're not falling for it? Lenny is sick. Lenny, how's your leg? And why are you sick over this? Oh, good Lord, this stupid thing keeps making noises. Why are you sick over it? I don't think it's that bad right now. Brian will be an excellent witness. I cannot wait till they bring him up. You know, surprisingly, wait, wasn't the defense going to bring him up before they signed off today? Wait a minute. Wait a minute. When they mentioned witnesses, I totally forgot about this. When they were mentioning witnesses today, not one time did they not say that they weren't going to call Brian. They said they weren't going to recall the neighbor witness, Maria Gallipoli or something like that. They weren't going to recall Abraham Marino, and they were not going to call up Detective Lowen, since Koepsell had already done all the witness for that. So, but not, and they mentioned that Pearl Walker was coming there today, and they mentioned that Dr. Harper was coming, but they never said anything about Brian. I'm looking back in my notes from yesterday. Do you guys remember anything about the defense bringing him up again? Because remember, that was such a big deal at one point, making sure Brian was on the defense's witness list. We know that if Owens doesn't call him up, the prosecution is going to. I just was interested to see, because that was something that we were all kind of a little bit peeved about. Like, why is he going to testify for the defense? Well, if they're going to call him up, I don't think he was mentioned. I think you're right. Custard girl, what's wrong, honey? Why you got to keep the faith? What's going on, Bubba? Where's my sweet custard girl? I haven't seen you. I saw you in that. There you are. Oh, yeah, we'll be okay, Custard. We'll be all right. I really appreciate you guys hanging out with me those last couple of days. Y'all been like, I gotta say, you were really hanging in there. But I will also say that this trial to me has not been boring, The only part that was boring was her first 20 minutes when she wanted to talk about herself. When she started talking about Sarah, I got interested. When Sarah was talking about herself, that was a little boring to me because, we knew that was coming. We've heard it all before from Sarah. But when Jay got up and questioned her, it was like, okay, that took that away. So really, it's been a very interesting trial, I would say, from start to finish. You know what I had for lunch today? What did I have? Oh, I ate some Fritos. I wanted to eat a sandwich, but I don't want to get sleepy after I eat, and then because I'm just so tired today. After this is over. I didn't do it yesterday. So I don't know if y'all heard me, but yesterday I kept saying after this stream I'm going right to bed. Well, I didn't. I didn't go right to bed. No, I don't know if it's gonna be bologna and cheese or not, but I do have bologna and cheese in there. I ended up staying up till after 10 o'clock last night. I don't know why. And then I was watching. What have I been watching lately? I always have to have some kind of like crime documentary going on in the background for me to be happy, like for me to fall asleep. That's what I like to listen to. So I like it when the 48 Hours does the marathons on YouTube. Do you know there are Facebook support groups for Boone? Is it a joke or are they really true supporters of her? So they think that she's been mistreated and they believe her. Well, I guess to each their own. I don't know what to say about that. 1,000 people watch me on a live stream. I never thought that would happen. So I guess it's possible for Sarah Boone to have a fan club. Oh my goodness. Sorry. Sorry what? What happened? Oh no, it wasn't because you called. No, I was wide awake anyway, Laura. It wasn't because you called me. Thank you, West Coast Mesh Spider. I appreciate that. I hope y'all have had a good time in the chat this week. I'm sorry I just don't feel like reading right now. I just wanted to kind of sit and talk to y'all for a little bit. You know what I used to listen to, Christine, when I would go to sleep? I would put on for the longest time, it was Law and Crime. And then I got tired of those. And then it was, I think it was the Missing People or something like that. I forget the name of it. I forget the name. Anyway. And then Vanished or Disappeared or something like that. Anyway. And then it became, after The Mentalist, it was Castle. Love Castle. And I would just I didn't even have to. And the reason I liked watching it was because I knew what was happening because I'd seen the shows and reruns so many times that I wouldn't lift my head up to look at the TV because I knew what was going on. So that's why I always like to watch the reruns. But just hearing them talk and all that, it just kind of put me at ease and I'd fall asleep. But I always have to have something like that. Not something that's going to keep me awake though. I've noticed more and more, and I don't know if you guys have noticed. I don't know if any of you guys have Prime or Netflix or anything like that, but there's way more true crime documentaries hitting those platforms than there ever have been. And there's one that hit Netflix today, which I probably am going to fall asleep watching tonight. The Zodiac. It's a true crime documentary on the Zodiac killer, and it's on Netflix. And they think, I guess whoever they're talking about is apparently may or could have been or was the Zodiac. They never caught him, but I guess this person is no longer alive. Here, you're a woman after my own heart. You eat Fritos, drink Diet Coke, eat bologna and cheese, and I do all that. Are you from the South too? Zodiac looks good. Yeah, doesn't it? I want to watch that. It's coming out today. I told you guys I watched that movie Trap. I didn't like it. You go to sleep listening to my voice. No, you don't. Do you really? People say I'm so loud all the time. You must have to turn the TV down really loud, huh? Well, you think that's what it was, Phyllis Ann? True crime exploded after Jodi Arias. That makes sense. I don't know if it was her or yeah, because she was all the other ones followed after. Because Watts was way after that too. But yeah, so what do you guys think about doing some stuff on Jodi Arias? Would y'all be interested in watching that, or do you feel like, we've watched it, we've been there, we've done that? 'Cause I never dove into the trial. Like I've never dove into all the evidence and everything. I did not sit through the trial, and I know that we have access to it. I think Court TV has a thing on their channel of it. Would y'all want to watch the trial together? She was the beginning of all of this. Yeah. Dead horse. Don't beat a dead horse. Is that what you're saying to me, Cheryl Patton? Casey Anthony. Which was first, Casey Anthony or Jodi Arias? Y'all better start looking it up. Pam Smart. Oh my gosh, Pam Smart. If you watch the Pam, no, not you're right though. Pam Smart was the first one. Oh, and then the one that's gonna be where's my calendar? Wait a minute. Susan Smith, you guys. She is up for parole. Well, her parole hearing is going to be this Friday, today after tomorrow. I don't think she's going to get it. And you know, she got a strike or something on her record for doing something stupid, like writing a letter to somebody. Or no, she did an interview. So she got a strike, like a negative on her prison record, which is going to really hurt her in parole. That would be stupid if she went all this time and like the same month that she's supposed to get paroled, she does that. But you know, that's what you call karma. Yeah, Scott Peterson, Casey Anthony, there's a lot of them. But seriously, what do you guys think about doing Casey Anthony? Because it would be the type of trial or the type of stuff that I could go out there and find everything I need to find on it, because it's out there. And we could watch the trial together, and we could fast forward through the boring stuff. Let me know. I dug deep into. Oh, you did? You already dug into Casey and Jodi's trials. Beach Lover did. Well, do you want to help me with present it, or are you just you're over it? Yes, snowball's chance in hell. Exactly, Mark. Jodi Arias, no. Lauren says, look up cold case files documentaries. Okay. No, Scott Peterson was. Okay. OJ started everything. Yeah, well. Elise, I need to sign. Elise says that I maybe should. You have a lovely voice. Love the accent too. Thank you so much, Kate. I like your name, Kate. Maybe a case that's not as heavy as this one. Yeah, I didn't want to get into anything that had to deal with like any children or anything like that. And then I say that, and then I do have a case. I have 2 cases on the back burner that I've already kind of been digging into, but I just don't know if you guys would want to go there with me. Do you remember that fat little guy in Atlanta that left his kid in the car and he went to jail for it? And his wife came in there and she was like, "Oh, baby, I love you. I love you." And she wasn't even mad at him. His name was, I know I've brought this up to y'all before. Ross something. Anyway, I've already done some digging into that. The problem is there was a baby that passed in that case. So it's kind of, But I wanted to dig into I've already done Chandler Halderson. We did that one already. Stephen Avery. I've never done that one. Is his trial was it even streamed? Oh, the other one was the guy that drove his family off the bridge. Remember that guy? We talked about it once before. We talked about doing that one. Oh, they're back. Hang on.
CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Dave Ketchner on behalf of the state.
Wait, Jay.
Defense.
James Owens for the defense.
Tony Henderson for Sarah Boone. Kevin Beck for Sarah Boone.
All right. Ms. Boone is seated at counsel's table wearing the same dark gray suit and maroon blouse from this morning. Mr. Owens, are there any other matters we need to address before you rest in the presence of our jury?
Yes.
Yes, sir. Yes, sir.
Yes. Judge, there's two orders that I'm going to be requesting the court to take judicial notice of under 90.202 sub 6. And the orders of no contact. I have copies of the certified copies of the orders. May I approach?
Yes.
No contact
State,
orders.
have you seen them?
For George and Sarah?
Understand, but you have seen them.
I have not.
You have not seen them. Okay.
Doesn't change my decision.
Understood. Okay. You can bring them on up. Thank you, sir. Court has been provided no contact orders issued in case number 2019 MM 5062 on or about June 16, 2019, and a no contact order in case number 2019 MM 5114 issued on or about June 19, 2019. Both cases styled State of Florida versus Torres George Jr. Let me hear any argument as to the judicial notice from you, Mr. Henderson.
Judge, I think they're relevant. I think just from the testimony of Redirect Dr. Harper saying that an element of control, the control is talked about greatly by the state when I point out things hypothetically that they refer to. They refer to them as hypothetically. However, they refer to things that they're developing on this boom. These show that they were in fact orders, and the orders were for no contact. So these are elements of control in relation to George Torres.
Okay. Response.
So in regards to the judicial notice aspect, we don't dispute that that can be a substitute for authenticity. However, they're not relevant, they're not admissible. They contain statements that were made by people who are not testifying. Just because an expert relies on something doesn't mean that it's admissible. What happened during redirect with Mr. Owens was he was asking, what are the hypothetical things that we rely upon in making these determinations as an expert about whether there's battered spouse syndrome or not. So one of the many inadmissible things that he mentioned was pretrial orders of no contact. So it's fine. The expert can certainly rely on the fact that there may have been pretrial contact orders or no contact orders that were involved in this case, and she considered that. That doesn't make them admissible. There has been testimony, I believe, from Ms. Moon that there was pretrial no contact orders and violations of them. It's not a fact and dispute. It just that doesn't mean that the paperwork comes in as evidence. So that's our objection is it's irrelevant and hearsay. Just because an expert relies on inadmissible evidence doesn't make it admissible.
What's your response to hearsay?
Judge, I think under the, as to hearsay, I think the statute takes care of that itself because it says that the court can take judicial notice. So that's the foundationary part. And it's not hearsay. It's an order of the court. We're in a case where we've gotten evidence of past domestic abuse. There was evidence of it started with the state about control. And these are things of control. And I'm sure the state's going to, in rebuttal, they're going to come up with things that they feel either by body cam or any other evidence that shows her exercising control. This shows Mr. Torres exercising control. It is very relevant.
But how's it not hearsay? Just because it's a court record, it's still out of court statement. Certainly being offered for the truth of the matter asserted, no contact order.
Judge, that's why we have the thing that the court could take judicial notice of. There are certain things that
But the case law says you can't utilize judicial notice to get around hearsay. I know 9202 says that I may take judicial notice. 9203 says that upon sufficient notice being provided, which the state is conceding based on their argument, the court shall take judicial notice of items identified in 9202. But my question is, the case law, as identified in Professor Earhart's treatise, specifically says in Dufour v. State, 69 Southern 3rd, 235, which specifically talks about notice of judicial documents in a court file, that doesn't get you around hearsay. So what's your response?
Let me go through hearsay in my mind again.
You're fine. Take your time.
Let me think about that, Judge. You want us to play the Jeopardy theme while you do that? Kevin, what should I do? Cookie said, sit down, dummy. They did underestimate Kranick. Y'all let the police reports not be brought into evidence. I think that's what they just want, those brought into evidence, those 2 no contact orders from those 2 arrest dates. But because of right now, they're not. How is 3 seasoned attorneys? I know, Dorothy. It's horrible. Oh, Matthew.
Yes.
Missed you again.
I'll start this way first. One of the exceptions to the hearsay rule is business records exception.
Business
So
record.
It's a business record and it's kept in the normal course of business. Then someone can come in and lay the foundational things for the business record exceptions to the hearsay rule. However, in this case, that would not be needed if the court takes judicial notice of it. That eliminates the necessity to do a business record in that foundation, because the court, under the statute 90.2026, can take judicial notice of court orders. This is a court order that's certified. I think it's an exception to the hearsay rule. Also, I think the probative value of these documents outweighs any prejudicial effect.
Any other argument?
No, you're right.
Any other argument, state?
The fact that there was a pretrial court order of no contact between them is going to come in. I mean, on one of the body worn cameras, Mr. Torres is like, well, the court said I couldn't, but she said I could come. And I believe she testified to that during her examination. My objection is to the paper and the grounds that I've argued.
Okay. All right. Thank you very much. State v. Mobley, 98 Southern 3rd, 124 by the Florida 5th District Court of Appeal, cited in 2012, says that there's a procedure that specifically needs to be followed for judicial notice, as set forth in 9202 and 9203. State is conceding that although there's not a writing, they're not objecting to the judicial notice concept. They're objecting to the evidentiary bases. I do find that it is relevant, but the problem is I have with hearsay. And the court, in relying on the Florida Supreme Court decision in Dufour, D-U-F-O-U-R v. State, 69 Southern 3rd, 235 at pinpoint 253 by the Florida Supreme Court in 2011, which states, while the court may take judicial notice of documents in a court file which were properly placed there, this notice would not make the contents of the documents admissible if they were subject to challenge, such as when a document is protected by privilege or constitutes hearsay. It is an out-of-court statement that is being offered for the truth, to wit, it is a no-contact order, and the requisite requirements for a business record under 98036 subsection A have not met, nor has there been a certificate from the custodian of records as to those things as required by section 6, paragraph C, and the timeliness of a certification. So I cannot accept judicial notice of these two documents, even though the state is not conceding the procedure for judicial notice. I am sustaining the state's objection as to hearsay under the grounds and the exceptions that you have offered.
Boom. I can't do the Atlanta child murders. That's too many kids. I don't want to do a kid thingy, Matt. That's the only thing. Thank you for your super chat, though.
We do have the clerk of court subpoenaed. I don't know where they are. I assume they're somewhere in this building. I believe they sent some message to us back before the hurricane about what date they were to come, and we said to be continued. So we haven't gotten back up with them yet. So
What is he talking about?
it would take me some time to check on that. It's 4:30.
Was the subpoena still for this time period?
Yes, I believe it was a 3-week period.
Okay.
But we haven't followed back up with them. This came up
Sure.
late.
I'll give you an opportunity to do that.
I don't know whether you could just go ahead and send them to home for the evening, and let me see if we could find the clerk maybe in the morning, and then we could rest in the morning, and if the state has Dr. Werner. This is probably going to take me a little bit.
Yeah, I'll give you that opportunity. Absolutely. If you want to, sure. If you want to try to do it now or do it tomorrow, I'll leave it to you. Because I can't imagine it would take long if we're able to get a records custodian or a person to lay the foundation. I can't imagine it would take that long.
Aren't they in the building?
Yeah. 3rd floor?
Oh my God, we're gonna sit here and wait for him to go to the 3rd floor?
Sure.
No, stop
I
it.
suggest we go ahead and let the jury go. It's 4:30.
He wants all night.
So they can do that. We could present that in the morning and then rest in the morning, and then
All right, that works for me.
I'm not going to make some poor employee come in and do that. I was conceding the authenticity. I don't understand the relevance of it coming in.
Are you now withdrawing your hearsay objection?
Well, I still believe it's hearsay, but I think it's cured by it's a public record and it's stamped and all that stuff.
I know, but no one's made that argument yet.
I don't want to punish some poor clerk.
Okay.
I won't object to them coming in, but it's a slippery slope for other records. We'll see what we do.
Okay. All right. So the state is still maintaining its hearsay objection. I do find that it is relevant.
I don't want to make a clerk.
So then what do you want to do, Mr. J?
I'm stipulating to if the hang up for the court and the defendant is that they believe a clerk in the court needs to come in and testify, I'm conceding that issue so that person does not have to do whatever that issue is.
Okay. All right. Fine. Then based on the court, on the concession by the defense, by the state, excuse me, do you have any other objections with regard to these two non-contact orders? Mr. J?
No more.
Okay. For the reasons previously articulated, I do find it's relevant. The state has withdrawn its hearsay objection. Do you want these as a composite or individual?
Individually.
Okay. Madam Clerk, could you pre-mark them and then we'll identify them, please?
I think he's playing a game too, Tracy. It's all games with Owens. Casey Carley, I'll look it up. It's funny how when he said, yeah, go do it now. I think the judge did it on purpose. He was going to see how Owens reacted. Go ahead and do it. We'll wait. Yeah, we got time. Judge knows it's just a game. It's just all a game. Watch Owens come in the morning and say, we judge, we decided not to do that. Explain why. So what happened? Explain what? Explain what's happening. Okay. I just didn't want to talk over him. Okay, so when George was arrested in June, twice in June of
The
2019.
No contact order in 2019 MM 5062 dated June 16th, 2019 has been pre-marked as AB. And the no contact order in 19 MM 5114 dated June 19th, 2019 is dated as AC. Mr. Owens, you can approach. Let's just tackle a couple other housekeeping matters that we have. You can move those in when our jury returns into evidence. Are there any other witnesses, evidence, or testimony, sir, that you're going to be offering this afternoon?
I don't believe so, but we're intending on resting either this afternoon or first thing in the morning, but we want some time to talk to Sarah Boone and explain to her, why we think we should rest, not call any further witnesses, not introduce any other exhibits, just to make sure that we're all on the same page with her about what our strategy is. So we need a little bit of time. I don't know if you want to go ahead and excuse the jury for the night and then have us come back in the morning and do that colloquy with the court, with the defendant. But we do need some time with her.
Okay.
Need some time.
All right. So then here's what we'll do. I'll bring in the jury and I'll excuse them. You can save those pieces of paper and you can move them into evidence tomorrow morning and then present. That'll work. Thank you, Madam Clerk. We'll bring the jury back at 9 a.m. tomorrow and you can continue with your evidence presentation at that time, including but not limited to calling any additional witnesses. Court can have any further colloquy with the defense at that time. The state then can put on its rebuttal case. The state, how long do you anticipate ballparking it for the court, your rebuttal case?
I don't believe Dr. Werner will take long on our part. I'm not sure how long it'll take on their part. And then there's about.
How long is that for your part?
I'm not going to hold you to it, Mr. J.
Probably less than 30.
How long do you anticipate your cross being? And ballpark it. Again, I won't hold you to it.
His direct is 30. My cross is probably going to be 30.
Okay, what else do you have to present?
And then there will be about 2 hours of videos from body-worn camera and from the phone extraction.
Mhm.
And then reading a good bit of phone text messages with the record.
Separate and apart from the 2-hour video presentation. Okay, got it. All right. Okay, so that's going to take us in tomorrow afternoon. Are we going to be in a position for the state to rest its rebuttal case tomorrow and proceed with closings? Or are we going to proceed with closings Friday morning after had the opportunity to have a full, not that we would not have a full charging conference, but after having a charging conference Thursday afternoon with regard to the jury instructions?
I just don't know how long. I think all the instructions are pretty relatively simple and straightforward, except for 3.6.
Agreed. 3.6F. I agree.
That's not going to be simple or straightforward in any way.
The instruction is complicated. I agree.
And the special jury instruction on that spouse that we're going to be requesting.
Okay.
There's different courts, Judge, here in Florida that have used the special instructions. There's different courts in other states that have used a different instruction. We've looked at a bunch of them, so I don't know what this court is going to be inclined to do if court would be so inclined to give a special instruction on battered spouse, whether or not you want to consider one of the local courts, the Palm Beach County case that I mentioned before with Dr. Brannon. There was a special instruction in that case. And we've got some from other states. I don't know what the state's position is going to be on that. So we may
Has a draft of that been circulated yet?
not to the court.
Okay. All right. All right. So
Or the state.
here's what we're going to do. Okay. Let's just see how long the rebuttal case takes. And then if we have to do closings Friday morning, we'll have to do closings Friday morning. I'd rather go through and spend the time to make sure that we're all on the same page with regard to the instructions, especially due to the complicated nature of 3.6F. With regard to those, the court will have Ms. Barrios email you till she just started her drive back to Kissimmee, so it might come a little bit later this evening. I will have Ms. Barrios email to you all the red line that the court has worked on so far of the jury instructions provided by the state. The defense is to provide its markup of the 3.6F and 3.6G instructions and any other defensive instructions that the defense seeks to have read to the jury.
Before 9 o'clock in the morning?
I think so. That gives the state the opportunity during the lunch hour to review them in advance of our charging conference.
I'll have it done before now.
Okay.
Judge?
Yes, sir.
There was one thing. The state had filed a motion requesting a special instruction as to, I think it goes to voluntariness. I read the motion and the proposed instruction. I have no objection to it.
Okay, all right. So just so the record's clear, we're referring to the state's request for special jury instruction regarding Florida Criminal Standard Jury Instruction 3.9B, defendant's statements filed October 22, 2024. The provision that the state seeks to add to the 3.9B instruction reads as follows. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. The state defense state, have I read that correctly?
I believe so, without reading myself.
And defense, you have no objection.
No objection, Judge. And it's my understanding that's going to, there's already the standard instruction. That's an add-on to the standard.
It's just a matter of where y'all want it. So I will add this to the red line to be sent out this afternoon. Ms. Boone, I want to have a couple other conversations with you, ma'am. Again, I don't want to know specifics of anything that you or your attorneys have discussed, just whether or not you've had those discussions. Did you hear the court read the proposed additional language to the jury instruction about your statements?
Just now?
Yes, ma'am.
Could you please read it one more time?
I can. So just to give you some background, ma'am, there's a form instruction. It's 3.9B, and it talks about how the jury is to consider your statements that were read to them and provided in evidence through the course of the trial. And that they're to consider the voluntariness of those statements and whether they were coerced. The state is seeking to add the following language to that instruction. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Do you understand that portion of the instruction?
Yes.
Do you have any questions about it?
No.
Okay. Have you had conversations with your attorneys about the proposed additional language that I just read to you?
Not yet.
Okay. Let's go ahead and have those conversations tonight when you all break, and we can go over this tomorrow when we have the charging conference. But I'll go ahead and add it to the red line for the purposes of our discussion tomorrow.
Thank you.
Okay. Anything else, state, we need to address?
Thank you, Your Honor.
Defense, anything else?
No, sir.
Okay, let's go ahead and bring our panel back in, and we'll tell them we'll commence tomorrow with additional evidence and testimony at 9 a.m.
All rise, jury's entered.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
I do.
Thank you. Y'all can be seated. Members of the jury, good late afternoon, early evening, I think. Again, could you just raise those hands, confirm that you complied with the court's instructions? All right, record reflect all hands have been raised. Members of the jury, it's 4:43. We're going to go ahead and break for the evening. I'm going to ask you to be back here at 9 a.m. tomorrow morning. We'll continue with evidence and testimony presentation by the defense, and then we'll proceed accordingly thereafter. I want to read you the same instruction that I've read you multiple times over the last week, and I beg your forgiveness as you hear it again, but I just have to keep reminding you. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. Do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, again, I thank you for your time, your sacrifice, and your attentiveness in this matter, and we'll see you tomorrow morning at 9 a.m. Y'all can be seated. Thank you. Anything else we need to discuss, state, before we go into recess for the evening? Defense, anything else?
No, sir.
All right, we'll see you all tomorrow morning at 9 a.m. Thank you very much. Court's off the record.
Okay. I have just been talking like a crazy woman. I've just been talking and talking and talking this whole time. And have any of y'all even put my emoji up that I'm muted? No. I just realized I was muted. Rebecca said, thank you so much, Carrie, mods, and chat for today. Justice for George. Thank you so much, Rebecca. Yes, justice for George. What I was saying was, for those that are still here that didn't get irritated with me and leave, what I was saying was, the state is going to come in with the phone extractions and the text messages and 2-hour video presentation. We've got about 5 different body cam footage incidents that I think they're going to pull out. They're also going to pull out a video of Sarah coaching George on how to get the charges for her dropped, which they finally did. And I'm telling you guys, Owens is going to pull something in the morning. He is definitely going to pull something in the morning. They're not going to close before lunch, I bet, or rest before lunch. You know he's got something up his sleeve. There's a reason he wanted tonight and tomorrow. I don't know what it is. I think they're still trying to get a hold of Melissa, but all right, I'm going to go because I'm so tired. I'm going to go to bed. I really appreciate you guys hanging out with me all day today. Thank you so much for being here. Oh, Janice, thank you for wonderful mods and lovely Carrie. Oh, thank you, honey. I appreciate y'all so much. Love you guys. And we'll be back at it again tomorrow morning at 8:45 a.m. Eastern Standard Time. Same bat time, same bat channel. See y'all tomorrow. Rest well.